leave, my lord, to mention item number 30, my lord, of days list. Lordship will recall, my lord, this is that matter where, my lord, my bank account has been blocked by the bank on the basis of a complaint by the local PS. GST commissioner has not no complaint. I had mentioned this matter. Lordship, my lord, included the matter in the list and directed me, if it is not take up, then kindly mention Thursday. My lord, my lord, wages, salary, I cannot pay anything. My business is stopped. Lordship, my lord, kindly takes it up today, my lord, at around 3 o'clock. I will give them notice, or tomorrow urgent motion, my lord.
Tomorrow is an urgent motion.
My lord, I'm grateful, my
It will
lord.
be listed as urgent
My
motion.
lord, I've given notice also today.
Give the notice again. You give the notice.
Yes, my lord, I shall serve notice.
My lord,
Eh,
with regard
The urgent motion থাকবে জজ সাহেব বলে দিন
Kal-
হ্যাঁ I'm grateful, my lord.
कल कर देना 30 item number 30 tomorrow urgent motion. Yes.
my lord, with regard to 129 electricity matter, well, I mentioned this matter. My lord, direction come on Monday. Monday was not the electricity. My lord, last week. Let it be tomorrow at urgent.
দিদি বলুন দিদি
এটা 129 129 item number 120
120.
कल के कर देना urgent motion कर
দিদি বলুন দিদি বলুন
May I permit to mention item number 103 matter.
हाँ
We have applied for the new connection.
তার জন্য বলতে পারছি না
हाँ
We have payment all quoted amount, but they are not provide our electricity.
why it is not provided?
Because they are saying that this is the land is belongs to
105
103.
103
We are without electricity since June 2026.
why earlier there was no earlier there was an electricity
No,
new
Earlier-
connection
new connection.
हाँ
Ma'am, kindly take it as a urgent motion.
इसको
I have sought notice upon all the.
इसको urgent motion में ना Monday इसको urgent motion
Pilot.
Milord, may I have your lordship's leave to mention, Milord? I have mentioned this matter on 6th. Your lordship was kind enough to post the matter on the 10th. Milord, the matter did not, appear. Although this is a, the new motion, the urgency is this. This is nothing but a, interpretation of a clauses of a contract. Nothing else, Milord. Whether the particular circular would be applicable or not.
so what is the urgency
The urgency, Milord, I have mentioned on that day, Milord, your lordship was kind enough.
what
The-
is the urgency interpretation will be done anytime
No. The urgency is this, Milord. Since the clauses of the contract has been interpreted wrongly, therefore, Milord, they have, not disbursing the entire amount of the additional payment of GST
additional payment of GST
in the contractual matters, Milord. In the contractual matters. Only interpretation of a clauses of a contract.
ठीक है उसको रख पहले वो Monday बोला Tuesday बोला ना Tuesday रख दो उसको
But may I have your
urgent
kind,
motion में कर
may I have your
urgent
kind leave to mention a matter with the urgency here? This is against doctor's choice, where they are using the sign of a stethoscope and the doctor in all the vegetable oils and everywhere, which is not permissible. It's a Food Safety Act regulation and the regulations violation clearly on the face of it.
so what you have prayed for
We have prayed for an injunction on everything. This is
or not to use
not to use, and there's also
It
a
is-
report of
it is before this court or
it's before this court, It's before this court
it will not
in
be
this.
the intellectual property
No, Milord, because it is a violation, Milord, of the Food Safety and Regulations Act, 2006. So we have culled out everything, Milord. Affidavits are complete. I'm only praying, Milord, if the matter may be taken up on an urgent basis, not in the list. Milord, I'm being led by Mr. Mukherjee, SN Mukherjee in the matter. The only difficulty is he's directed me to request the court, Milord, if it can be listed on any of these 3 dates, 25th of November or 24th of November or 20th of November. Milord, 25th is, Milord, if it is 25th, I'm very deeply obliged, Milord. Very, very
25th November urgent motion
My lord, may I be
I will
Very deeply obliged.
25th November urgent motion
my lord, may I be permitted to mention one matter?
who is senior yes Mr. Manda yes inclusion new motion inclusion give the list to my court officer all inclusion give the list to my court officer
My lord.
My lord, may I be permitted to mention, my lord, on
Just all new motion please hand over all your paper to my court officer we'll see to that yes
my lord, this is the new motion, my lord. I mentioned this matter on 7th. It was returnable on 7th. My lord, did not appear, my lord. What is the urgency in the matter, my lord? MSME Council, they are proceeding in a matter. They have no jurisdiction. Because that they're under section 18 and buyer and seller unit. It's a totally works contract. Supreme Court, the matter has been referred to the Supreme Court. That is pending. It's not a works contract, number one. Number two, there is an arbitration clause. In despite of that, my lord, they have proceeded with the matter, my lord. MSME Council.
Where it is proceeded?
Council. Council. So that's why my urgency is there. Otherwise, this application become infructuous.
Tuesday? Tuesday?
Yes.
Urgent motion kori din.
My lord, may I be permitted to mention one urgent motion? My lord, petitioner is the retired government service holder, my lord. My lord, his pension account has been blocked by the concerned SBI, my lord. On the issue, I am neither the borrower nor the guarantor of the loan, my lord. My lord, my entire pension account has been blocked on the reason that my wife has borrowed a loan that has not been able to pay. In such agreement, my lord, I am not the guarantor. My lord, I am a senior citizen of 69 years of age. I cannot pay even a medicine bills also.
So how your account has come into picture?
My lord, that is the reason. But they have only communicated me over the, my lord, message and WhatsApp message, my lord. Nothing.
Tuesday.
May I have your lordship's leave?
Wednesday.
Wednesday, my lord. I will
Wednesday
give
has to be urgent.
urgent motion.
Lord, may I have your lordship's leave, my lord, to mention this matter, my lord?
Respondents, my lord.
But in this matter, my lord, there's a direction to file affidavit by 6th, and matter was directed to be listed tomorrow, my lord. Lord, what has happened? They have not used any affidavit. In the meantime, my lord, for non-payment of my lord, the my lord, charges, my lord, that they are levying, my lord, in terms of my lord, rules of Motor Vehicles Act, my lord, penal action is being taken, my lord. That's the urgency, my lord, in the matter. My lord, kindly take some, my lord, any day, my lord, either tomorrow or my lord, Monday, my lord.
Monday kar do.
Lordship,
Monday urgent motion.
Lordship,
My lord, under compelling circumstances, my lord, yesterday I mentioned before your lordship and your lordship directed me to mention today. My lord, in coordinate bench already fixed the matter as my lord on 10th. My lord, urgency is that filling up the pond, my lord, multi-storied building has been drawn up without any object, without any permission, and already DM issued my lord 17(1)(a)(b) notice under Inland Fisheries Act. Ignoring that notice, my lord, construction is going on in full swing. For that reason,
Why you not approach the authority? Why you not
My
approach the DM?
DM, competent authority is the DM.
So why you not approach the DM?
My lord, DM already direction has been given. My lord, for that reason, for implementation of the DM, my lord, as an urgent basic matter.
Monday.
Lordship,
With
Lordship,
time
may I,
Urgent.
Lordship,
Great.
I have mentioned thrice before for inclusion. Now I'm mentioning for upgradation because the vehicle in this matter of the petitioner has been wrongfully detained, and it's almost a month, my lord.
इसको भी Monday रखो उसको.
my lord,
Urgent motion.
Lordship,
Urgent motion.
Lordship, may I be permitted to mention two electricity matters, Lordship, petitioners are without matter is running in the list for upgradation any day next week in the urgent motion.
Which serial number?
149 and 58 of today's
149
and 58 of today's list. Yes, 58 and 149.
Okay, Tuesday, Wednesday कर दो. Urgent motion में.
My lord, with your lordship's kind leave, my lord, may I be permitted to mention two motions, my lord, for inclusion LOC matter, my lord, a little urgent, my lord.
What is the urgency?
My lord, the petitioner intends to travel, but there is an ED proceeding. We are not even given a notice whether there is any LOC pending against us or not. If we travel, we might be.
Come in the list. Let it be in the new motion. We'll see to that.
Lordship, may I seek your kind indulgence to mention?
May I be permitted?
Can we give notice to the respondents on any?
It will be listed as a new motion. We'll see to that.
Well, may I be permitted to mention this matter? This is an unlisted matter. Examinations will be starting from the 22nd. The student of the CBSE class 10. Without the electricity and due to the resistance of the family member who have not been given the electricity.
Since when the electricity is not provided?
Since 2 days before.
Why? It has been disconnected.
It has been disconnected by the common electricity has been disconnected by the family members, and we are not getting the electricity in spite of application made to the electricity authority.
What you're not you want to file new one?
New one. Well, can you give a leave to move it on Monday?
Leave granted. Leave granted to file. List the matter as urgent motion on Monday.
Matter relating to payment of dues. Petitioner rendered their service in 2021.
What is the urgency? That will come.
2021, they are not getting.
So let's wait for the.
At the last occasion, Honorable Justice Amritsar Sinha directed to release the payment prior to the 7th November and release the matter 7th November. but it is not appeared in the list, and even they have not made payment. Without the payment, they have in tremendous financial crisis, my lord.
It is not in the list. It is not in the list.
Last occasion,
It is in the list or not? Give.
May I seek your kind indulgence to mention one matter, Lordship? This is the fourth time I'm mentioning this matter. Item number 91 of today's list. The urgency is the private respondents have surreptitiously and maliciously disconnected my electricity meter, domestic electricity meter in my own premises in collusion with the station manager, and they have obtained the electricity meter fraudulently. The urgency is I have no electricity meter in my own premises, and the matter is last adjudicated in the month of June. So, Lordship, the urgency is kindly adjudicate this matter for and fix it for the urgent hearing of this matter any day on next week. I've served the opposite parties.
Thursday urgent motion.
my lord, we have to
Thursday urgent motion.
application for restoration. Let the matter be listed.
उसको application में लेके आ जाओ. Restoration. Application for application to
Lord, may I be-
tomorrow, whatever it may come.
My lord, may I be permitted?
My lord, application number 20. But I'm not seeking for immediate list. All that I'm seeking for, my lord, the matter needs to be heard out. The marriage of the petitioner number 1 and 2, my lord, has not been registered. There is no designated marriage officer for the particular locality, my lord, where the marriage had been taken. My lord, now the issue is, my lord, may be pleased to fix any day.
What is the prayer?
The prayer, my lord, is that the register of marriages, my lord, may be directed that a designated marriage officer be appointed for that particular.
So there is no designated. Why?
My lord, it's been almost more than 2 years, my lord, that there is no designated marriage officer for that.
No marriage officer is appointed.
My lord, to fix any day, because I'm not pressing for immediate.
Next week, Thursday. 20th.
My lord, may I be-
motion में करता हूँ.
My lord, may I be permitted to mention this matter, my lord? Last Thursday, that is on 6th November, I mentioned this matter wherein your lordship was pleased to list it on Tuesday, but unfortunately, my lord, the matter has not came up in the list. My lord, the urgency is the petitioner's passport has been impounded and till date not released. As a result,
What?
petitioner's passport has been impounded
Ah.
and without any order, it has not been released, my lord, and he cannot.
That it is involved in the criminal matter.
No, my lord,
Ah.
no criminal
So how
matter.
it has been impounded?
My lord, he landed in Mumbai airport, and from there it has been impounded and sent in the custody of East Passport Officer Eastern Zone, that is on Calcutta. My lord, we made representations. We appeared in the office twice, but no order
There is
was.
no criminal cases
No
initiated.
criminal case against me, my
No
lord.
ED case.
No, nothing against me.
Ah.
Still, my passport has not been released, my lord.
What is the reason? They are not given
No
any reason.
order has been passed, my lord. No reason has been stated, my lord. On the last occasion, Honorable Justice Amrita Sinha directed to produce an affidavit, and the exceptions in the meantime, my lord, no affidavit has also been filed, my lord.
21 karo. 21.
May I have my lord's
21. Urgent motion.
May I have my lord's
I'm grateful, my lord.
matter, my lord? This is a tender matter, my lord, challenging the resolution dated 20th May 2025. The matter was heard, my lord. And
What remains in the tender matter now?
my lord, that is, I was the L1, my lord, and by the resolution dated 20th May, the entire tender TIA has withholding my appointment engagement. And my lord, that has been challenged, my lord. The direction of affidavits were there, my lord, and the my lord.
Work order is issued.
My lord,
Work order issued.
it had been issued, my lord. So, my lord, if this can.
What is the work for?
This is the my lord running of the canteen in the Asansol District Hospital.
So now.
Nobody is there, my lord. Still the matter is for consideration, my lord. If this cannot be taken up immediately, my lord.
21. Urgent.
Lordship, let me mention one urgent matter for include.
Restoration. Give the restoration or parted matter.
Application. That application has been to be.
No, you filed an application for restoration of the writ petition. Application.
To mention one urgent matter.
Tomorrow या day after tomorrow देख लो कल अगर कल एप्लीकेशन आता है कल कर लीजिए.
Last date for participating in the tender process is from the 30th of November 2025. Difficulty for me is my company has been blacklisted without any show cause and without any hearing.
When it was blacklisted?
my lord, a few six or 6, 7 months, my lord, I cannot participate, my lord. Recently,
6, 7 back, but he has been blacklisted. Have you
blacklisted.
challenged that?
Yes, I have
When you
challenged that.
challenged?
My lord,
It is pending before this.
yes, yes. Item number 203, my lord.
200.
Item number 203, my lord. It absolutely dehodes the rules and statute. It won't take much time.
Respondents appeared.
Yes, yes, yes.
They
My lord,
filed
I will serve. I will serve. I've served
They
everything.
filed affidavit.
Yes, everything is not affidavit, my lord. Report. Report has
But
been
they have
filed.
filed.
And rules, my lord, specifically say for blacklisting a company, there must be a show cause notice and there must be a hearing. My lord, nothing has been given.
You have
my
a
lord.
judgment of Supreme Court, 2023. Justice Chandrachud. You don't have the judgment.
My lord, that judgment, my lord, I would say, my lord, as per the rules, here the rules, my lord, categorically specify for blacklisting any company,
Okay.
at least a so cause notice. My lord, your lordship, it won't take much time. Any day before 30th of November.
24th ko rakho.
Lordship, beg to mention.
24th to urgent motion mein karo.
Lordship, beg to mention one matter. It relates to running of a illegal bronze metal factory.
Huh?
Illegal bronze metal factory in a residential area of the petitioner, and it is causing serious health hazard and environmental hazard for inclusions. Lordship.
Okay.
My lord,
It will be included.
my lord, this matter was supposed to appear in the list yesterday, but did not appear. My lord, the urgency is, my lord, the case diary of a criminal case that is not traceable under serious circumstances for the last 16 years, as a result of which my trial has not commenced yet. My lord,
So why before this court?
my lord, that allegation have been made against the public prosecutor, against the court inspector, because according to the report, it is untraceable from the custody of the court.
Case diary.
Case diary.
Case diary, how
That was
the
supposed to
case
be in
diary
the-
will be in the courts. Case
that
diary
was-
having 3 copies.
Yes, my lord.
One with
There has been a direction by
public
the
prosecutor or assistant, whatever it
But
may
there
be.
has been a
One before
direction by
the IO, one before the what is called the special duty, something is there.
There was a direction by the learned trial court upon the various authorities to reconstruct or retrieve it. For the last 16 years, it has not been done. But kindly,
So how this could have
my lord, there are other aspect also. Allegation
how
have been
this
made.
could have a determination?
My lord, this allegation have been made against the role of the public prosecutor also, for change of the public prosecutor also. Lord, kindly list this matter as urgent matter, my lord.
When you file the writ application?
My lord, the matter was supposed to be listed yesterday.
No, it is a new motion.
Yes, my lord.
It is not yet listed.
No, my lord.
Let it new motion में कर दो उसको. Day after tomorrow.
Lordship, one part matter, Group 9 residuary, my lord. That is the pending since 2019, my lord. For inclusion, I am praying.
Give inclusion.
I have already given.
Okay,
Obvious.
Yes.
Lord, it is the most unfortunate incident, Lordship, where it is a case of gas cylinder, LPG gas cylinder explosion, where the petitioner's wife succumbed to the injury. And the petitioner is undergoing treatment, my lord. Application has been made, all sort of application has been made to the respondent.
What you have prayed for in the writ application?
My lord, for the compensation as well as the treatment which is I am eligible to.
How the writ court can entertain on this?
My lord, they have not taken any steps so far.
How the writ court? Compensation, you go to the civil court.
My lord, this
How
is
the writ court can decide the compensation?
this is matter against, my lord, against the oil company, and also against the Union of India, lordship.
Whether during the working hours, during the employment, it was happened.
Lordship.
During the employment.
Lordship, there the fire certificate is there. Everything.
During the employment, it was done.
Lordship, yes.
It was blast during the employment in the working place or in the residential house.
Residential house, my lord.
So
it is inside the residential house, my lord.
So not in the workplace. Not during the work hours.
No, it is a domestic gas cylinder, my lord.
So what do you want? Compensation? How the court and sitting in the
Lord, it is the gas company, the oil company is not taking any step. All the application has been made. All the
have you received the report? What is what the report says?
Postmortem report says, according to the postmortem says, due to severe burn injuries.
Postmortem, it's okay. With regard to the gas leakage and fire, what is the report? Fire report is there.
Fire report is there, my lord.
What the report says?
It confirms that due to the explosion.
Explosion, whether it is due to the negligence or there is any fault in the cylinder or the pipe.
My lord, the gas, it is due to the cylinder, not in the cylinder, it is the socket. And there is a report that the socket is found faulty.
Socket has been fitted by whom?
Fitted by the gas company, Lordship.
Okay, list, give the motion. Motion. Let it come in the motion, then we'll see to that.
Your Lordship, under grave.
For new connection of the matter, my lord, the new connection of the electricity and the other occupiers of the petitioner is coming in the way. My lord, 5 times the CSC limited tried to effect electricity connection. They are
okay. Give in. Will come in.
Your Lordship, under grave. Your Lordship, under
May be
grave.
permitted to mention one matter. Item number 44 of today's list. Lordship, young badminton players, they have been suspended for 6 months without any inquiry. Lordship, registration has started for tournaments scheduled in 1st of December. Lordship.
So what do you want?
For upgradation, Lordship.
So if the it has been how the writ court, how the writ can interfere? There's no authority.
Lordship, West Bengal Badminton Association has suspended their for
So
6 months without any inquiry.
So there is
we
an
have
authority.
made numerous applications to the board, but they are not
So
responding.
there will be an authority. Who is the appellate authority to take care of all these things?
They are the association. They have only taken
Association
the
is there.
Yes.
Association is registered under whom? Under whom? Who is the party before this?
West Bengal Badminton Association.
Badminton Association. Then who is the party? Who has given the recognition to the association?
West Bengal Association.
Who control the association?
Badminton Association of India.
So, have you made that?
No.
Then, how the writ court can go into that fact?
Your Worship, on the last occasion on Friday, we had taken leave to file this matter, which
Yes,
appeared
I
on
allowed
Tuesday.
that, but
Was taken.
tell me. Okay, it's going to list करो urgent motion में list करो. Tuesday, Monday करो. Urgent motion Monday.
Your Lordship, under grave circumstances, Your Lordship, if I may be permitted to mention 2 writ petitions, Your Lordship, we had filed this with the leave of Justice Amrita Sinha before the vacation bench. It appeared before the vacation bench, however, could not be taken up. We had mentioned it before Your Lordship for inclusion on the 3rd.
What is the urgency?
Your Lordship, we run diagnostic centers. 2 of our bank accounts have now been liened and blocked and frozen since September 15th. So, Your Lordship, we are unable to make payments the entire
Why it is frozen?
Your Lordship, the bank has given no reason for such. We had a POS agreement pursuant to which
Is there any criminal case initiated?
nothing, Your Lordship, no, nothing has been done. They have just frozen the account. They had actually withhold payment for a span of 6 to 8 months, after which they released the payment and they froze the account. So, Lordship, now we run a diagnostic center. It's a cash-centric business. It is extremely difficult. And with the idea of the public service that it does, diagnostic centers, Lordship, we had mentioned it before, Your Lordship, on 3rd, expressing grave urgency. Your Lordship had appreciated the urgency and directed it to be listed on 10th. However, Your Lordship, it did not appear. I'm only praying that Your Lordship may kindly take it up on Tuesday, Your Lordship.
18th को कर दो. 18th. Urgent motion.
My lord, may I be allowed to
18th
mention on
Lordship.
electricity matter?
Obliged,
My lord,
highly
last
obliged,
bench was pleased to direct that upon completion of the exchange of affidavits, the matter to be mentioned. The exchange of affidavits are completed, my lord.
Let it be to be mentioned day after tomorrow. Day after not Tuesday or Monday, 17th.
My lord, may I be, my lord, may I be allowed to mention one another matter? My lord, it's a restoration application, my lord.
Lordship, may I be
Much
permitted to
obliged,
mention
my
in
lord.
that, Lordship?
Restoration application, take note of it.
May I be permitted to mention for inclusion of the restoration application?
May I be permitted to mention a matter, Your Lordship? I'm an NBFC. I want to surrender my certificate. I had applied before the RBI. However, RBI has rejected my application without stating a reason. I had filed writ. Pleadings are completed. It was supposed to be listed on 10th of November. It has. I'm praying for inclusion under adjournment motion, Your Lordship.
21.
Obliged.
Lordship, may I be permitted to mention this matter for inclusion in the list, Lordship?
What
It is 2022, Lordship.
What is the urgency? What is the matter about?
The inclusion in the list, Lordship. It is
Inclusion, give.
Your Lordship, may I mention on 10th November, on 10th November 2025, upon mentioning this Honorable Court directs the court officers to keep the matter on last
What is
Wednesday.
the urgency?
Huh?
What is the urgency?
Urgency, Your Lordship, passport authorities are illegally and unauthorized seize the passport of your petitioner.
25 crore.
My lord.
25th urgent motion.
My lord, for upgradation.
Upgradation.
Yes.
Why?
Petitioner without electricity.
Without electricity. 21 urgent motion. Yes, next. Call the mandate.
Not pressing this matter, the matter has been settled out of court.
क्या लिखा तो समझ नहीं आया.
Sorry, it is written in Bengali.
What is written?
It is written in Bengali.
What is the contents?
The content, my lord, the matter has been settled out of court.
You are for the petitioner.
Yes, yes, yes.
And the
Not
matter is
pressing.
listed as to be mentioned on the prayer made by the counsel for the petitioner. The petitioner has handed over the communication in Bangla language and submit that the petitioner has communicated to the learned advocate to the petitioner that the matter has been settled and the petitioner does not want to proceed with the matter further. On the basis of the communication among the petitioner, the learned counsel for the petitioner prays for withdrawal of the suit. In view of the submission made by the counsel for the petitioner, the WPA 18567 of 2022 is dismissed as withdrawn. Communication be kept in the record. Development. Dismissed as withdrawn. Yes.
But item 2, but I am for the state respondent lordship in this
My
matter.
lord, I mentioned this matter day before yesterday for taking leave of my lord because it's part of my mistake, mistake on my part, that I have mentioned the private respondent inside the writ petition, but I have not made them party. Kindly grant me leave to make them party and serve them, my lord.
What is the case for?
The case is of it is a notice inviting tender of 3 water bodies, among them 1 water body, namely
The person has got the tender work.
the private but the private respondent are restraining the petitioner for taking physical possession of the
You
yes,
want to make the party?
yes, to the private respondents, my lord.
What is the name?
But
yes,
but my lord, so far my instruction is concerned, my lord, on 27/8/2025, the issue has been settled and they have given the handover the possession of this plot, my lord.
My
I have
lord,
an instruction.
my lord, the petitioner have been given 3 years of lease period, as the private respondent have restrained the petitioner for 1 year. 1 year has been.
Possession. Have you handed over the possession?
Yes,
Yes.
I have been. But my lord, 1 year lease period has been over, and it is in my prayer. I prayed for 2 things. I prayed, one, for the physical possession to be handed over to me, and so because the private respondents are restraining me for taking that.
Once you handed over the possession, how you can taken back pray for the you back?
No, I have prayed that I have taken the physical possession. I have been given the physical possession. I went there to take physical possession of the fact of the pretender, but the private respondents, what they are doing, they are threatening me of dire consequences.
But the entire
This is
issue has
how
been
1 year has been elapsed out of 3
Let the
years.
private respondent come.
Yes,
The
yes,
counsel
ma'am.
for the
Grateful.
petitioner submit that though there is an averment and allegation against the private what is the name of the private respondent?
My lord, there are 11 private respondents.
About 11 persons, but the petitioner has not made them as a party in the present application. Accordingly, she prays due to add them as a private respondent in the present case. Until the submission made by the counsel for the petitioner is granted due to add the private. How many?
11, my lord.
Add the 11 persons as private respondent in the instant application, and to serve the notice to each of them, and to file the affidavit of service on the next day, please.
Lord, kindly record my submission, my lord. Since, my lord, on 27, my lord, they have already given possession.
And a counsel appearing for the state submit that the writ petition has become infractuous as the petitioner has already handed over the possession to the state. To whom it did?
Hand over possession to them, my lord. The state has already handed over the possession to the petitioner, my lord, and they have accepted that, my lord.
To the possession has already been handed over to the petitioner and nothing remains in the present application. Per contra, learned counsel for the petitioner found that the private respondents are assisting for taking possession, and as such, she intend to add the private respondent as party in the present application. Considering the above, वो तो ऊपर बोल दिया ना. Let the matter appear on 4th December.
4th December, my lord. Grateful, my lord.
Grateful, my lord.
Grateful.
New motion.
I am for the state, my lord, and I am for the petitioner, my lord. This is my affidavit of affidavit has not been done, my lord. I have served all the respondents. Leave me kindly to I undertake to file after affidavit, my lord.
You served?
I have served all the respondents. I have served.
Yes.
Your lordship, can you come to page?
What you have prayed for?
18, my lord. 18, page 18.
18,
Come
18.
take 10 to come to page 18. But this representation was filed by Anamika Pal, who is respondent number 9 hearing. My lord, after 5 lines, my lord, I cannot use it as ingress because Chaya Bhomik, wife of Kamal Kumar Bhomik, second, Nidhu Shau, son of Gaur Shau, both are addressed, has been obstructing my illegal construction and structure over government land, directly in front of my right land. Therefore, I cannot use it as well. Permanent structure, thereby we are facing much problem of ingress.
Yes.
Again, my lord, she is non-conscious of representation, my lord. In the month of middle of January 21, we filed a writ petition, that is WPA 1893 of 2021.
Where is the order?
When the writ petition is pending, my lord, kindly come to page 19.
Page 19.
Page 19. And it was by assistant engineer, respondent number 3, my lord. The undersigned, first paragraph, last 2 lines, are undersigned, hereby order them to clearly remove, demolish such structure, obstruction to the satisfaction of the higher officer on or before 7/8/21. My lord, no BLRO's report.
Where it is? Page 19. Page 19.
Page 19.
The undersigned hereby orders them to clearly remove and demolish the structure, obstruction is
Without serving the BLRO's report. But referred as per report of the BLRO, filed memo number 27/7/21. Report has not been submitted. Now, against this, my lord, I have submitted a representation, my lord.
So this is of 2021.
21.
Yes.
After 2 lines, your honor has been pleased to issue the above notice on the basis of report of BLR, LRO Mohisaral in connection with WPA, so and so. But so far as my knowledge is concerned, that no effective order was passed by the Honorable High Court directing you to serve the above notice, and the said matter is pending before the Honorable High Court for its final disposal. On the other hand,
where from you are reading, sir?
Well, second paragraph,
page
21. After 2 lines,
yes.
Your honor has been pleased to issue the above memo notice on the basis of report of BLR Mohisaral and in connection with WPA 1893 of 21. But so far as my knowledge goes, knowledge is concerned, that no effective order was passed by the Honorable High Court directing you to serve the above notice, and the said matter is pending before the Honorable High Court for its final disposal. On the other hand, no copy of the report of the BL and LRO Mohisaral was supplied to me to ascertain the subject matter of the report for its legality and validity. Please supply me a copy of the LMAP and the said report of BLR. My lord, then, my lord, they have not supplied. Page 22, my lord.
Yes.
I have filed an application under Right to Information Act 2005. My lord, then was page 23. My lord, assistant engineer sent this letter, my lord, and directed that in this respect, the undersigned is requesting him to furnish the following questions: Right of Information Act, xerox copies of the application under RTI Act, attached shall and requested him her to supply the necessary documents to the undersigned in the interest of public service. Then, my lord, the petition ultimately in 2023, my lord, 19th January, page 27, was taken up for hearing. This is the first time, my lord. When I hear, my lord, last first page, my lord, in view of the above, the writ at bottom, my lord, in view of the above, the writ petition is disposed of directing the third respondent to consider and dispose of the representation submitted by the petitioner dated 8 November 20 within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents in accordance with law. Then, my lord, notice was served by the assistant engineer. My lord, your lordship kindly see. Nidhu Sahu, the respondent number 8, was not called for hearing, my lord. Nidhu Sahu. Only Chabhumi, Anamikawal. Ma Sahu, she is a stranger. She has been, she was called. But Nidhu Sahu, respondent number 8 of the this, my lord, order.
Okay, you have been served notice.
Nidhu Sahu was
You have been served notice.
Yes, sir.
Yeah, then what has happened?
I appeared, my lord. Then, my lord, page 30. Last paragraph. I have not made any construction on land of the writ petition.
Okay, you have submitted representation. That why the Nidusha has not been called for. Yes.
Yes. Then, my lord, without disposing that representation, my lord, assistant engineer, my lord, send this matter. He filed an application to the SDEM Holdia.
Chandan Kumar Shakil.
That was sent in terms of 2,204 of 204 and dated 28/7 answer 2 in the light of that. Then an order was passed 5/6/23 SDM, and my lord, against which I filed an appeal. Then, my lord, next, my lord,
what is the order?
Order, my lord, last order, 21st August 24, page 43. This is 24. Two order passed. One 5/6/23, and it is 21st August 24. Against which also Commissioner has filed an appeal, my lord. Thereafter, my lord.
Yes, what has happened in the appeal?
Can come to page 82.
Where is the appellate order?
Yes, I'm coming, my lord.
82.
82, this is the appellate order. Now, before final hearing, my lord, BL and LRO serve notice to the petitioner that in pursuance of WPA number so and so, and as per letter of District Magistrate Purva Medinipur, by this memorandum so and so.
Which page you are reading, sir?
No, page 82. Notice for joint inquiry program.
So this notice was issued by the BLRO.
That no copy has been served. Report has been served up in the petitioner.
So this notice is dated. What is the date of the notice? 2025. August 25.
Dated, and inquiry was held on 2nd September 2025.
Yes.
But no copy has been served.
No, this notice was issued in August 2025. Correct. Have you received this notice?
Which notice, my lord?
82. Page 82 I referred to.
No, yes, my lord, notice I have received.
Yes, then what has happened?
I appeared. I was present at the time of inquiry. Copy has not been served.
What? What copy?
BLR's report.
Okay. So what has happened after this notice? What has happened?
Happened, my lord. Page 85, my lord.
Page 85.
At the bottom, my lord, 89/25. The case is taken up today for hearing. The appellant is present along with his learned advocate and filed Hajira. on behalf of the state respondents, the representative of the subdivisional magistrate, Haldia,
Page.
the representative of private respondent 5 and 6 also present. They attended the block land and land reforms officer Moishadal.
Which page you are referring, sir?
Page 85.
Yes.
At the bottom, the block land and land reforms officer Moishadal, Puru Medinipur, has submitted a report by memo number 1092/85 dated 8/5/25 in connection with the instant matter. On perusal of the said report, it appears as follows. Next page, as follows. But I have not been served any copy, my lord. See it beginning. Several representations were made. Then, my lord, after 1, 2, 3, 4. Next one, the learned advocate of the appellate admits that the encroachment of the petitioners over the government land, that is plot number so and so, that is the government land. The learned advocate of the appellate also submits that this encroachment is not creating any hindrance to others. Hence, considering the facts and circumstances of the encroachment made by the applicant over the government land 98/419 should be removed. Hence, I could not find any cogent reason to interfere with the impugned order of subdivisional magistrate Haldia dated 5/6/23. Well, there are 2 appeals have been filed, out of which first appeal 5/6/23 has been disposed of, and second appeal is still pending. Hence, it is ordered that the order dated 5/6/23 passed by subdivisional magistrate Haldia in MP case number 845 of oblique 2023.
Yes.
Under West Bengal.
You are admitted before the authority. And counsel for the appellant admits the encroachment of the petitions over the government land. You are admitted. You are the appellant. You are the appellant.
Yes, my lord.
Kindly come to the page 86, last paragraph, last but one paragraph. The learned advocate for the appellant admits that the encroachment of the petitioner over the government land, that is the plot number so and so so and so, and also submit that the encroachment is not creating any hindrance. So you are admitted before the
order, my lord. But I have no report, my lord, since beginning. What
once you are admitted, what the report will do?
My lord, entire things, my lord. My lord, can you see, my lord? My lord, admitted, my lord, that order has been, my lord, only, my lord. My lord, left hand side, my lord, this is my gate on the road, and just at the brink of the road, my lord. And then, my lord, blue color, that is my lord, Anamika Mal's house, my lord. It is her car. Space is sufficient space.
So Animika wants that her car should go to till her house, and you are restricted you constructed the gate in the
no.
path.
This is the way.
Correct.
This is the road.
Correct.
This is the road.
Correct. Which gate is yours? This one or that one?
This
big one.
This.
Why you constructed on that place?
At the big.
That is your recorded land. This is your recorded land.
No, my lord.
No. Okay. Yes. Who is for the state?
I am for the private respondent number 8, my lord. I say, I have a look to the order of the Honorable High Court.
Have
a look to the order of the Honorable High Court, my lord. 79/80. 79
and 80.
That is, my lord, we consent to the state respondent to stated that the referral should be considered after hearing all the parties.
Correct.
My lord, I am the respondent number 8, now 9, but no notice was given as on date to me, my lord. My lord.
By? Notice was not issued by?
My name is Nidhu Sahu. I am the respondent number
8.
The earlier it was 9. but no notice was served
Okay.
on me.
You have not filed you
Yes.
have filed an appeal. You have filed an appeal.
No.
Against the order.
No.
As there is any order against you for
No, no, I'm deeply obliged to your lordship. I'm deeply obliged to your lordship. Admitting my lord, any order, this is my only submission. Any order passed contrary to the direction of the honorable.
Is it,
court,
Lord,
that is null.
my lord, now my lord is understanding this is a connived application.
My lord.
Okay, I will take care of it.
Yes.
I will take care of your submission. Yes.
Lord, what my lord has Lord asked Lord, to my learned friend for the petitioner. But your lordship kindly see the order of the Lord, the order impugned starts from page 82. But in the appeal, Lord, entire thing has been dealt with. From page 85 relevant, but 12th August 2025, all opportunity, 18th of September, time and again.
Yes.
Then will not come to the conclusion, yes, if there is an encroachment.
Yes.
But if it is an encroachment, but my learned friend has come up with a disputed question of fact. Yes, I have not encroached, but impugned order has said it's encroachment. But how the read court, I'm asking a question to myself. How the read court will decide?
Correct.
But your lordship, this is my resolution submission. There is no infirmity or blood illegality in the order impugned.
Yes. Anything further?
My lord, my submission is to
Okay.
submission, but that
Okay.
I have not been given any opportunity to see the report, see the position actual on which what basis just pass this order.
The petitioner has filed the present writ application challenging the order passed by the district magistrate Purba Medinipur dated 18 September 2025, wherein the district magistrate Purba Medinipur has upheld the order passed by the subdivision magistrate Haldia in MP case number 8845 of 2023 under section 10 within bracket 3 of the West Bengal Highways Act 1964 and 1964. The concept for the contention of the learned counsel appearing for the petitioner is that the private respondent number 9 had initially made a complaint to the to whom the page 18 to whom the complaint was made, assistant engineer. To the assistant engineer Bharatiya Highways subdivision.
I never, my lord, have been in that.
Alleging that the petitioner has illegally occupation of the government land and illegally constructed over the government land and requested for eviction of the petitioner from the said government. Police. On the basis of the same, a notices have been issued by the assistant engineer on 28th of July 2021. The petitioner has submitted his objection to the assistant before the assistant engineer, but no order has been passed. Subsequently, the petitioner has made an application under Right to Information Act requesting for certain information, but no such information has been provided. In the meantime, the private respondent number 1 had preferred a writ application being WPA number 1893 of 2021, and this said writ petition was disposed of by the coordinate bench of this court on 19th of January 2025, directing the concerned authority to consider and dispose of the representation submitted by the private respondent number 9 on 8th of November 2020 within a period of 3 months from the date of communication of the order
upon affording reasonable opportunity of hearing to all interested persons, including the petitioner and the private respondents in accordance with. In terms of the order passed by this court, further the assistant engineer has again issued the notice, and subsequently the assistant engineer has forwarded the matter to the sub-divisional executive magistrate Haldia, Purba Medinipur. The executive engineer Purba Medinipur and the executive magistrate Purba Medinipur has passed an order on 5th of June 2023, holding that the petitioner has encroached the government land and directed to vacate the government land and the illegal construction over the government. Police being aggrieved and dissatisfied with the order of the sub-division officer, the petitioner has prepared an appeal, and the appellate authority has also dismissed the appeal prepared by the petitioner. The main contention raised by the petitioner in the present application that the authorities have relied upon the report on the basis of which the impugned order is passed. But the report has not been supplied to the petitioner, and the petitioner could not get an opportunity of hearing. Thus, he pressed for quashing of the order so that the petitioner can get an opportunity, quashing of the order and the supply of the report so that the petitioner can get an opportunity to deal with the report. Learned counsel for the respondent number 8, you are appearing for the 8, submits that this court by an order dated 19 January 2023 has directed the authority to dispose of the representation of the private respondent number 9 after giving an opportunity to all the interested persons, including the private respondent, but the private respondent herein, being the respondent number 8, has neither gotten any notice from the subdivision officer or notice from the appellate authority, and as such the authorities have not complied with the order passed by the Honorable High Court in its true spirit by giving any notice to the private respondent number 8. Then counsel appearing for the state submits that in terms of the order passed by this court, the subdivision magistrate has inquired into the matter and found that the petitioner is in illegal occupation of the government land and has illegally constructed over the government land. Accordingly, order of eviction was passed. The petitioner has challenged the said order in the appellate authority, and before the appellate authority, the appellant and the petitioner admits that the petitioner has made an encroachment over the government land, and he has also submitted before the appellate that the encroachment is not creating any hindrance to others. He submitted that taking into consideration of the admission made by the petitioner before the appellate authority has dismissed the appeal and upheld the order passed by the subdivision officer. Had the learned counsel for the respective parties peruse the materials on record, this court find that initially the private respondent has made a complaint, but that was not considered by the concerned authorities, and the private respondent has approached this court by respondent number 9. Approached this court, and this court has directed the concerned authority to dispose. In compliance of the order passed by this court, the authority concerned had issued notices and passed an order for eviction. The order passed by the subdivisional officer has been challenged before the appellate authority. Now the petitioner has raised the question that the authorities have relied upon the report, but the report has not been supplied. This court finds that the appellate authority has taken up the matter on several occasions, but on none of the occasions the petitioner has raised any objection that the report has not been served. upon the petition. In the appeal also there is no ground that the order has been passed without the supply of the report. Full stop. In the impugn order passed by the district magistrate Purva Medinipur, that is appellate authority, it is categorically recorded that, inward comma, the learned advocate for the appellants admit that the encroachment of the petitioners over the government land, that is plot number 98 by 419 of Moza Terapekya, Terapekhya, page 86, JL number 113, the learned advocate for the appellant also submits that this encroachment is not creating any hindrance to others, inward comma close. The appellate authority has considered the submission made by the land counsel for the petitioner, wherein the petitioner advocate has admitted that the petitioner has encroached the government land, but it is not creating any hindrance. Considering the above, the appellate authority has passed the order by rejecting the appeal and upheld the order. So this court find that once the this could find that the petitioner has not made any averment in the appeal or made any submission before the appellate authority with regard to supply of copy of the report. And before the appellate authority, the petitioner admitted that the petitioner has encroached the government land and the construction made will not create any hindrance to the others. Once the petitioner had admitted the encroachment over the government land and the construction, nothing remains to the appellate authority to further consider anything. Accordingly, this court finds that the order passed by the sub-divisional officer as well as the appellate authority does not require any interference. According WPA number 25039 of 2025 is dismissed. That always. Next.
Disposed of.
Dismissed.
My lord, I am for the state. I am for the state.
Appear on behalf of the
I'm
petitioner.
being led by additional solicitor general.
Item number 4.
Item number.
Which was the petitioner?
I am for the petitioner.
For my learned friend starts, Lordship, I'm being led by additional solicitor general. There has been a bereavement in his family, Lordship. Therefore, Lordship, I will be.
What is the issue?
Issue is, my lord, petitioner is praying for renewal of passport since he is having education case. My lord, criminal. Yes, having a criminal case. My lord, it is under section, my lord, 69, 355, 351, 277, 35. That is, my lord, false promise to marry. My lord, what has happened, my lord? I am for my postdoctoral research, my lord. I need to go to United States and permission has been granted by the concerned university. What exactly I want is, as per the rules of the passport authority, I must get the permission to depart from India from the competent court, specifying the time. What I pray, my lord, I will file an app.
Have you applied before the London magistrate?
No, I want a liberty, my lord. I will apply, and that may be this.
Liberty always there.
My lord, the difficulty is, even if I apply, then again criminal court. Two authorities, my lord, needs to be directed.
One, you want to apply the passport so that you can go to the abroad. Correct?
Abroad, yes.
Now, criminal case is pending. So, first authority is the London magistrate or the judge before whom the matter.
Why I am before the 26 court is, my lord, kindly visualize. Well, it is extreme urgent. I have to leave India on 30th of November. This is the first part. Once the concerned court considers this, the passport authority should also consider within a time-bound manner. These are the orders, my lord, identical.
Take the order from the magistrate. If they will not consider, then come.
Kindly pass a time-bound order. That's my prayer.
Unless and until.
Well, I will go once your lordship.
We don't know whether the magistrate will allow or not.
No, that the magistrate will decide independently. That's the magistrate will. Just, my lord, I am praying before your lordship. Kindly grant me liberty to approach. If I apply before the magistrate will not magistrate, my lord, ADJ call.
One issue is that while considering so, or while passing such order by the learned court below, Lordship, the order has to be in accordance with the GSR 570E, Lordship. which
What it says?
My lord, it is annexed, my lord.
Page number?
Lordship,
My lord, rules
and-
at page number, my lord,
Give-
37, page 37.
37?
37.
This is the notification of 570E, Lordship. If your Lordship can kindly takes up this notification. Lordship.
May I just read it out, my lord?
Yes.
Specifically stipulates that a permission has to be accorded to depart from India, and also while such permission is being granted, there has to be a time specified. Specific time period has to be mentioned.
Where is?
Lordship,
My lord,
uh,
my lord, may kindly come to page 37. It is the same. He is showing the Gazette notification. I am showing the office memorandum.
No, he is
But-
showing this 1993.
Yes. Same thing. In the office memorandum, my lord, it is copied.
Okay, 1993. Okay.
My lord, kindly come to page 37.
Yes.
The lordship has seen A. The passport to be issued to every such citizen shall be issued for the period specified in the order of the court. Referred to above if the court specifies a period for which the passport has to be issued. This is one thing. Well, second is if no period either for issue of the passport or for travel abroad is specified, the passport shall be issued for a period of 1 year. Here, my lord, I want the passport up to 2030. That is the reason, my lord. If 1 year, there is no problem. Then, my lord, if such order gives permission to travel abroad for a period less than 1 year, but does not specify the period validity of the passport shall be issued for 1 year. And my lord, if such order gives permission to travel abroad for a period exceeding 1 year and does not specify the validity of the passport, then the passport shall be issued for the period of travel abroad specified in the order. So, my lord, I have to approach the competent criminal court. The criminal court will specify the order. Now, my lord, at times, my lord, your lordship knows, my lord, in lower court, my lord, it is difficult. Why we have approached, my lord, kindly see the identical orders passed by the high courts, my lord, in this regard. My lord, kindly come to page 46. Because why I am before the writ court, two authorities needs to be directed. In view of the above observation, the writ petition being number 1499/22 is disposed of by granting liberty to the petitioner to approach the competent criminal court where the criminal proceeding is pending against the petitioner at present, either to seek a clarification, modification of his previous no objection by extending the period for which passport is to be issued to the petitioner, or to obtain a fresh order from the said criminal court for issuance of the passport to the petitioner, covering the period during which the petitioner shall pursue his studies abroad. And then, my lord, if such application is made, the criminal court shall decide the same as expeditiously as possible within a period of 10 days from the date of making of the application. Upon the order being passed by the criminal court, the petitioner shall be at liberty to approach the passport authority with a copy of the order, and upon such approach being made by the petitioner and the application being made by the petitioner for modification of the said passport, the respondent number 1, that is the regional passport officer, shall process the application at the earliest and modify the petitioner's passport accordingly in accordance with law. Just that second part also, my lord, I just want a time-bound manner, this part. Learned additional solicitor general.
Lord, actually, I was not aware that it has been, that leave has been granted, no notice has been sought.
Okay, you can.
That apart, my learned engineer submitted, I'll have to immediately
Yes.
take the court.
Well, I don't.
Bereavement. My
Yes, you can.
brother-in-law has.
I am not. Only I ask what is the
But
matter.
I am making no
No,
objection.
if his urgency is on 30th.
No. I don't. 30th urgency. It can be taken up tomorrow. It can be taken up tomorrow. Yes. I have told already. I mean, okay, bole.
No, that's only I ask what is the matter about.
Without presence of ASG, এটা হবে না.
He has already paid for the time. He has
The
already
honorable
paid
court
for
is
the
hearing
time on
what
a
is.
personal ground. No.
আমি সেটা কোনো objection করিনি, sir.
When
I also have no objection.
Tomorrow.
He is having some personal difficulties.
As per the prayer made by the learned ASG, case adjourned, let the matter appear tomorrow under the same heading.
30 তারিখে রিলিজ করবে।
হ্যাঁ 30 তারিখ।
ঠিক আছে।
কোনো objection করিনি স্যার আপনার। আমি সেটা just শুনতে চাইছি।
ঠিক আছে।
Yes, next. In this matter, my lord, I am for the private respondent applicant.
I am for the
Now, my lord,
GST matter.
the crux of the dispute is that they have obtained, my lord, the order granting electric connection
showing my address. I am a resident of Behala Pornosri, showing my address at near about Sundarban. So, my lord, we took out an application under section 340. My lord Justice Kaushik Chandra in the last order was pleased to my lord reject that application after granting us leave, my lord, to pray for recalling. Now, my lord, in this application we have prayed for recalling of the order granting electricity. Now, my learned friend has pointed out that this copy of the CAN application is not in his file. But so far I recollect, I have served him. My lord, kindly take it up on any other day. Today I will serve them copy. No problem, my lord. I will serve them copy.
It's also not served to the CSC.
CSC.
Immediate after getting the knowledge regarding the wrong address, my lord, I have make out an application CAN 1 within a week. And there Justice also passed an order, my lord, that there is no malified intention. And 340 is being rejected. And let them serve the CAN 1, my lord, and kindly hard together, my lord, or the
No, they have already obtained the order granting electricity.
So you have filed an application
Done for recalling that order.
Which application? CAN number?
CAN number 3.
CAN 3 is not served to us.
No, Lord, as per my instruction, we will have served, but we will serve again.
CAN number 3.
CAN number 3, we will serve again upon Mr.
You also filed, no?
I have filed in CAN 1, my lord.
Where?
That is disposed of.
That is disposed.
No, CAN 1 is not disposed. That is also pending, my lord.
No.
The CAN 2 is disposed of. That is section 340.
340. CAN 1 and CAN 2 is.
CAN 2 is disposed of.
CAN 1 is pending, my lord.
What is the CAN 1?
CAN 1 is.
CAN 1 का है? CAN 1 का record. CAN 1 का record नहीं है. CAN 3 है. CAN 1 का है.
আমি বলি কি যে এটা আপনাকে দিয়েছি আর এইটা সিএসসি আমি বলি কি আপনার ফোন নাম্বারটা ফোন নাম্বারটা একটু লিখে দিন আর ওনার নামটা তো আছেই ঠিক আছে আমি দিয়ে দেবো একটা জেরক্স করে দিয়ে দেবো ক্যাটে যাবো এখন চলে
Yes, so
let my lord serve the copy, my lord, and take it second both the petition, my lord.
Well, we have served, but again we will serve, no problem.
When you will serve?
Today or day after, any date, my lord can take it up, we will serve. Both of them are very well-known figures in the bar. My lord, we will not face any difficulty to find out them, my lord.
You are the private respondent.
Private respondent, my lord.
Private respondent has filed an application being CAN 3 of 2025, praying for recalling of the order dated 4th of March 2025. Learned counsel for the rate petition submits that he has not received the copy of CAN application. CAN number 3 of 2025. Directed to serve the copy of CAN number 3 of 2025 along with the document to the learned counsel for the petitioner. Rate petitioner by 14th of November 2025. This is the matter under the same heading on 18th November.
18th. I'm great.
Grateful.
আপনার
মোবাইল নাম্বার
লিখো তাড়াতাড়ি এফসিআই রেসপন্ডেন্ট কত এটা আছে রেজিস্ট্রেশনটা
Yes.
Your Lordship, beg to appear on the petitioner, Your Lordship.
I'm appearing for the Respondent Union of India.
We're appearing for the FCA matter.
3.
And
For the petitioner?
Yes, sir, for the petitioner.
Who has filed the CAN 2?
I am filed, Your Lordship. It's a restoration application.
Restoration application. Have you served?
Yes, it has been served.
What is the stage of the writ?
Yes, it's Your Lordship. The facts of the writ is that basically the petitioner is a transport contractor, Your Lordship. The job of the petitioner is to get the goods from the railway siding and deposit to the FCI go down, Your Lordship. That's the purpose. I have annexed all the documents. Now, what happened, Your Lordship? It's a weight bridge to weight bridge delivery, Your Lordship. Suppose the wagon is placed on the railway rack, Your Lordship. We go over there. Our job is to get the food grains from there. It is weighted over there. Then we put it in the go down, and that is also weighted over there. Now, the dispute is, Your Lordship. Initially, we have raised the bill.
we found that the Food Corporation of India has deducted some amount. They have never disclosed why that amount was deducted. We made a representation before the Food Corporation of India that these are the bills we have submitted. After the statutory deduction also, we find that certain amount has been deducted. So we made a representation. In reply to that, they said that no, it's a railway transit loss. You have incurred the railway transit loss. That's why your amount has been deducted. So your Lordship, kindly see the representation first, your Lordship. It is at page 104. And for your Lordship, first I will ask your Lordship to come to page 24. That is the basic tender document, your Lordship, which gives the scope of the work, what we are supposed to do.
Yes.
Your Lordship is there. It says notice inviting tender. Food Corp.
So you will not use any affidavits.
Malad, I am appearing for the FCI. I shall use
FCI
affidavit. Malad, I shall use affidavit. Malad, there is no question. Malad, there was the contractor was engaged as per the terms of the contract. Malad, he has not fulfilled the contract. The goods were came in the railway siding. The goods were weighed and entrusted to them. They didn't take any steps. Goods were lying idle in the railway siding for 1.5 days. Thereafter, they took the goods, and in a way there is a huge transit loss. Here in the contract, there is a provision in clause 27 that if there is any transit, he has to perform his obligations about the delivery of the goods with full condition and protection. If there is any loss, he will have to reimburse, and the general manager of FCI will have the authority to consider the question. If it is found that the loss is for his fault, the 2 times of the loss has to be reimbursed. Now, my lord, in another page, my lord, he has page 79. He has said that, well, I shall abide by the all terms and conditions. Now, my lord, another page is page 48, where a grievance redressal cell is there. He has not raised his dispute to the grievance redressal cell. Therefore, my lord, after completing, my lord, GM has
How soon you will file affidavit?
My lord, you'll see
Petition.
main petition. But I shall file an affidavit within 3 weeks. Well, another question is there, my lord. In this matter, the district office, the divisional office Murshidabad, and the West Bengal regional office is the concerned party. Now, my lord, as per DUP, my lord, Union of India is nothing to do in this contract. My lord, the respondent number 1, 2, 4, and 6, my lord, they have been pleaded. I have made an application, can number 1, that let them be their name be strike out. You should kindly see the prayer.
I am opposing that, your Lordship, because
that he. Your Lordship, my question is this:
Your Lordship will consider the matter and put it
if there is
So you file affidavit disclosing that they are not the concerned.
I have disclosed it, but let them file an application, opposition before in my application. Let it be heard along with that.
Which application?
Can number 1.
Can number 1 is yours.
Mine. Can number 1 is mine for deletion of the names.
Your Lordship, the managing director.
1, 2, 3, and Punana. Jokon writ petition has been dismissed, then we can obviously dispose of. But if the order is recalled.
As the matter
if the order is recalled, every order applications.
As the matter was dismissed for default, that's why the can has been disposed of, your Lordship.
Correct. So I will recall that order.
Then
but the can. So what about the can?
Your Lordship, the Food Corporation of India, they want to delete the name of the managing director of Food Corporation of India. I'm putting this question to myself. It is before your Lordship. They will file their opposition. They'll put it before the Lordship. And FCI is not the managing director. I don't know why they have an objection. If
No,
the
yes,
managing
but
director is a party.
But there is a
Because
question.
the issue is, your Lordship, the top boss.
Whom you want to be deleted?
Well, 1, 2, 3, and 3, 4, and 6.
1, 2.
1, 2, 3, 4, and 6.
3 is the Union of India.
3 is the Union of India. Nothing to do in this matter, my lord.
Who has issued the tender?
But the regional manager, general manager region. General manager region is my lord, respondent number. You also kindly come. General manager region is respondent number 5. Respondent number 5. And my lord, the operating section is respondent number.
Where is that?
In the cost title.
Page number 2, your Lordship.
Tender notice. Who has issued the tender?
Page 24 is the tender notice.
Yes. Who has signed this? Who has issued this?
Page 24, you also kindly see.
General manager R.
General manager region, respondent number 5.
General manager region.
And operating division is respondent number 8. Well, of the district divisional office Murshidabad.
8 is the general manager depot.
And 7 division manager Murshidabad, and 8 is depot. 7, 8, and 5 are the actual party, but they are responsible as per the DOP of the government. Unnecessarily, they have implemented all the persons.
And Executive Director, Food Corporation.
Your Lordship,
chairman,
the fact remains
first is
the Food Corporation of India.
first is managing
The
director.
chairman doesn't want the chairman to know the facts what is going in the state. That's the problem because
Question
they
is
are
there
the-
is
Whatever it may be, they are the authorities, they are the railways authorities.
They are the Food
So,
Corporation
okay,
authorities.
you are filing the affidavit either by the 5 or by the 8. Let the affidavit file.
Well, I shall, my submission is this. I shall file affidavits for the FCI. Well, for 5 and 6 and 7. Only question is the actionable. But question is the let the you kindly allow me to speak. Sir, my application is there, but as per instruction of the government, I have filed the application. Let them file an opposition to that application also.
Yes, we'll do that, Your Lordship.
That's I am playing only.
We will adopt, my lord, the
Even a car had appear করছে।
কারো appear করবে।
respondent 3, my lord. Union of
But Union of India always written to us that don't deplete our name in any writ petition. They are sending an instructions.
Petition has filed the present application being can number 2 of 2025. Praying for the recalling of the order dated 1st of July 2025.
अरे हमरा डिपार्टमेंट থেকে মনে হচ্ছে কি পাগল করে দিচ্ছে।
Dismiss the application for default. Consequently, can number 1 of 2024 was disposed of filed by the Council for the petition is that
ঠিক আছে তাই কর তাই কর।
when the matter is called, petitioner
তার থেকে অর্ডার দিন। অর্ডার থেকে হ্যাঁ যাই হোক অর্ডার করে দিন।
case is
না না কোনো অর্ডার
the writ application continued. At the learned counsel for the parties, this court find that the petition was dismissed on 1st of July 2025 and immediately
কটা বাজে 15:12
28th of July
এটা এত না ষোলো ধরেছিল এপ্রিল আমি ছিলাম ছুটি এখানে এলাম এখানে নেই আমার ওখানে যাচ্ছি।
this court find that the petition has assigned sufficient cause for non-appearance of the petitioner before this court. Accordingly, order dated 1st of July 2025 is recalled. WPA number 199299
আমাদের এ তো আমরা সবাইকে পার্টি করি এখন গভর্নমেন্টের সব মানে
original
আমাকে ছেড়ে
with consequently can number 1 of 2024 is also arrested.
করতেন খেয়েছে তো তারপর থেকে আমাদের যেন না থাকে
The respondent pressed for time to file an affidavit in opposition to the writ application. Counsel for the petition pressed for time to file the affidavit in opposition to can number 1 of 2025. Let affidavit in opposition be filed within 3 weeks.
Well, kindly giving me 4 weeks, well, 4 weeks. 4 weeks.
Within 4 weeks, reply if any there to be filed within a week, within 2 weeks. 2 weeks. This is the matter on
Well, only one joint
Then
there,
it will
but
go
it may appear for orders.
then it
Otherwise,
will go to the January.
January
6
as
weeks.
orders, well, we have jointly we are paying.
Yes, Your Lordship. Let
No, under the heading, my lord,
Appear in
for orders, my lord.
combined monthly
Let
list
the
of
matter
January
remain under the heading
2026.
for orders.
Your Lordship, only let it be under the 4 orders heading.
Combined monthly list of January 26, then you mention if the pleading is completed.
As your lord, this
Whether, my lord, respondent number 3 is, my lord, there, my lord. Union
monthly
of
list,
You the name.
monthly list of January,
Because of 6 weeks.
as your lord,
Because 24th onward, then vacation.
as your lord.
Yes. Which was the petitioner?
I'm appearing for the petitioners, my lord.
I am for the person that was not been made party, though at my instance, all orders were passed.
Lordship, I'm appearing for the petitioner, your Lordship. Petitioners, for the
Made
petitioners.
by Mr. Balram, sir.
Order impugned.
You have not made the party who have made a complaint before the concerned authority.
Lordship, the proceeding was at the instance of state respondent number 4, Assistant Engineer County Subdivision.
But
If
who has
required,
made-
we'll
has-
implement.
Who has made the complaint to the assistant engineer?
Initially, it was made by one private respondent, but so far as 10-3 proceeding is concerned, 10-1, 10-2, all these were at the instance of private respondent, state respondent number 4, Assistant Engineer, Kontai Highway Subdivision, Your Lordship.
So you made the party, sir, the copy, then I will hear the matter. Made the party to.
Lordship, Lordship.
What is the name?
Mamun, mane impugn order refers to my name, my lord.
Mamuni
First line of the impugn order, second line.
Mamuni Ponda, Mamuni Ponda. I'll do
Mamuni
it, Your
Ponda.
Lordship.
Kartik Chandra.
Second line of the impugn order. Page 32. Mamuni Ponda.
Mrs. Mamoni Ponda, Your Lordship. Mrs. Mamoni Ponda.
Record an order. The petitioner has filed the present writ application challenging the impugn order.
As by the appellate authority.
Passed by the 10-3 authority as well as appellate authority, 10-4 authority.
Passed by
the district magistrate, Your Lordship.
Passed by the appellate authority dated
7/8/2025, Your Lordship.
August 2025. Mr. So-and-so appearing submits that the case was initiated on the basis of the complaint made by Srimati Mamuni Panda, but the petitioner has not made the complainant in the present case as party respondent. This court considered the impugn order, wherein it is find that Mamuni Panda is the complainant in the before the concerned authority, on the basis of which the case has been initiated. Accordingly, Srimati Mamuni Panda is the necessary party in the present case for adjudication of the present writ application. The petition is directed to add Srimati Mamuni Panda as respondent number
6, Your Lordship.
Respondent number
Should be respondent number 6.
Respondent number 6. By
Lordship, kindly allow me 1 week time, Your Lordship.
Within a week from date. After adding the private respondent as after adding the Mamuni Panda as respondent in the present case, the copy of the writ petition along with the document be served upon the added respondent within a week thereafter, and to file affidavit of service on the next date fix. List the matter.
Lordship, certain documents couldn't be annexed with the writ petition. I'm beseeching Your Lordship to allow me to file a short supplementary affidavit.
Counsel for the petition submit that the petitioner has not disclosed certain document and paid for leave to file supplementary affidavit. Let the first supplementary affidavit be filed within a week after serving the copy to the respondent. List the matter on 28th of November. 28th November.
Lordship, in the meantime, no coercive steps.
No.
Let be added first.
Lordship.
I'm item number 8. I am for the state Lordship directed to
take instruction on EWS.
Lordship.
But I'm appearing for respondent number 5 in item number 8, my lord, School Service Commission.
Yes.
No.
Have you taken instruction?
Lordship.
What?
As per notification, Lordship, 18 May 2023, petitioner is not entitled. This is the notification, Lordship.
That was placed with the single judge.
There, in the notification that has been sent through mail, Lordship, that is that there is some underline, Lordship, in the notification. Extremely sorry, Lordship. Number 1, nomenclature. যোগাযোগ তো করবে বাবা
Why the OBC cannot be EWS? What is the criteria of the EWS?
That particular year, it is based on the economic condition of that particular year. In fact, this circular was placed before Justice Sinha. Last week I have handed over all the orders, and I have made submission that I'll not take advantage of OBC. In fact, in that matter also, that was my submission, that I want to forego all my rights under OBC and I want to avail EWS flat. And considering that, court directed them to change the portal so that I can apply for EWS. That order was that was placed before the justification, and that's why Lordship directed them to take instruction.
Lordship, in that the order there is no order. Only there was the instruction that the portal has been updated.
Yes, yes.
Nothing else.
Because
if he is eligible to apply through portal, he is eligible. If the portal does not permit him, he will not eligible to get that certificate.
Following first order, that is June 26, or first order was passed, or court has recorded.
Last order.
Court has recorded my submission, and court is of the opinion that the authority cannot force a candidate to accept the benefit of caste reservation. The petitioner has himself disclosed that he belongs to general caste and that he does not want the benefit of reservation. He only intends to have the EWS certificate. That was the context. You got it?
Yes, yes.
Paragraph 3 of first order. That was the context. Court has directed them to change the portal.
Yes.
Here also, my referral kindly takes up page 19 of my writ petition. I have applied as general category candidate.
19.
Page 19.
Correct. EWS.
General, I have sought for benefit of EWS in the middle. Can you see?
Where is the general? Date of birth applied.
EWS. I didn't take any. I didn't mention that I'm OBC.
Correct.
And in the middle category, I have stated EWS.
Yes, EWS.
Yes. That's
at that relevant time, he has no certificate of EWS, but he has claimed for the category of EWS.
And I kindly see that EWS certificates issues every year. Page 16. Page 16, is the first EWS certificate I had obtained in 2021.
2020.
First page 16, 16.
Yes, 2020.
And this is valid for 1 year, mentioned in the certificate.
Yes.
For next year, page 17, I have again applied for so that I can take advantage of this benefit in the selection process. I have applied for these certificates are yet to be issued. That's my context. I have I'm before your Lordship.
When you applied for?
Applied on 4th July 2025. Yes.
So that certificate expired in 2021.
Yes, for one year.
2021.
Whenever we apply for any selection process, only then we can have this benefit.
Yes.
That's why we have applied for this.
Lordship, the petitioner has possessing the caste certificate still now.
What certificate?
Caste certificate.
Caste certificate, yes.
And as per the notification, if he possesses that caste certificate, he is not entitled.
I'm not taking benefit for.
No, that is not the issue. Issue is if you possess that certificate, you are not entitled.
That cannot be that.
That notification has not been challenged, Lordship. Number 1, nomenclature. As per notification, economically weaker section EWS is not the term describes the person who are not covered under scheme of reservation of scheduled caste and scheduled tribe. Still, he is possessing that certificate.
Nobody should take advantage of both.
No, advantage and that is not covered. He is possessing that certificate. He cannot say that I will not.
You tell me, caste certificate, EWS, what is the EW is not a category, EW is a weaker sections.
Notes.
Economy weaker section. It
Yes.
might be OBC, might be the scheduled caste, or might be the scheduled tribe. If he is a weaker section, then that is a different thing.
But my lord, I agree to that extent that you cannot take advantage of OBC and EWS
That's
together.
correct. That's correct. Oh, yeah. If you are taking the OBC, if you are taking no, you cannot trust in the. If suppose
Yes.
the petitioner is OBC, but he is having the lesser income in terms of the EWS notification, whether he will not, so he cannot ask for the, he cannot pray for the both category.
Yes, yes. That's
He
my
cannot pray for the both category, but he can go for the EWS. But if he is having, he proved he has, he is proved that he is a weaker section.
Lots of that is not the notification.
And
Lots of
good that-
notification,
After going through the notification,
and that has not been challenged here, Lordship.
that has in fact not the
No,
foreign.
unless that notification has been challenged, he cannot avail that.
because
Justice Sinha's order is in fact not the same.
No.
that's correct. But kindly see the note because justice
And yes,
has
ma'am.
not
Notification I have seen. Notification I have seen, ma'am.
You have challenged, not challenged.
But only thing is that after the order, in terms of this notification, the person who had the certificate of OBC or who does not have the certificate but falls within the category, they cannot apply for. Portal does not have that option. Ma'am. Now, this order of Sinha had changed the website.
Change the website, it's okay. But the problem is now before this court, because before the Justice Sinha, this is not the question with regard to the notification.
But in fact, but they have placed the entire report matter.
Notification.
Yes, but notification was also placed.
Notification is.
But I was there, man. All the affidavits discloses those notifications.
EWS
2, 3, yes, 2, 3 In fact, that was a submission on the very first day.
Instruction.
Yes, yes.
But if the notification you challenge this, then you could see that.
But the time is very limited. But I have applied for SSC. But that process of verification is going on.
When is the last date?
Last date has expired. Now, last occasion, the council for SSC was appearing.
It will not challenge them. If you challenge, then the court.
Lordship, he cannot avail that.
But
At that relevant time, he has to possess that certificate. Now, after application, he is trying to collect that certificate. It cannot be, Lordship. Before application, he has to collect that certificate. And at that time, he can mention that I am EWS. Now,
yes, mention in the EWS, but certificate.
but without any certificate, how he claim?
No, he is not provided the certificate.
Certificate I cannot get at the relevant point.
Lordship, one candidate can apply for that category if he possesses that certificate at that relevant time. Now he is showing that this is the urgency that will be completed. That is that cannot be prayed for.
Requirement is at the time of verification I have to produce the certificate. But it says
No,
it is valid for what?
No.
But when the list has been prepared, categorized with the list.
Lordship.
The EWS.
Yes,
Yes.
Lord.
At the relevant year, I have to show that I am EWS.
You have.
Once you submitted the form, if you are unmarried, the list will be prepared as per the category.
Yes.
Lordship.
So that I have
So
to produce the
he
certificate
has to
verification.
often prior to file the application.
May I do one thing? May I bring as file a supplementary affidavit and bring on record that kindly keep it on the
better.
Yes, ma'am. Tuesday. So that
Malad, I have to, Malad, I would like to make some submissions for the commission, Malad.
Yes.
এখনো commission আসেনি।
Malad kindly comes to page 131 of the petition.
131.
I have only
page.
Oh,
which page you are
my
referring,
learner
madam?
junior will have. Kindly give the page number, please.
We have not annexed the advertisement. This is the compilation containing the advertisement for this election.
Kindly show the page 131.
Yes.
এই আমি সাপ্লিমেন্টারি ফাইল করি তারপর বলো
Yes.
Malad, in our advertisement, there is a clause for consideration of belonging to reserved categories. The certificates issued by the competent authorities of only the government of West Bengal on or before the last date of receiving online applications shall be treated as valid documents.
Oh.
Qualification obtained only. Yeah, this is the cutoff date.
Malad, that is so. On the last date, if he possesses the certificate, he will be categorized as EWS or else not.
Correct. Yes, बोलो ना.
And the last date was 21/7/2025.
July. Yes. Okay. Yes.
But there are subsequent notification. I'll bring on record that all those by your supplement. I'll keep it on a witness similar.
Counsel for the petitioner prays for time to. The counsel for the state respondent has brought on record, has handed over the memorandum dated 18th May 2023 and submits that as per the nomenclature, the petitioner has already obtained scheduled caste within bracket B certificate, and as such the petitioner cannot be applied for EWS category. Full stop. Learned counsel for the respondent number 5. You are appearing for 5. Respondent number 5.
Respondent number 5, my lord.
5. Submit that as per the advertisement, it is categorically mentioned that consideration of the belongings to reserved categories, the certificate issued by the competent authorities of only the government of West Bengal or on or before the last date of receiving the online application shall be treated as valid. This submitted in the present case, the last date of submitting an application for 27 July. What was the last?
21st July, 21st July, my lord. 21st July.
And on that day, the petitioner had no certificate of EWS. Full stop. As the petition counsel for the petitioner prays for time to file to bring some document on record by way of supplementary affidavit, time is granted. Let supplementary affidavit file by.
Malad, can you keep it on a witness day, but before that I shall file it.
So be filed today, 14 by Monday after serving the copy to the by Tuesday by serving the copy to the learned counsel for the respondents. List the matter on 19.
Well, in the meantime, whatever bunch they have, Malad, hand over to Lordship, may I have a copy of
it? That is with
all the
notifications.
Those are the advertisements, the notifications.
Later. Yes, next.
Grateful lords.
Lord, your lordship may recall, my lord, that matter where, my lord, the
respondents
allotment has been granted to a serviceman for running of a stationery shop, my lord.
Yes.
Lordship, my learned friend is using the sympathy. I feel the pulse of lordship. Only 2 and 3 months are there.
That's what I'm telling.
That's lordship. I have already talked to my officers.
That's telling you as per your agreement, the 3 months, January 24 or 26 is there.
January 10th, my lord.
No, 10th. No. 10th January is the last day. But after the 10th, he will not be claim anything.
Well, that is that.
So, lordship, then
because
then I will start on my letter.
Policy, my lord.
No, you are challenging the central government policy.
Why not?
Lordship, then you come. Lordship, come to page number 24.
Subsequently, my lord.
No, let me finish. Page number. Let us see.
Let the matter be decided on my.
Let us see. Page number 24. This policy has come for the 100% reservation for the war widows. Widows of defense personnel killed while on duty, disabled. He is using that since 2012.
Which clause you are?
Lordship, letter, page number 24.
Yes.
Especially this is the welfare.
Which clause? Which clause?
A. 2A.
24.
Para 8, a reservation of the shops allotment, 100% reservation for the war widows, widows of the defense, personnel killed while on the duty, disabled, soldiers for the ex-servicemen, and spouses, widows of ex-servicemen, etc. shall be followed for the allotment of the regimental shops.
You are referring from whom?
Affidavit.
Where? Petition?
No.
Or affidavit?
Affidavit opposition.
In our sorry, I am.
Annexure C.
So I'm not coming in this way that let them to enjoy till the license period. But after that, they will have to vacate and hand over. And after if they fail, again they will come with a new writ. If their policy is wrong, I have to allow it. There's a renewal clause is there. I have to continue. How many years they will enjoy? Other widows are there. Either ex-servicemen are there who had died. His sons are there.
This is a sentimental welfare society for our defense, not for the permanent owners.
Yes, page number 24.
Lordship, page number 24, let us
I will
see.
give answer what my learned friend is
Yeah, definitely.
Definitely, I
Yes,
am
page number
entitled to give an
24.
answer.
24.
Yes.
Your Lordship, 2A.
Yes.
100% reservation for war widows, widows of defense, or personnel killed while in duty, disabled soldiers or ex-servicemen, and spouse, widows, or ex-servicemen. He is the ex-serviceman. He is enjoying last 13 years, 2012, 5 years. Again, 17 to 22. Again, 1 year here, like if you have given, how much they want to their whole life. This is not the personal property. This is the only welfare to the ex-servicemen. Other widows are there. Other servicemen are there. They are also waiting to get some benefit from the force.
Yes, then?
Then I'm only saying, let them to enjoy till after that they will not come for any new clause. They will hand over if they default. If they default, what the Lordship will decide, he will have to face.
Yes. My lord, I give a response what has been content. Firstly, my lord, your lordship has seen the list. The license period, my lord, that comments from 10 February 11 February 2025 and is going to expire on 10
Initially the allotment was
initially for 5 years.
2012.
12 to 17. Now the policy has been introduced.
Let come. Where is your initial appointment?
Yes, my lord.
Initial
The
allotment
P1,
order.
my lord, annexure P1 is my initial appointment allotment.
Page P1. Page.
Yes, my lord. Page is, my lord. Yes. That is, my lord. Page 19.
19.
Where is the 5
got it? Allotment of shop number 6.
Yes.
Common. So, my lord, first, my lord, the allotment letter was issued in the year 2012.
Correct. Where is the 5 years? Where is the time mentioned here?
Although, my lord, the time period is not mentioned, but it is understood that it is for a period of 5 years.
Correct.
Thereafter, time to now, according to my learned friend, the policy has been introduced in the year 2018.
Yes.
It is admitted position.
Yes.
Thereafter, in the policy agreement, if my learned friend of the espouse,
since 2012, you are continuing with the
I am continuing. And the authority also has not objected. Time to time, they have renewed it.
Correct.
But
It
after
was renewed.
compliance of all the formalities.
Correct. It was
Now,
renewed.
the question is,
Yes. Lastly, on 11th of February 2025, this was
yeah, yes,
Correct.
only, what is, kindly, pause there for a moment, Here, what has happened, the authorities were aware of that policy because they have introduced it, 2018.
Yes.
Although, my contention is it cannot be operated retrospectively since, the allotment letter that has been, issued way back in the year 2012. So, unless, the policy, there is a specific declaration that it will come into effect retrospectively, it cannot be given retrospective effect. That is my contention.
This is a reason to
Let me. So, this point, for the first time, they have canvassed in their affidavit in opposition. Initially, while entering into the successive lease agreement, nowhere, they have mentioned that this lease will subject to the policy, Kindly, keep in mind that nowhere they have stated. Because when the policy has been introduced 2000, thereafter, several leases has been licensed.
Why you filed the writ petition?
But I filed a writ petition
on the vacation notice.
Yes, 17 May. Because during the subsistence of the license agreement, I have been asked to, but a authority, they cannot act arbitrarily. When I am honoring my commitment, I am depositing rain, there is no, I have not committed any breach. Simply, 1 month notice, that too, they have to give at least issuance. I have already, invested lot of money. I am also ex-serviceman.
What you have been...
And if your lordship sees the policy, my lordship, there several categories have been mentioned. That the widow of the, and also the ex-serviceman. Nowhere it is stated.
You are also ex-serviceman?
Yes, I am ex-serviceman. I am not a civilian. So therefore, as per their own policy, I am also entitled to have. If the agreement consists of a renewal clause, then I have also right to apply for renewal. So that's why I am saying you cannot curtail my right.
They have not to apply. They can apply. After the 5 years, there is cooling. There is a cooling for 3 years. After they can apply. No. But in the agreement, I have to write. This is my discussion power.
Agreement envisages that
if this is my decision that I should be continuing or not.
I am not.
No, why are you misleading the court?
No, I am not misleading. It is your agreement says there is a renewal policy, my lord. I am just showing your lordship.
The notice did you vague? Are you saying?
On the one hand, they are saying that 1 month notice, but at the same time, after 11 months, there is a renewal policy also. I am just showing you lordship. The
This
last
is your
agreement.
decision for, this is my part.
I am not saying, but there is a renewal clause is there.
I will not renew.
That is your discussion. I am not
Then-
saying that, but I can
That's what I'm
apply.
saying.
What I am on my, I can apply.
5
What
years,
my
5 years, 3
target
years.
is suggesting
You have
that I
implied.
will give an undertaking that I will not apply for renewal. But whether, and I will be stopped from challenging the policy. But can this undertaking be given?
Okay. That's all.
That's all. So, my lord,
The petitioner has filed the presented application challenging the order of vacation issued by the respondent dated 17th May 2025. 17th May 2025. Full stop. The case of the petitioner is that petitioner is the ex-serviceman, and as per the guidelines from the respondent authorities have allotted a shop to the petitioner, a shop number 6, Roman 2 lines, command HOSP complex, Alipur, Kolkata 700027 to run book and stationery shop on 23rd of June 2012. On deposit of security amount of rupees 12,500. Right. Pull it. They submit that though the initial order of allotment of shop does not contain any period of the tenancy, but the authorities have time to time extended the tenancy period and increased the rent of the premises of the shop room in question. Lastly, on 11th of February 2025, an agreement was entered between the petitioner and the respondent authorities, wherein the period of tenancy is prescribed for 11 months from 11th February 2025 to 10th of June 2026. Full stop. The petitioner submitted. The petitioner is enjoying the premises in question and paying the monthly rent as agreed between the parties. All of a sudden, on 17th May 2025, the respondent authorities have issued the vacation notice relying upon the guidelines for allotment of the shop dated 7th of February 2018, informing that 100% reservation for war widows/widows of the defense personnel killed while the duty /disabled soldier ex-serviceman and spouses/widow of ex-serviceman etc. shall be followed for allotment of the regimental shop in various formation of the establishment unit. In the said notice, it is further mentioned that the license period of allotment shall be subject to 5 years with the 3 years cooling off break period. Counsel for the petition submitted. The respondent authorities have issued the notice on the basis of the guidelines dated 8th of February 2018. But the respondent authorities have allotted the shop in the year 2012, and the authorities have extended the period of tenancy from time to time. And lastly, on 11th of February 2025, for a period of 11 months, and still the tenancy period has not been completed. But during the existence of the tenancy period, the authorities have issued the vacation order of eviction and eviction full. Learned counsel for the petition further submit that the guidance which the respondents have relied upon, which is not applicable to the petitioner, as the guidelines has been issued in the year 2018 and the petitioner is in occupation of premises in the year, since the year 2012. Thus, the guidelines cannot be given retrospective effect. But counter learned advocate appearing for the respondents submit that since the year 2012, the petitioner is in occupation of the premises in question. And lastly, on 11th of February 2025, the rent agreement, the period of tenancy was extended for a period of 11 months, and the petitioner agreed for the extension of 11 months, which is going to be expired on 10th of June 2025. He submits that in the said agreement, as per clause 7, there is a provision that 1 month by giving 1 month notice, the agreement can be terminated. And accordingly, respondents have found that respondent in terms of the guidelines dated 7th of February 2018 have issued the notice by giving 1 month time to the petitioner to vacate the shop. Thus, there is no illegality in issuing the said notice. Police. Then counsel for the respondent further submit that in his fairness submission after on instruction submits that though the respondents have issued the notice to the petitioner for vacating the premises, but the petitioner can enjoy the premises till 10th of June 2025 and thereafter 10th of January 2026, and thereafter the petitioner cannot be allowed to continue with the premises, and he should vacate the premises and hand over to the respondent authority so that the respondent authority take appropriate decision in terms of the guidelines dated 7th February 2018. Heard the learned counsel for the respective parties produce the materials on it. This court find that initial order of allotment was issued in favor of the petitioner with respect of the shop room on 23rd of June 2012. And since then, the petitioner is in occupation of the premises in question and enjoying the shop premises. Lastly, on 11th of February 2025, a fresh rent agreement was entered between the parties. A lease agreement, lease agreement was entered between the parties, and in terms of the said lease agreement, the tenancy period is only for 11 months. That is from 11th February 2025 till 10th of January 2026. In the said agreement, as per clause 7, 1 month notice from either of the side will be sufficient to terminate the agreement, and on such termination, the licensee will hand over the vacant possession of the premises back to the licensor without showing any reservation whatsoever. And the licensor is not bound to give any reason for termination of the agreement. Learned counsel for the petitioner relied upon clause 6 of the said agreement, wherein the renewal clause has been provided. As per clause 6, the agreement shall remain in force for a period of 11 months from the date of commencement, but the license reserves its right to renew the same for a further period of 11 months, twice up to a maximum period of balance month at the discretion of the management on agreed terms and conditions, and accept that the rent and the rebate shall be increased by 10% or more on every extension in case this agreement is renewed for an additional period. This could find that the petitioner is enjoying the shop premises as an ex-serviceman since the year 2012. The respondents have relied upon the guidance dated 7th of February 2018, which reads as follows. Page number 24, para A and B. Okay. The said clause categorically reveals that 100% reservation from the war widows/widows of defense personnel killed while on duty / disabled soldier or ex-serviceman and spouses/widow of ex-serviceman etc. shall be followed. Negative निकाल दो जो मैं बोला काट set out के बाद छोड़ो. This guidelines provide for reservation as mentioned in para 8 of the said guidelines. As per para 9, the license period of allotment shall be subject to 5 years with the 3 years cooling off period. In the present case, the shop was allotted in the year 2012. Until date, the petitioner is in occupation of the premises and enjoying the premises. The last agreement was entered on 11th of February 2025, which is going to be expired on 10th of January 2026. This court finds that the petitioner has enjoyed the shop allotted to the petitioner more than 2012, 2025, 30 years, 32 years, 33 years, 2012, and 13 years, more than 13 years, And as per the guidelines, the period of allotment shall be 5 years and with the cooling period of 3 years break. Considering the above, this court finds that the offer made by the respondent that the petitioner shall continue with the premises in question till 10th of June January 2026, and the petitioner has to vacate the premises is a good offer. Thus, the court has accepted this offer made by the respondents, and the petition is directed to vacate the premises on 11th of January 2026. And if the petitioner intends to continue with the premises, the petitioner can make a representation to the authorities. The authorities can consider in terms of clause 7 of the agreement, clause 6 of the agreement, within a period of 3 weeks on receipt of the representation of the petitioner. WPA number 7% so disposed.
My lord, disposing of the petition.
Disposed of the representation, I directed you have to vacate. If you want to continue, made a representation, they will consider.
My lord, that period that the will till 10 January, my lord,
10 January.
Thereafter, I will make a
representation.
But one level in default. If they fail
well,
to
that is renewal clause is there.
It's default already there.
Well, the entire lease period I will cover. Grateful to you, Lord.
Item number 10.
My application. It's all right. No, this is served on everybody. This is the affidavit of service. We've served on everybody. You needn't be troubled with the papers right now. That I am importing petroleum coke from Devonport in United States of America. My insurance covers from warehouse to warehouse. The coke, the pet coke is put in 5 different holes, like 5 cylinders. The bill of lading says that the goods which have been exported from America for import into Holdia is a clean bill of lading. The goods have been uploaded onto the dock or onto the ship, the vessel, in a clean manner. When the goods arrive here, Holdia Port writes to me saying 3 out of the 5 have a lot of water in it. So when I'm taking it down, there is loss of quantity. I am not going to be responsible for this. So we naturally go around because this is the insurance claim. The goods are valued at 134 crores. That is the value that I have in the what is coming to me.
What is the insured amount?
134 crores. And full premium on that is paid. Now, Your Lordship understands why. When it comes here, when I'm taking it out from the vessel.
That's why whenever the insurance cases come, my single question to the insurance authority, you show me any of the example, any case you have settled.
You pay. Here, my lord, with humility, they've gone a little too far. They've altered the exclusion clause to repudiate the claim. Exclusion clause doesn't even have 2 words. Moisture and reduction in quantity is not there. They've added that and repudiated the claim.
That's not in our contract.
It's not in the contract. Not in the exclusion.
Moisture is not in the contract.
Not in the contract.
Moisture when it was found?
Moisture was found when I'm bringing it down from the vessel. Holdia Port lets me know. I go when I'm bringing it down. What happens is, it becomes like a slurry. So with the water, the coke also drains out. So I write to them immediately. They appoint a surveyor 2 years later.
2 years there was correspondence. What is their excuse?
How
That
the writ?
Writ because of two aspects. Your Lordship is aware that now the 2015 there's a survey regulation. It says you have to do it within, I think, 90 days, right? 72 hours. 72 hours you have to appoint. Second,
Receipt of the complaint.
receipt of the
Report.
of the report, of the
Complaint,
intimation
whatever.
of law. Their plea is that I was supposed to make an assessment of the loss and inform them. But if I assessed the loss and told them 200 crores, would they have come and given it? 2 years later, the surveyor is appointed. 1.5 years from then.
After 2 years, they have been appointed. So how they came to know about the moisture?
That's right.
If 2 years,
Your Lordship has put the query to me. What I would have put it in an affirmative sentence. 1. The surveyor's report makes no reference as to whether this is actually why it's not payable. But because the 134 crores, 25th, 2025 September, my repudiation counts. 5th of September for a May for a loss that has occurred in 2022. And what is the ground? That under the policy, what is excluded is A, B, C.
which insurance policy? United India.
United.
So what can be done?
Not relying on two decisions, I was only furthering this. And I'll show that clause. I'll bring it down to only 2 points. One is that
What interim order you prayed for? Nothing.
Well, interim order, I was going to, the two judgments that I had, two questions the court has considered. One is that you pay the money immediately. That might be a little too far for me to argue today. Eventually I will, but today it might be a little too far. So I was praying for at least them to deposit 50% of this 134 crores in court. Because this is ex facie contrary regulation.
But whether the writ will lie.
Yes, that I'll be able to satisfy.
How the quantum can be adjudicated in the writ jurisdiction?
Yes, so two things that your Lordships have always held. That because it's an insurance contract and because of the nature of functions that the respondent discharges, there is a public law limit. This is based on the Supreme Court judgment and a rejection of like any other contract, but the test is slightly higher. Rejection has to meet the test on the anvil of Article 14. If it's patently arbitrary, or if it's something done with undue haste, or the right things have not been taken into consideration, then your Lordships have always interfered. This is based on one Supreme Court decision and two High Court judgments. This I'll cite. But what I want to highlight is, look, this respondent, the exclusion clauses say A, B, C, and D. It doesn't have moisture. Instead of relying on me, can I just show that page directly? Please see how this has happened. Well, otherwise I would have actually, they had come to me. I'm being very honest. They had come to me wanting a suit. But just seeing the repudiation, I said immediately prefer a writ because this one page should really suffice. Just one document your Lordship will kindly have make a note of. Please have a look at page 227. And I'll place 227 with 83. 227 paragraph 6. We vehemently,
Yes.
We vehemently deny the contents of paragraph so and so, your notice is false and frivolous. We would reiterate that even though the policy is governed by ICC A clauses, the coverage of any loss due to heating, please mark this note, sweating, contamination, adulteration, moisture, your Lordship will please mark, moisture, condensation, next one, deterioration of quantity are excluded under the policy. Now, my case is moisture, deterioration, quantity. But what is happening when I'm bringing it out? It's slurry, so I'm losing pet coke. Therefore, I've invoked. Now, please have a look at page 83 is the insurance policy.
Yes.
83. Well, the pagination could have been slightly blurred due to the name of the respondent. Well, your Lordship will see exclusions at page 83.
83 exclusion.
1, 2, 3, 4 is what they have quoted. At page 83, exclusion. Left-hand column, there's the exclusion. 1, 2, 3, and 4. Losses due to heating, sweating, contamination, adulteration, deterioration of quality. So moisture, and this is why I said file the writ. Especially I'll be able to show the reputation has been. I'm grateful, that your lordship is comparing it to 227 once more. Please come back, Due to heating, sweating, contamination, adulteration, moisture they add, deterioration of quantity they add.
Excluded under the policy.
Excluded, and this is not excluded.
Losses due to heating.
Heating, sweating, contamination, adulteration, moisture not there.
So where is the report?
This is the reputation letter.
No, there is no report.
Survey's report.
Survey's report. It might be based on the survey's report.
It's not. 240 I'll show. Even if I don't go there, 240 I'll come to that. Lordship will disregard that. I am saying that when you are, it's patently unfair and arbitrary.
No, that's correct. That's correct. I appreciate your argument. If it is the moisture is not in the contract, moisture is not in the contract, you cannot.
That's
correct.
Moisture not there, deterioration of quantity not there. These are my claims.
Correct. So where is the report of the surveyor? What the surveyor says?
240 your lordship will see. And please make a note of the date also. 240. Right hand corner.
Yes.
28 November 2024.
When the incident was occurred?
2022. August 2022. Surveyor has been appointed by them.
Incident on?
22nd of August 2022. I have written to them on 22nd of August 2022. Surveyor is appointed by them.
So till that time, where is the material?
It's been because it's warehouse to warehouse. It's in my warehouse.
Still.
It's still there. Oh, now we've used whatever was there. Because the inspection when they send, that was happened. This your lordship will find from page 240 I'll place from a surveyor's report. Your lordship will find that this is given on 28th of November 2024.
Correct.
The final part your lordship will kindly come. Please come to page 323. Now, 323 I'll place two paragraphs. I don't think I'll need to trouble your lordship any further.
Yes.
Immediately after that table, to sum up the matter.
323.
323.
Yes.
323.
Correct.
Immediately after there is a box, not immediately under. To sum up the matter, we wish to state that keeping in view the findings of the Haldia Port authorities in the above shown two email, it is very difficult on our part or not in a position to deny and dispute the presence of water inside hash number 135 of the vessel. In view of the above stated facts and circumstances, we cannot comment on the acceptability or deny the liability. However, we are leaving the final decision at the discretion of the underwriter. This surveyor is clear saying we are not being able to deny because we are not being able to deny that there's a presence of moisture. Now there is no way out. 134 crores they have to give me. What do they do? What your lordship had pointed out. You cannot add words to the policy and exclusion. Courts have always held, your lordships have always laid down, exclusion is to be read in a manner which is beneficial to the insurer.
And to interpret it.
Interpretation. Here, I'm saying that interpretation is also not required. Because it is expressly evident. Once the surveyor gives his report, I'm very grateful the lordship got me to this one. Once they give a report saying I'm not being able to deny the presence of the moisture in this, so they have no option but to add moisture because it doesn't come under any of the exclusion. It is not heating, not contamination.
How you came to know? Where is the reputation letter? 2?
Yes.
83. 83. Where it starts from?
Your Lordship is looking at
Reputation letter?
reputation letter. This is the reply number 227.
No, reputation letter. Where is the reputation?
209.
209.
Same thing, Your Lordship will find there. At 213, kindly see. Two one three, the second last, the penultimate arrow or bullet, whatever. There are no details of the quality and moisture content of the pet coke for the cargo discharged at Paradip Port. The draft survey report of the cargo discharged at Paradip Port for the unknown consignee was not provided by the insured. Therefore, the manner in which the loss has been calculated or quantified is arbitrary, and it is stated as an effort that has been made by the insured to justify an unexplained shortage. The insurance for this, the insurance policy excludes rejection and quality shortages, and also unexplained shortages, condensation, moisture, etc., caused by ICC-B perils. They applied a wrong test, including the word moisture. So when I write to them saying I'm covered under ICC-A, how are you using ICC-B?
But it is correct. So okay, if you go, if the court will say, if the court will find, okay, this report or the reputation is wrong, but how the red court can assess the damages?
No, that I don't want. That I don't want. My prayer before your Lordship is to have them reconsider this on the basis of the policy as it exists. This, what is not available to me, I won't argue. Too many years now to argue something that's not available to me.
Whether yeah, where is the service?
Yes, no. Service, I haven't personally checked. My instructions are. Our response number 1 has been served by hand. Page number 3, Your Lordship will see. Response number 1, who's the answering respondent, has received it by hand.
Okay, I am fixing, and next week issue the another notice to the.
I will do that. In the meantime, Your Lordship will stay the repudiation.
Gone through nothing.
They have repudiation stay really, but at least repudiation, Your Lordship will stay. This really can't.
What will happen? If your reputation continue, you will not get the payment. If you stay also, you will not get the payment. What will happen? You tell me. If the court is passed an order for staying the reputation,
I'll tell you, Lordship.
What benefit you will get?
It allows me to come and urge before your Lordship for them to reconsider that.
Let the one opportunity be given. Otherwise, I will dispose of the writ application. If they will come, then let me hear. The petitioner has filed affidavit in opposition. Let the same be kept to the record. In spite of service of notice, none appears on behalf of the respondent number 1. So the respondent number 1 is the main party to decide the present writ application. Accordingly, the case is adjourned. Let the matter appear on कौन सा कोई दिन खाली है देखो 12 बजे या 2 बजे का एनी डेट कौन सा दिन हम लोग खाली पड़ा है नेक्स्ट वीक हाँ
Look, could I just indicate something? But this is the second. We've served them twice.
Okay, let it serve. हाँ 17 नो ट्राई उसके बाद सब फुल हो गया 2 बजे का सब 2 बजे नहीं है ना तो आई एम फिक्सिंग ऑन 20 को 2 बजे है 20 तारीख को 20 एट 2 PM है 2 है कौन सा तारीख में नहीं 21 को 21 भी 2 बजे है कब नहीं है 19 है 18th में नहीं है 18th November at 2 PM 18th November at 2 PM the petition is directed to inform the next date of hearing to the respondent number 1 and to file affidavit of service on the next date fixed. The petition also directed to communicate this order to the respondent number 1.
Very good.
Next.
Lordship, is that matter, Lordship? RTI application, petitioner made the RTI application, Lordship.
Urgent motion. Urgent motion. Sorry, urgent motion. Under the urgent.
My Lord, I am appearing for the state respondent led by Mr. Owen
For
Banerjee.
the petitioner.
I am for the petitioner.
Yes.
Lordship, petitioner made the RTI application in the in the year 2018, Lordship.
2018
Yes,
RTA
sir.
application.
Made.
Then what has happened?
Lordship, kindly see page 13, Lordship.
Yes,
There is a
see.
question, Lordship.
See.
Yes, Lordship. Lordship,
13,
last option. Yes, sir, Lordship. And thereafter, petitioner didn't get the reply. Thereafter, petitioner made the first appeal, Lordship. Page 14, Lordship. And led by Mr. Anindalai, Lordship.
Lordship was pleased to take up this matter on earlier occasion.
Then the second appeal also pending. Appeal is also pending.
No, second appeal disposed of. Kindly comes to the order of the second appellate authority.
Page 19.
19. Sri Tarashankar such and such.
The commissioner has found sufficient.
After producing all the relevant documents and annexed thereto, the commissioner has found sufficient grounds to inquire into the matter and has decided to hear the instant matter on such and such in presence of all. Both parties are present during the course of hearing. Matter has been called for hearing. Heard submissions, both parties. After consideration of all the documents, it appears that the first appellate authority has rightly directed SPIO to dispose of the RTA application within 3 days. The commission thus upholds the direction of the first appellate authority and further directs the SPIO to allow inspection of all relevant files stroke documents prior to the computerization of the records and to provide authenticated copies of all documents thereof, as indicated by the appellant, free of cost within a period of 4 weeks from the date of receipt of this order, with its such and such disposed of. Thereafter, my lord, the first appellate authority again called the SPIO in compliance of this order. Next page. Being aggrieved, he records everything. As a result, the Lordship has been, as a result, the Honorable State Chief Information Commissioner heard the matter of such and such, and was page 21. Next page. Yes.
Being aggrieved with the
As such and such, heard the matter on such and such and was pleased to order for inspection of relevant documents, files prior to computerization of the records and to supply the required documents at free of cost. Hence, Block Land and Land Reforms Officer Kultali is being directed to take necessary action in strict compliance with the order of the Honorable State Information Commission under the intimation to the end without fail. Now, thereafter nothing. I give a letter, total inaction from the day one, my lord. He is totally indifferent. What is, well, and the kindly sees the information that is sought for innocuous informations. My information page 18. Oh yes, page 13. My father's name was there recorded in the revenue records. It has suddenly disappeared. Page 13.
Lord, I am for the state, Lord. Lord, 2019, this order was passed. New incumbent has joined. 6 years have passed. He has made a request before your Lordship, Lord, the BLLRO. And if your Lordship gives him 2 weeks' time, he will consult all the records and try to comply and with the direction.
Disposing of within 2
Or
weeks.
your Lordship
keeps his
only because what is the position? Because 6 years have passed, COVID was intervening. So he'll have to trace out the record and so kindly keep it pending. I'll come back.
COVID record has not been damaged. It is not.
That is not my instruction yet that there is any difficulty in finding the record. But since 6 years have passed, kindly give me some time. I'll come back with the instruction.
When you tell, I will fix as per your convenient date. Tell me.
No, whatever date
you tell. You give the date, I will fix it. But my date, once I fix and you are not complied with, then it will be a very difficult.
Because his prayer is for compliance only. He's just given a letter to me that kindly prayer.
The
keeps it pending.
He has to comply because the commission has passed an order.
Application on the allegation that in spite of a specific direction passed by the State Chief Information Commissioner as well as the first appellate authority, the SPIO failed to comply with the order by providing the information fully.
Learned counsel appearing for the state respondent submitted. This is the case of 2019 and requires some time. Accordingly, as per the submission made by the counsel for the petitioner, counsel for the state respondent, the case is adjourned. Let the matter appear on. I am giving 3 weeks. Today we are on 13th. Let the matter appear on 2nd of December 2025 under the heading adjourn motion.
Would it be a lordship pleasure to keep it? Oh, 2nd of December is this side. Okay, yes.
It is made clear that by the date fixed, if the state respondent failed to come with the appropriate,
information as sought for in page
appropriate
13.
Information in terms of the order passed by the state
Information Commission.
Second appellate authority.
State Information Commission.
That's the second appellate
commissioner, appropriate order.
19.2.
Next.
Deep language.
Phone call.
I don't know, 12, I'm appealing for the petitioner, my lord.
Yes.
My affidavit of service.
For the state respondent, lordship, for the state respondent, interest regarding lordship.
Yes.
My
lord.
I am appearing for the respondent number 8, private respondent.
My lord, the petitioner and the private respondents are the owner of a water body, my lord. Pukur, my lord. My complaint in this writ petition, my lord, is that the private respondent, my lord, is carrying on unauthorized construction work of shop rooms by constructing pile-shaped pillars in that water body, my lord. If my lord kindly let me show you the documents, my lord, the classification of the land, water body one by one. My lord kindly comes to my first annexure, page number 13.
Yes.
Yes, dag number 171, and then it's written in Bengali, my lord, Pukur. Sreni Pukur, it means water body, my lord. Then my name and the private respondent's name is recorded, my lord. The next page, my lord, page number 14, this pertains to, my lord, dag number 511. There also both of our name is recorded, and my lord kindly sees Jomi Sreni Pukur. So it's a water body. Now, my lord kindly sees what the private respondent is doing. If my lord kindly turns the page, I have annexed some photographs. My lord can see. They have constructing unauthorized, my lord, there has been no permission. Obviously, that cannot be. The unauthorized construction of shopping, shop rooms, my lord. That is what, when the writ petition was filed, after this is, my lord kindly sees these photographs, this is the position now. I have taken those photographs yesterday.
Yes.
Now, my lord kindly sees the petitioner has written to the Gram Panchayat and also to the Ministry of Fisheries. The next page, page number 18, my petitioner's letter date is 16 December 2024.
Yes.
Now, my lord kindly sees the reply has come from Department of Fisheries, Aquaculture, Aquatic Resources, directing the district magistrate to demolish those unauthorized construction work and to restore it in a pristine condition. If my lord kindly sees the second paragraph, this has been addressed to the district magistrate, South 24 Parganas. You are requested to take necessary action in the capacity of competent authority, because he is the competent authority under this act, West Bengal Inland Fisheries Act, as notified with a notification. That notification I have, my lord, if my lord wants. And by taking steps to restore the said water body into pristine condition, if found to be filled up illegally. This letter was sent on 28th February 2025. We are nearing the end of this year. Till date, nothing has been done by the district magistrate. That is why we are before your lordship. Next page is my demand justice notice, my lord. Page number 22, my lord. I have sent this notice on 21st February 2025. Till date, they have not done this. This is my case, my lord.
Yes, state. Yes, private respondent, what is your
But
condition?
factually, my lord, my connect fed is not properly instructed, my lord. Whatever I have instruction, my lord, there is no construction.
But
So
what
for the dag number, my lord, that
Okay, let the
photograph has
report
been
file.
taken.
Let the state
I will also file an affidavit to that respect, because there is no construction. So for dag number 511 and so for dag number
with the
171 are concerned, where there is no
the
construction.
photographs with the petition.
Well, that is, that photograph is taken in respect of.
Okay, and the report, the order passed by the concerned authority, that is the where is
But
the-
inspection
Page number
is already
21,
post, my lord. inspection has already been caused, my lord. My lord, I do not know whether the state will file the report. My lord, report has already been.
Page 21.
But I understand, my lord.
But that is wrong. That is wrong.
Lordship, but it's
My
stated
lord, there is
found.
no, my lord. My lord, there is not. If it is found, my lord, there is no construction, my lord.
Lordship, at present, I don't have the report, Lordship. I'm
The
going
report
for
is there.
Because
my
there
lord.
was a direction to file.
How soon?
Lordship, a week. Lordship.
Because you persons are allowing all these illegal activities, and once the building fall down, then you started creating problem to the site plot holders, not to the persons whose building has been demolished.
Lordship, I'm sorry, I don't have the report at this moment, Lordship. I will.
Please find it. If
Lordship, I will.
till the time I am here,
Lordship.
this type of the activities I will not allow.
Lordship.
If I will find immediately, I will fix for demolition and call the report for demolition.
Lordship, Lordship.
And if this court will find your report is wrong, this court personally will go and inspect.
Lordship.
I will invoke that jurisdiction also. February 2025, one authority has given a request to you. What you have done?
I'm really sorry. At this present, I don't have the report.
The counsel for the state respondent pressed to file a report by way of an affidavit. Full stop. The private respondent also pressed for time to file affidavit. The state respondent is directed to file a report by an affidavit within
Lordship, then 2 weeks, Lordship.
within 2 weeks. Full stop. The private respondent is also liberty to file reply affidavit in opposition within 2 weeks after serving the copy to the learned counsel for the petitioner. The petitioner is at liberty to take exception, if any, to the report of the state authority as well as the affidavit in opposition, if any, filed by the private respondent within a week thereafter. Please the matter on 4th of December 2025. No, not 4th. 9th of December 2025 under the heading adjourn motion.
Grateful, Lordship.
The affidavit of service filed by the petition be kept with the.
12th, Lordship.
Yes.
Lordship.
Yes.
Can it be 12 or 11 or 14, Lordship?
Why?
Should find this little
9th is?
difficult.
You asked for the 1 week.
Lordship, I will file the report, but the date has been fixed on the month of December. Is 9th. Can it be
12th December?
Lordship, 12 or 14?
12th.
Very well, Lordship.
12th December.
Grateful, Lordship.
Next.
My lord, I am for the petitioner, my lord. This is my affidavit of service served upon all the respondent authority.
Yes.
This matter, my lord, what happened? This is second.
Out affidavit of service out.
Yes, my lord. This is second round writ petition, my lord. First, my lord, this writ petition, one writ petition filed before Honorable Justice Amrita Sinha. She passed an order, and my lord, in that order, the bank authority was directed. My lord, the precise story is this, my lord. The petitioner is being a baul within this baul sampradaya, my lord. She invested some money in the bank authority before.
Which bank?
In UBI, my lord.
UBI.
Bank of India, my lord. 7,50,000 rupees for 4 years, and my lord, under MIS scheme. And thereafter, my lord, that even after maturity, bank is not releasing that. Thereafter, my lord, she filed one writ application, and there, my lord, in the order, my lord, kindly have a look into P8, annexure P8 page. Page 55, my lord. Kindly have a look into. Here, my lord, they disclosed, the bank authority disclosed there is one objection of BDO. That is why they are not releasing.
Yes. The bank manager of the State Bank of India.
Yes.
Tatla branch is directed to intimate the petitioner reason for not transferring. Have they informed the reason?
Yes, my lord. No. Not thereafter, my lord. I have filed RTI. Even at have done RTI, no answer was given. Even my lord, that BDO I have made party, district magistrate I have made party, Gram Panchayat who has raised.
What they will do? It is the bank only. What the Gram Panchayat and the district magistrate?
That is why, my lord, this second round writ petition is coming, my lord.
Ah.
If one objection coming against me without any criminal case, without any civil case, my lord, whether the bank authority can, my lord, withheld my own money, what I have invested from my own property, my lord, kindly have a look into P1. I have given the source of the money. I have sold out one property of my husband. From there, my lord, Bikroy
Whether this account, your account is subject to any criminal case?
No.
No criminal case.
Nothing else. Only simply, my lord, video that later I am giving, my lord. That is in vernacular language, but somehow I am.
Where is your fixed deposit? Where is your deposit? Receipt?
Receipt. This is
Where is your deposit receipt?
27, 28 page. No. This is. My lord, I am showing, my lord. Yes, my lord. 33. P3 and P4, my lord. 13 page 39.
3 is the election identity card.
Yes, my lord.
33 is the election identity card.
No, my lord. 39. Page 39. They are, my lord, receipts of that bank authority.
This is a receipt, deposit receipt.
Yes,
where is they have not given any certificate with regard to?
43, my lord.
43.
Yes. Thereafter, my lord, for change of residence.
Where is the 43?
43, my
Also
lord.
receipt. Where is the certificate? They are not given. If you have deposit the amount under the scheme.
Yes, my lord.
So where is the certificate of the scheme?
It's not there. That is not there, but bank authority is saying that yes, there is an account, but we cannot disburse the money because of this complaint.
What complaint?
That complaint of video.
Video is made a party here.
Yes, my lord.
Have you served?
Yes. Gram Pradhan is also made party.
Why the video has made a complaint? Who is appearing for the video? Which area?
Area of Chakda. Nodia.
Yes, madam, you are appearing. You.
No, your lordship, not in this matter.
Notice served, nobody is appearing.
In the
Chakda.
Lordship, can you?
Serve the copy. One copy give, we take instruction.
Yes, ma'am.
And I am also directing you again, you serve the bank. Let
Yes,
the
ma'am.
bank
Yes,
file the report and they will also come with
She is a very poor lady.
the petitioner has filed affidavit of service. Let the same be kept with the record, but in spite of service of notice, none appears on behalf of the respondent. On instruction, the Leonard, what is the name of the lady? Sensu is directed to appear in the matter on behalf of the respondent number 6. Respondent number 6 and to take instruction. The petition is directed to have the copy of the writ application upon the non-advocate with in course of the day. As none appears on behalf of the bank, the petition is also directed to inform the next date of going to the bank and to file affidavit service by the next date fixed. List the matter on 21 November 2025 for filing report by the respondent number 6 as well as the respondent number bank
Video chapter.
as well as the respondent number 1 and 2. Respondent number.
And my lord, Pradhan of
Come with the report. What
yes.
And my lord, Pradhan of
under
Tatra
the
is
urgent,
also being.
under the urgent motion.
He is also important part.
Yes.
My lord, Pradhan of.
Let the BRO come. Let the BLRO come.
Yes.
Lordship, may I just mention with respect of item number 12? I was asked to appear on behalf of EKWMA, but I heard it wrongly. I thought it was item number 15. So I was waiting for item number 15, but it was item number 12.
Which matter? Which
EKWMA.
matter?
12, your lordship. East Kolkata Wetland Management Authority. Lordship has been pleased to direct the state respondents to file affidavit or report, and it is going to appear on the 12th of December.
Correct.
If Lordship is
Record that. Give the record that. Item number 12, record the name for the respondent number 2. Respondent number 2.
EKWM.
EKWM. I have written. Grateful, Your Lordship.
Yes.
My lord, I'm for respondent number 7, 8, and 9. My lord, I am for the bank, my lord. But this writ petition is not maintainable, if so for my understanding.
My application.
What is the
allowed? But the fact is that the one Abdul Kader, who is the who? It's a bank. Oh, sorry. But the fact is that the petitioner is the director of the respondent company. Respondent number 7, having 70% share. And presently, my lord, due to his illness, he is unable to attend in the company.
Correct.
And taking the advantage of the same, the other directors are making misappropriation. For that reason, I have made an application to the concerned bank, which is in the name of the company, to stop the operation of the entire transaction in respect of the bank account. Initially, same was accepted, and ultimately, after few days, I have been informed by the concerned bank manager that that cannot be possible. My lord, kindly come to.
But how the writ petition, how this code will go into the partnership, disputed partnership?
No. I have made an application to the concerned bank for stopping the.
So that's why it is a partnership. You are making
Company
complaint, you
matter.
are making complaint. How the writ code can
But this is
interfere
a
in
perfect
that?
case to operational mismanagement, my lord. How the bank authority.
How the bank can go with the partnership deed? There is a dispute between you and the other partners, and the other partners misappropriating or whatever it is.
Between the internal dispute, it would be decided by the company. I know, my lord. But regarding the operation of the bank account, regarding the operation
That's
of the.
why the operation of bank account, whether the writ code or the other.
But initially the
Go to the civil
So, my
suit,
lord,
file a civil
it will
suit,
be
take
disposed
before
of.
the, it has to
take
be
an
Madam,
injunction.
please allow me.
Take an injunction restraining the other partners.
But initially the
freezing the
operation of
account.
bank can be stopped, my lord. Thereafter, my lord, thereafter
Correct.
the entire issue will be
I
decided.
fully appreciate with your submission, they cannot do.
Yes.
But by sitting in the writ jurisdiction under 226, whether the court
My
can
entire
interfere
allegation against
with
the
the
bank.
dispute between the two parties.
The subject matter of this writ petition is allegation against the bank. I have made an application.
Maybe bank, but arises from where?
Yes, my lord.
Where the disputes arises?
Initially, the operation of the transaction of the bank account may be stopped. There subsequently, I will make an application to the concerned authority or concerned forum.
Go to the civil court and
initially kindly give a direction to the concerned bank authority.
No, why?
The bank is a private bank, my
dispute? How the writ court will interfere?
It's an HDFC bank, my lord. Writ petition cannot.
Bank, each and
That
every
also
bank
the
is regulated under the
Writ
bank
petition cannot
regulation
be.
act. Each and every bank is operated by the banking regulation act after giving the license of the Reserve Bank of India. So my learned friend is saying that this is a private bank.
So for the company affairs is concerned and their grievance regarding the affairs of the company, they have already approached the NCLT, my lord.
Who?
This
Petitioner?
My lord.
NCLT.
It is under adjudication. We are participating.
No. According to my instruction, man, I do not have any instruction regarding filing of the any application before the NCLT. I do not know, my lord. I do not know, my lord. Then, my lord, kindly give a an
So, my lord, there is no replacement.
at this stage.
What is the name of the petitioner?
Sopon Kumar Saha.
Then what is the company? What is the name of the company?
Company name is Tram Shipping Travel.
Then see NCLT. File the reply.
Kindly make it not today. I have to take instruction. My lord, kindly make it not today. Kindly make it not today.
Not today.
My lord, you cannot even sustain. My lord.
Breathing time may be given.
My lord. My lord, the petitioner can easily applied for the suspension of the.
Well, may I-
No PR has been.
আমাকে একটা কপি দেবেন আমাকে একটা কপি দেবেন
My lord, that is in the annexure, my lord.
Take a record and order.
Yes, my lord.
As per the As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear tomorrow under the same heading. Come tomorrow with the. Yes, next. Take instruction from client.
Yes, my lord, I'm taking instruction. On 15, I am for the petitioner and for the state respondent. But one Abdul Kader, who is the husband of the petitioner number 1 and father of the rest of the petitioner. In the year 1990, said Abdul Kader purchased a land by executing a deed of sale. But said Abdul Kader was unable to obtain the copy of the registered deed. Thereafter, my lord, the ancestor of the petitioner died, said Abdul Kader. Initially, the petitioner number 2, he make an application before the concerned authority for obtaining the copy of the, no, my lord, original copy of the registered
Original
deed.
copies with before him with the
Before
how
the
authority
authority, before the registering authority,
because it has not been given to the concerned parties.
No, during his lifetime, the original executor was unable to obtain due to some personal reason, my lord, who is the ancestor of the present petitioner. Now, my lord, thereafter I made an application before the concerned
When the deed was executed, 1990.
Yes, my lord. My lord, thereafter I made an application before the concerned authority for obtaining the same. Who is the additional district sub-registrar Sutahata, Purbo Medinipur. And the application has been annexed as page number 17.
When your father died.
My lord?
When your father died.
Father died
14th December 1990.
1990. And when the deed December?
No, my lord.
No.
1490.
1490.
It was executed. It was executed. Executed.
Date of the
And
deed.
thereafter, my lord, 2003. 20th July 2003, the said Abdul Kader died. Now, my lord, kindly come to page 18 in my application.
18.
18.
Yes.
And I have been replied by the concerned authority. May I permitted to read? In reference to the above, this is to inform you that as per the office records of the documents, number such and such for the year 1990 was seized by the district enforcement office, Mohishadol, as at present district enforcement branch, Ganapatinagar, Nimtauri, Purbo Medinipur, on the ground forged or tampered non-judicial stamp. Now, this is not in my case. The entire.
But this is a Telgi matter.
No. In not my matter.
No, it is a Telgi stamp.
Yes, like that. like that. So the original deed cannot be delivered, but the certified copy of the deed can be provided if the honorable court gives the direction to do so. I am praying before your lordship, kindly give a direction to the concerned authority to provide me a certified copy of the. I am also agree to.
No, but the.
I am also agree to give the entire requisite fees.
See, if you will given the certified copy in terms of the order, so you will use that, and that deed is a forged document.
No. In not my. No.
Offense, my lord.
No. In
criminal
my case, kindly give a direction to my learned friend to take instruction. In my case, there was nothing in regarding forge.
তোমার ডিড নাম্বার দিয়ে দিয়েছে
আমারটা ফোর্জ নয় দাদা, খবরটা নাও, ওখানে একটা স্ক্যাম হয়েছিল।
তোমাকে যে চিঠিটা দিয়েছে
স্ট্যাম্পের নলেজ থাকবে কেমন করে যে স্ট্যাম্প
আমারটা ফোর্জ হয়েছে নয়, আমার ইয়েতে দিয়ে হয় না, ওখানে একটা এন্টায়ার স্ক্যাম হয়েছিল।
My lord, sale deed number is also mentioned in this letter, my lord.
Correct. That's
I have annexed one.
See, what is your number? 6533. And we come to the page number 18. As per office record, the document number 6533 for the year 1990 was seized by the district enforcement office.
That is not.
Correct. Yes. You compared your prayer, your document and the document mentioned in your letter dated 18.
Then kindly give a direction to the concerned authority to supply me the copy of the certified.
Oh, if it is a forged document, how the certified copy will be given to you?
They are agreeable.
What, who is agreeable? They may agreeable, but how the certified copy will be given once the authority has seized that is the forged document?
Or in my
And you inquire what has happened to the criminal case. There might be a criminal case. That's why the enforcement district enforcement officer sees that.
My lord, in a similar matter, this honorable court was pleased to pass an order that has been annexed in page 19, my lord. My lord,
That cannot be a precedent.
my lord,
Because the
I am-
representative states and so.
19. Annexure P4, my lord. I am paying for parity also, my lord.
Deposit
My
the
lord,
sum
I am-
equivalent to the allegedly forged stamp. You will deposit.
Yes, sir. I shall deposit. Yes, sir. I shall deposit. I shall deposit.
You
my
do one thing. I am calling for the report. What would be the stamp duty of the debt bond paper? You notify this. Then I will direct to pay the stamp duty. And if you will pay the stamp duty and by
Yes,
electronic
my lord.
mode,
Stamp duty.
then you will supply the copy.
Yes, my lord. I am willing to pay the stamp duty.
But my lord, if any criminal case is pending, my lord.
আবার বলছেন কেন? থামুন।
If any criminal case is pending, my lord.
So you also obtain report. The petitioner has filed the present application praying for a direction upon the respondent number 7 for supply of original or certified copy of the deed of sale being number 6533 dated 14 December 1990. Counsel for the petition submit that the petitioner has applied for before the authority said document before the authority by a letter dated 14th March 2024. The additional district sub registrar Suhata Purba Midnipur has informed the petitioner that as per the office record, the document number 6533 of 1990 was seized by District Enforcement Office, Mashihadal, within bracket at present District Enforcement Branch, Ganapati Nagar, Nimturi Purba Midnipur, bracket close, on the ground of forged or tampered non-judicial stamp.
Actually, my lord, the order which my landed friend shows, my lord, in that case, my lord, document was not seized. But here the document was seized.
Document, full stop. So the original deed cannot be delivered. But the certified copy of the deed can be provided if the honorable court gives the direction. Full stop. The petitioner has relied upon the order passed by the coordinate bench in another matter in WP number 15128/2023 dated 13 September 2023 and submits that in the similar circumstances the court has passed an order and has asked and prayed for the same order in terms of prayer A. The learned counsel for the state submit that the order passed by this court in WPA 15128 of 2023 is not similar to the facts and circumstances of the present case. He further submit that the authority has to ascertain whether any criminal case is pending or not. In view of the above, the state respondent is directed to submit a report by way of an affidavit clarifying that number 1, whether any criminal case has been initiated with respect of the document number 6533 of 1990. Number 2, if the case is initiated, in which court it is pending and what is the stage of the case. Full stop. Number 3, if no case has been initiated, whether any action has been taken by the authority with regard to the alleged forged bond paper. Full stop. Let the report full stop. The number next. The authorities are also directed to submit number 4. To submit the to inform what would be the value of the stamp duty at that point of time with regard to the document number 6533 of 1990. Let the said report be filed within 2 weeks.
within 3 weeks after serving the copy to the learned
And
counsel
fix
for
the date, my lord. Fix the date.
The petitioner is liberty to take exception, if any, within a week thereafter. Release the matter on 11th of December 2025
Briefly.
under the adjourned motion.
My lord, can you indulge my lord? My lord, can you indulge my lord? Item number 45, due to some inadvertence, my lord is appearing this today, but yesterday my lord had fixed the matter on 21st of November. The matter where
Item number
45.
fixed on.
My lord, 21st of November, my lord is fixed, my lord, kindly, my lord,
Give the order.
my lord is asking for the order.
Acha, that electric
Yes,
connection. Report. Item number 45.
Yes, my lord. My lord, in today's list, my lord.
Item number 45. Learned counsel for the petitioner.
My lord, I'm for the respondent, my lord.
Learned counsel for the respondent had drawn the attention of this court to the order dated 12/11/2025, wherein this court has already fixed the matter on 21st of November 2025 at 2 p.m. 2 p.m. Let the matter appear on 21st of November 2025.
My name is Kushum Mukherjee for the
Yes.
Yes, my lord. Item number 60. Next item.
Ah.
My lord, issue is, my lord.
Come.
As your lordship. As your lordship. I shall not disturb. Yes. Yes, my lord, I appear. This is the affidavit of service. Yes, my lord, here, my lord, the tender was floated. I have participated in the tender. Subsequently, my lord, I have completed the job. I have raised the bill. Work completion certificate has been issued by the authority, wherein, my lord, I have done it. That is, my lord, at page, my lord, directly, my lord, if your lordship kindly come to page, my lord, that is page 40. My lord, the headmaster, my lord, where the school building was to be prepared, issued the work completion certificate. I have raised the bill, that is, my lord, at page 39. My lord will get. Page 39.
Yeah.
Yes. Lastly, my lord, I have made the representation before the authority on 24th July 2025. That is at page 41.
Yes.
And that is to be considered because, my lord, the bill has not been released for such reason. My lord, last occasion, my lord has been pleased to pass an identical order. My lord, though as it has not been made server, it was not available to us, so that for such reason, yes, it was because there was a direction passed by the authority that the work completion certificate, and it has to be done. It has to be done by the DEO, that is respondent number 6, district respondent number 6, district education officer, within a period of 8 weeks. That was the last order. Day before yesterday, my lord has passed. Mr. Yusuf is appearing. Lord, he will be approaching. Just now he will be coming. No issue. My lord, kindly pass the order. He will be, because my lord, at the time of rising, he was here.
The grievance of the petitioner in the present writ application. A work order has been issued to the petitioner with connection.
ছিল তখন এখন একটু
What is the name of the work order?
Milord, work order, Milord, that is at page
16.
I'm giving Milord page 37.
37.
Page 37. Acceptance come work order. Page 37.
In connection with construction of 2 ACR at Punda AK High School, which is HS under Gazol block, Malda, for the year 23-24. On receipt of the work order, the petitioner has completed the work and the headmaster Panda AK High School had issued the completion certificate certifying the construction work at section from the end of SS Malda in favor of the school in the year 23-24 has been completed, including electrical work and 20 set high-low bench as per the work order. As civil FSM dated 4 September 2023. After the completion of the work, the petitioner, you are appearing. I am disposing of. The petitioner has submitted a raised bill, but in spite of the receipt of the bill, the respondent are not considered the same, and the same is still pending before the authority. And counsel for the petitioner, after submission of the bill, the petitioner has made several reminders, but that has also not been considered. Had the learned counsel for the parties peruse the matters on record. There is no dispute with regard to issuance of the work order in favor of the petitioner, and it is also not disputed with regard to the work by the petitioner. It has been ratified by the headmaster of the country by a certificate dated 7/12/2020. Considering the above, this court finds that no purpose will be served by keeping the present date application pending. Accordingly, the petition is disposed of by directing the respondent number 6.
My lord,
to consider the
district education officer যেই হচ্ছে টাকাটা দেবে
to consider the representation submitted by the petitioner for release of the bill of the petitioner dated 9/12/2024 within a period of how much time? 6 weeks, 8 weeks?
8 weeks.
Within a period of 8 weeks from the date of receipt of this order, and the authority find that the petitioner is entitled to get the payment, the respondents has released the payment within 2 weeks thereafter.
I'm grateful. I'm grateful.
WPL census and disposed of. Yes, next.
Item number 78.
I pay for the petitioner's sale also.
कंटिन्यूटी होगा क्या 6 कंटिन्यूटी लेंगे ले लीजिए अलग आया है फॉर द स्टेट
You are for
I am for the registrar, Your Lordship. The registrar and the assistant registrar. Respondent number 2 and 5.
Lordship, the petitioners were the employees of Ramkrishnapur Cooperative Bank Limited, my lord. They were working, my lord, as the license of the bank was not renewed by the Reserve Bank of India. The bank has to close its operation on 3rd August 2010, my lord. Thereafter, several litigations were filed by the depositors. One of such litigation went into the appeal, my lord, before the division bench of this honorable court. In that appeal, my lord, the employees union of the bank approached, filed an application for addition of the party. That application was allowed. I will come to the orders, my lord. That application was allowed, my lord, and then it was observed by the honorable court, my lord, that the interest of the employees should be protected, my lord. The appeal was disposed of. Directions were passed that the employees' claims should be given to the employees, my lord. However, it was not worked out. Then a contempt petition was filed by the employees union, my lord. In that, during pendency of that contempt petition, the representation of the employees union was disposed of by the respondent number 1, thereby order or passing an order that since it involved the individual claims of the employees, so all the employees should file their respective claims separately. Pursuant to such observation, all the employees, including these petitioners, filed their respective claims, my lord. Now, these claims are pending since around a year, my lord. That has not been paid, my lord. Only a partial or a minimal amount has been paid. Thereafter, a further representation was made. That has also not been considered. Now, I'll take your lordship to the relevant orders, my lord. Kindly come to page number 20, order dated 11/4/2023, my lord. It starts from page 20. The relevant portion is at page 23, where the honorable court held that page 23, my lord.
Yes.
The second paragraph, my lord. Mr. Samrat Mukherjee, learned advocate, appears for the employees of the bank and says that the employees had filed an application being can such and such.
Where from you are reading?
My lord, second paragraph of page 23, my lord.
Yes.
Yes. Mr. Samrat Mukherjee, learned advocate, appears for the employees of the bank and says that the employees had filed an application being can such and such for being added as parties. That application was allowed by an order dated 19th April 2013. The only prayer of the employees is that their dues from the bank should be considered and cleared at an early date. They will be at liberty to make appropriate representation to the bank, which the bank will consider and disposed of in accordance with law. Here, liberty was given to the employees, my lord. My lord, then kindly come to the order dated 24th April 2023, my lord. It starts from page 25. The relevant portion which I am relying is, my lord, starts from page 27, my lord. Third paragraph, my lord. We are
25.
27, my lord.
Yes. Yes.
We are conscious of the fact that Reserve Bank of India had rejected the application of the bank in question for license to carry on banking business. This was way back in 2010. Now that the state government has come forward to take up the entire responsibility of reviving the bank and has admittedly repaid a number of depositors the aggregate sum of rupees such and such, we are of the view that the Reserve Bank should consider the issue of grant of banking license to the cooperative bank in question. For that purpose, purpose, fresh application, representation. These are with regard to that, my lord. Now the employee's interest comes at page 28, my lord. Second paragraph. The state government shall also ensure that the employees of the bank receives their dues which they are entitled to in accordance with law. So the petitioners at the time of closure were working, my lord. They neither terminated nor retired, my lord. Now, based on this observation and based on this direction, my lord, the representations were given, but it was not considered. Thereafter, a contempt was filed, and during pendency of that contempt, my lord, the respondent number 1 passed a reasoned order, which starts from, my lord, it starts from page 64, annexure P5, my lord, and the relevant paragraph is at 65, my lord, the ordering portion.
Yes.
Now, based upon the available records and after careful consideration of the fact and circumstances of the case obtained from the written submission of the parties, and considering that the parties have private claims against a cooperative society of which they allege to be employees, and the cooperative society being required to consider and dispose of each claim considering individual records, this department hereby directs the Ramkrishnapur Cooperative Bank Limited Employees Union to ask each and every employee to submit their individual claims with supportive documents and record duly certified by them to the State Bank within 15 days. So prior to that, their claim was carried out by the union. From here, the employees were directed to file their individual claims. Now, pursuant to such order, my lord, page 69 starts from the documents, my lord. Both the petitioner number 1 and 2 submitted their individual claims based on the last drawn salary, my lord. What they were drawing last drawn salary, based on that, up to their retirement, what could they have drawn as salary and gratuity? That claim is at page 70, my lord, of the petitioner number 1, and the petitioner number 2's claim is at page number 76. However, that was not considered. After filing of this claim, a meager amount of rupees, my lord, kitna amount payment kiya tha? Paid an amount of rupees 47,159, the petitioner number 2.
Where from you got?
My lord, that I have pleaded in my petition, my lord, page 8, paragraph 13.
Paragraph 13.
13, my lord. Only 47,159 was paid. That after deducting 1,04,431 from the gratuity amount towards a loan which he availed at the time of service, my lord. Now that amount was to be adjusted from the salary. This amount was deducted from the gratuity, my lord, and only this 47,000. However, the claim of the petitioner is much more, my lord.
No, kindly come. After filing of the claim, petition number 2 was paid rupees 47.
Yes, my lord.
After deducting itna towards the outstanding. What
Yes,
about the
my lord.
petition number 1?
Yes. Petitioner number 1 has not been paid. That is what my instruction is. Anything.
Not paid.
Not paid anything, my lord. Now, both the petitioner number 1 and 2's claim are more than that. You, my lord, kindly consider, because the entire period from 2010.
When you have been appointed?
My lord, the petitioner number 1 was appointed in 1995, and petitioner number 1 was joined in 1999, and petitioner number 2 was appointed in 1995, my lord.
And when the bank was closed?
In 2010,
1999.
Yes, my lord. Petitioner number 2, 1995. Petitioner number 1, 1999, my lord.
And bank closed
2010, my lord.
2010.
Yes.
Yes.
My lord, thereafter, we again made representation, the petitioners made, but no answers, my lord.
Who is appearing?
I'm appearing for the bank.
What is the conduct?
That means there is a committee. Actually, no proper management is there in the bank. The bank went into money. The Reserve Bank of India rejected the application for banking in the year 2010. Thereafter, liquidation order was passed. Now that liquidation order, as per law, when the liquidation order is passed, the employment of all the employees ceases. And from 2010, since the bank was not doing any business, so how there was no earning. and there was no work also to be done. So how the bank could have paid, that is one question. And second is,
What has happened to the liquidation proceeding?
Liquidation proceeding, there was a court case.
Hmm.
There was a court case, and in 2023, the state government came forward and said that we would be reviving the bank. And they gave some money also, because the idea was to save the depositors. Reserve Bank's first criteria is that the depositors should be saved. And for that, 38 crore rupees was given. And that, if I have to take my instruction, how much has been spent and how much is lying there with the bank, I have to take instruction. But so far as this petition is concerned, the status of the bank, even in the order, it is very clearly stated as the entitlement as per law. And secondly, they claim to be the bank employees, but actually whether they are bank employees or not, from 2010, or what would have been the status of those bank employees? Because 2010 the bank closed, no work, so no money to be paid. And 2012, if the liquidation order is passed and the liquidation under the law, after the liquidation order is passed, employees loses their employment status. So in this situation, bank has.
That's why I'm asking what is the stage of the what has happened in the liquidation?
Liquidation, actually when the state submitted that they would be reviving the bank, that was recorded and the court order was passed accordingly, where it was stated that
So there is no liquidation proceeding.
No, now at least on the paper there is no liquidation. Okay, but the bank is defunct.
Yes.
Bank is defunct. Bank has virtually is not functioning. Okay. Even after that order, the bank has not started functioning.
Yes.
Lordship, on behalf of the authorities, I will be taking the point of demurrer because this is a cooperative society. The name, though, states of a bank, but it is a cooperative society which was supposed to run a banking business. However, they did not get the license, and so ultimately steps were taken by the state government because there was too much of defalcation of funds. The loans were not recovered, for which reasons there were huge NPA, for which the state came forward to help the depositors. But Your Lordship, as the banking operations closed possibly since 2010, these employees were not coming to the bank or were not performing their regular duties. So we have information. And Section 102 of the Cooperative Societies Act provides for specific mechanism to resolve such kind of disputes between an employer and an employee. If they claim that they have been appointed from so and so date and they had worked for such and so and date, these are disputed questions of fact which possibly will not be this read court.
Who will decide? As per
Your Lordship, the registrar is the authority under Section 102, where the evidences can be placed.
But your additional chief secretary has given the undertaking. You
we complied, and we complied. We gave the undertaking. When the content was filed, the Honorable Division Bench was of the view as if they are the employees of the state government. Correct. Later, it was clarified to the Honorable Division Bench that they are the employees of the cooperative bank. So, Honorable Division Bench was of the desire that this communication should be passed on, and these people were ultimately allowed or given the liberty to approach the bank, and the bank disposed of their representations. Now, whether it was rightly disposed of, wrongly disposed of, whether there are disputes, possibly Your Lordship, if sees Section 102, they can file a comprehensive plaint before the registrar of cooperative societies. By placing all their evidences, the counter evidences of the bank will be considered and recent orders will be passed, and which there is again an appellate tribunal to challenge such orders.
Show me the law.
Your Lordship, Section 102.
103.
102. Settlement of disputes. May I read, Your Lordship?
Yes.
Any dispute concerning the management or business or affairs of a cooperative society other than the dispute relating to elections in the cooperative society, as and when such election is conducted by the cooperative.
Today, as on date, there is no cooperative. So bank is not there.
This is a cooperative society.
Correct. No.
It's not a bank.
Which?
A cooperative society may carry on housing business, may carry on agriculture business.
No, this is the cooperative bank.
It is not a bank. There is no license of bank. It's a cooperative society. Your Lordship, in order to run a banking business, either a company has to be formed or a cooperative society has to be formed or any other institution.
Correct.
A cooperative society was firstly registered as a cooperative society.
Correct.
Thereafter, their object was to run a banking business.
Correct.
That banking business permission they did not get from the RBI.
Correct.
But the status of cooperative society still remains.
Correct.
And they fall under the definition
They
of
are not
cooperative.
the shareholders of the cooperative. They are the employee in the
Employees,
bank.
your
not in
lordship,
the
your lordship,
society.
your lordship, kindly sees B, clause B.
Yes.
Any dispute. Firstly, let me show your lordship the definition of dispute. Section 4, subsection 25. Section 4, subsection 25. What is the definition of dispute? Dispute means any matter capable of being the subject matter of civil litigation and includes a claim in respect of any sum payable to or by a cooperative society. Now, if we come back to 102, 102 speaks of resolution of dispute by the registrar. If we come now to the clause C of the section 102, this is if a dispute is filed between the cooperative society or its board and any past board, any officer, agent or employee, or any past officer, past agent or past employee, or the nominee, heirs or legal representatives of any deceased officer or deceased employee of the cooperative society. So this falls under the definition of 102. If they file a comprehensive claim before the registrar, your lordship, and if the bank is also allowed to participate in that proceeding.
But today the bank is not there. Who will
the cooperative society? The cooperative society. Cooperative society is there.
Can't be. How the cooperative? They are not the member of the cooperative. They are not the member. See how the bank is constituted. Society members came. Members have taken the share. After the share, they have applied for the Reserve Bank of India for the license. License has been obtained. The cooperative bank started functioning.
License was not obtained. License was not.
Whatever it may be, bank has started working.
They were carrying on finance business.
Whatever it may be. So then they have employed the persons in the cooperative bank, not as a member of the society.
As an employee of the cooperative.
Not cooperative society. Bank.
Bank.
Whether the bank is coming under the society, show me.
It's a cooperative society, your lordship.
Show me the bank is coming under the society.
Your lordship. Yeah,
if the employee has been terminated, he will go to the registrar.
Your lordship, they are the employee of the cooperative society.
If the employee is suspended by the terminated by the cooperative bank, whether they go to the registrar,
they will go to their chairman.
26. I will give this so many. Though I am appeared, I had appeared, sir. Not to mislead the court. I am telling you.
Your lordship then gives a daytime. I will come with several judgments on this. Your lordship kindly gives a
That's why show me the cooperative bank is coming under the purview of the society.
It even does not fall under the Article 12, your lordship. That judgment I will also come with. Possibly.
I appreciate society will not come under the purview of the society under 26.
Even the cooperative bank will also not.
Show me the cooperative bank if the employee, there is a dispute of the employee with regard to his claim.
Your lordship, I shall come. Kindly gives a day's time. I will come with proper judgment. Your lordship. So grateful.
There is one factual error, my lord.
And you are also satisfied why you have not raised the objection before the division bench?
Yes,
Bench has disposed of the matter.
No, these points were raised,
there is a direction of the division bench.
Your lordship, the division bench only said that their rights to be protected. Then they made a representation to honorable division bench. Thereafter discharged the contempt.
Three things is to be replied by you. First is with regard to the mentality, you are telling that the cooperative bank. Second, with regard to your authority have given an undertaking to save the contempt proceedings, that yes, the employee may give the representation, they will consider by
the bank, by the cooperative society.
No, kindly come to
by the bank. By the bank. By the individual to whom service. They have kindly seize the. Let us kindly seize the.
Yes.
Maybe I am mistaken, your lordship. Kindly seize.
Kindly come to the page 65.
65.
Every employee to submit their individual claim with supportive documents and record duly certified by them, the said bank, within the 15 days.
To the bank.
Yes. Now duly certified with the bank. So today there is no bank. So if they have submitted to you, you have to certify, take the certificate from the bank, or you have to inquire from the bank. Today there is no bank. Who will certify?
Your lordship, the bank.
Sir, this type of the order I know how to save the contempt.
The name
of
of
the contempt proceeding, you came with this order and you save your skin. Now you're twisting.
Your lordship, kindly seize the name of the petitioner. Kindly seize the name of the petitioner for
maybe petitioner, but
kindly seize the not of this petition, your lordship. Kindly the order of the contempt.
Yes.
This society was registered with the name of bank. It does not itself gives them the right to run the banking business. The banking act, license has to be license as per
That's
the
why.
banking act has to be obtained to run a bank.
Correct, that's what I'm telling.
This user of name as bank, this comes down to the order as bank. But today their status is a cooperative society.
So how your state is allowed to run the bank as in the name of the cooperative society? Cooperative
That
bank.
is the bank. The RBI cancelled their license. Did not renew it. They
Banking
did not
business
renew it.
with license which was not
License
renewed.
was issued or not?
License
was
was
license. There
they
was
applied for.
My lord,
License was issued or not?
For.
read the history, my lord.
You are for the bank. I am asking one question, sir. Whether any time, any point of time, any license was issued by the Reserve Bank of India?
Application for license was pending.
Was pending, not issued.
Actually,
I am asking one question. You give the direct answer. You are the senior person. One question am I asking. Whether at any point of time Reserve Bank of India has issued the license or not. Any point of time. Pending, I am not asking. Whether any point of time any license was issued
My lord, it does not have a very straight answer, my lord.
Why?
Because when this 65, the act was this one, Banking Regulation Act came into force from 1965.
Correct.
Before that, there were cooperative societies which were doing the banking business. Now, what happened in that case? They said you apply for the license till the application.
That's why I'm asking whether after the coming into force of the regulation, whether any license was issued by the Reserve Bank of India or not.
Application license was not issued, but the license application for license was pending.
That is different thing. Pending is different thing. Issued is different thing. Having license is different thing. You were having a license for running the cooperative bank or not? Simple question. If you're not, if you want.
So far, my information goes, the license was not issued, but I will have to check up. I will check up with my clients. Make it.
So directly you tell you're not. Then you
I
why you're going here and there? It was pending. It was
I will
pending.
ask
Once
for my clients, my lord. I'm sorry.
1999 to 2010, you run the cooperative bank. You're telling that applied for, and you will run the business.
My lord, I will try to satisfy that even if the application is made, it can run as a bank. I will try to satisfy you.
Application?
Fix it on Monday. I will try to satisfy.
It's an interesting subject, Your Lordship.
That's why I'm telling.
Very checkered history. The bank has a very checkered history.
Now all the cooperative banks has a checkered history.
So grateful.
Learned counsel for the state respondent as well as the bank.
May I take Your Lordship's leave?
Yes, as well as the bank. Prays for time to take instruction. Let the matter appear on 25th November under the
Service be kept on record, my lord. Service be kept on record, my lord.
25th under the heading adjourn motion. Affidavit service be kept with the record.
I'm grateful.
Yes, next.
My lord, this is my application.
I'm for the state led by.
My lord, this is my affidavit of service. My lord, my despicable submission before your lordship is this, my lord, that the petitioner, my lord, participated in a tender proceeding. Now, my lord, a work order has been issued in favor of the petitioner. Now, for the said work, my lord, financial approval is given by the respondent authority. My lord, matter was completed, my lord, in 2020. My lord, during pendency of he made a representation, the respondent authority didn't consider to pay the remaining portion of money. My lord, March 20, they have paid 25 lakhs in favor of the petitioner. My lord, when I filed this application, my lord, then during pendency of the said application, my lord, the respondent authority paid the amount, remaining portion of amount, whatever it may be, my lord, after deduction of my lord, LW cess and my lord, GST. Now, my lordship, kindly have a look to page 9 of my application, page 8. My lord, in page 8, in my lord, prayer A, I have stated a writ and or order or orders and or direction in the nature of a writ of mandamus, commanding the respondents, their employees, agents, subordinates, and other assignees to disburse the area dues amounting rupees 9,20,374, along with 10% performance security arising out of tender number 82 of 2019-20 of such and such issued by the Executive Engineer PWD Kolkata South Division along with the statutory interest. Now, my lord, the security deposit has already been paid by the respondent. Only thing is this, my lord, that financial approval that was given by the my lord, respondent authority, that is, my lord, page 13. Lordship, kindly have a look. Page 13, my lord, the financial approval on 16th of July 2021. And my lord, first line is this: an administrative approval amounting rupees 34,51,510. My lord, only for the works as mentioned in above. So, my lord, within the financial my lord, approval, I have completed the work. But my lord, the rest of the amount, that is my lord, 9,20,000, they didn't pay.
What is
My lord,
9,20,000?
my lord, that is the remaining portion, my lord, because lordship kindly have a look to
What was the total bill?
completion certificate, page 14. Page 14.
20,000.
My lord, the total bill amount is up to date bill value, that is my lord, column 8, 34,20,374.
Correct.
My lord, so my lord, remaining I have received my lord in the year 2020 25 lakhs. Remaining portion now after deduction they have paid, and my lord, they have already paid my lord security deposit. Only claim is this, my lord, since 20 till date, that is my lord, disbursement, that is 15th of September 2025. I am claiming before your lordship, my lord, the interest portion. Lordship kindly direct them, my lord, because my lord, it is my lord.
Yes.
Lordship, according to all payment dues amount already paid, my lord.
I have already submitted.
Lordship, kindly the page
When the payment was
17.
made.
Page
Payment
17. Payment already made.
Payment my lord, 15th of September 2025, the remaining portion. After deduction all, I have nothing to say.
10th of September
2025.
25 years.
Including security deposit.
Correct.
I have nothing to say.
Correct.
But my lord, the entire interest portion I am entitled because deliberately, in spite of
Yes.
in
Whether
spite
you are ready to pay
Lordship,
the
kindly,
interest.
kindly see the page number 17.
Yes.
The representation. The last portion, we kindly request you to clear the remaining due amount of rupees 9,20,370.
Page 17.
Page 17.
Yes.
Already, according to the representation, the authority concerned already considered and payment was made.
my lord, because of delayed payment, I am entitled to the interest. I have never stated submitted before your lordship that they have
According
paid
to
the amount.
petition, there is no prayer for the interest. So at this
Prayer is there. Prayer is there.
regarding the interest portion.
I have already prayed. That is, I am my lord, prayer A, page 9.
Instruction is necessary. Instruction is necessary.
What instruction?
Yes.
Regarding the interest portion.
Whether your authority will say, yes, I will pay the interest. Your authority will say, yes, I will pay interest.
My lord.
Tell me.
According to the prayer, according to the representation, not mention the for the interest.
But madam, how the court can read court can say
Millard, that is Millard. I'm Millard submitting Millard two judgment passed by Millard Honorable Justice Shobbhashachi Bhattacharjee and Honorable Justice Millard Ajay Kumar Gupta, where Millard their lordships were pleased to direct the respondent authority to make the payment including interest. That was Millard.
Payment including interest, that is different thing.
Yes.
Once you receive the payment, how the read court by sitting in
No,
the
lordship kindly
26 jurisdiction direct to pay the interest. But
Millard,
there is no contract.
No, Millard, lordship kindly consider this. This is not Millard adjudicated at the time of hearing. During pendency, knowing fully well that they have not paid the Millard the amount, Millard during pendency of the said writ application, Millard, they have paid. Millard, today the first time matter is Millard before your lordship.
Correct.
And
payment
that's why Millard payment
satisfied.
including interest. That is my prayer.
Correct. The including interest, that was the pay.
Yes.
Now they have paid the amount to interest. How the court can now only for the interest, the writ court can pass an order for interest.
Millard, lordship kindly consider this, Millard, deliberately, Millard, they have harassed and they didn't pay within the time. Though, Millard, there's a completion certificate, financial approval, and Millard, this is the first time matter is moving before your lordship. That's why, Millard, I made a prayer. Millard, principal amount along with Millard interest, and Millard other coordinate bench also passed this audit.
The Lordship, during the receipt of the payment, no objections was made by the
petitioner has made filed the present application, praying for disbursement
of an amount of rupees 9,20,374 along with interest with 20% performance security arising out of tender number 82 of 2019-20 issued by the tender issued by the executive engineer PWD Kolkata South Division. Counsel for the petition submit that during the pendency of the suit, pendency of the writ application, the authorities have made the payment on 16th October.
September.
15th September. Made the payment on 15th of September 2022. But the authorities have not paid any interest. She submits that the work was completed in the year 2020. And since then, the petitioner is praying for release of the amount, but the authorities have not released the amount. Only on 15th of September 2025, the authorities have released the said amount. Accordingly, petitioner is entitled to get interest. Learned counsel appearing for the estate submit that as per the request made by the petitioner, the authority found that the petitioner is entitled to get an amount of 9,20,000, entitled to get the amount, and accordingly the same was released in favor of the petitioner. In the representation in which the petitioner has prayed for release the amount, the petitioner has not prayed for any interest. Thus, question of payment of interest does not arise. Had the learned counsel for the respective parties, this court finds that though the respondents have released the principal amount of rupees 9,20,000, my lord. 9,20,374.
374, my lord, after deducting
74. After deducting the
ST and LWCs.
After deducting the applicable taxes on 15th of September 2025, but the authorities have not paid the interest. Accordingly, the writ petition disposed of by directing the authorities to consider the payment of interest for delayed payment from 2020 till 2025 within a period of 4 weeks from the date of receipt of the application, and to if the petitioner is entitled to get the interest, the same may be released within a period of 2 weeks thereafter. If the respondent authorities are of the view that the petitioner is not entitled to get the interest, the reason in speaking order be passed within a 2 weeks thereafter.
Grateful, my lord. Grateful.
Period of 2 weeks thereafter.
Grateful, my lord. নাম দিয়ে দিচ্ছিস? চল, disposed of.
My husband was a freedom fighter. After commencement of 1980 scheme, he applied. On the basis of that application, my husband was favored with a pension, which you also will find the PPO at page number 40. Your Lordship have a pain to come at page number 43 for a moment.
36.
43. 43, my lord.
Yes.
My lord, column number 2 from the top, serial number 2. Details of family pension eligible for pension in the event of the death of the pensioner.
32.
43, my lord.
43. Where is the 43? Yes.
Lord, your Lordship going to see serial number 2. Details of family members eligible for pension in the event of the death of pensioner. Well, I need not show the name of the PPO holder, that is the pensioner. My husband is the pensioner, it is in his name. Well, your Lordship kindly see the handwriting. Srimati Lokhi Rani Das, second by wife. That is in the PPO, it has been mentioned that on the death of my husband, that is the pensioner, his wife, that is myself, is entitled to have the pension.
From the date following the date of.
Milord,
Sorry.
and your lordship kindly skip over to the lower portion.
Yes.
From which date he will get? From the date of the date. Following the date of the date.
The day following the death of the
Date of death of the pensioner. That is from the next date of death, I will entitled to have the pension.
What is this? This is the pension book.
Milord,
PPO order.
PPO, milord. But PPO in the name of my husband, deceased husband. My lordship kindly come to page number 44. My husband died on, milord, 22nd of February 23.
Yes.
Your lordship has seen.
Yes.
Just after, milord, the law says, if the pensioner died, what I am to do? Your lordship have a look to page number 52 for a moment.
52.
52.
Yes.
Paragraph 1.1b Roman I. Milord, has your lordship got, milord? In case of pensioner
Yes.
already drawing their pension through the public sector bank, director of accounts treasuries, pay and accounts officer, payment of family pension as indicated in the pension payment order shall be commenced by the disbursing officer on receipt of the death certificate and application for family pension in the prescribed format. So, my lord, as per this provision, on the just after the death of my husband, I am to intimate the bank, this is the death certificate of my husband, and this is my application, kindly transfer the pension in my name. Lord, your lordship kindly skip over to page number 54. On 25th of August 2023, I duly applied in the prescribed form along with necessary documents.
54.
54, my lord. 54.
Yes.
Along with all necessary documents.
Yes.
Which is required. Since then, they did nothing. Now, at page 61, the branch officer has been informed by the CPO, CPCC, CPPC, my lord, Central Pension Processing Center. Well, as it has been applied after 6 months, you advise him to apply to the Ministry of Home Affairs for pension. But this is not the law. Well, where from they are getting that? Well, I can understand. In 2014, a circular was issued to the bank in the name of guideline to the public sector bank. Well, have a look to page number 63. On the basis of this guideline, perhaps the CPPC has said so. Because I have delayed I have applied after 6 months, 2 days. I should be frank to my lord. I should not suppress anything. This is the circular, the guideline for.
Where is that circular?
Page 63, my lord. Well, I'm sorry, my lord.
Yes.
Guideline for disbursement of central pension.
Yes.
To be followed by the authorized public sector bank. But this is not a scheme. This is a guideline to the bank. In that guideline, para 5.2 at page 73 prescribed. Well, I should show everything to my lord. Whichever even against me, I will show. Because these guidelines prescribe in paragraph 5.2 that if the application be made to the bank within a period of 6 months, they will transfer the pension. If after 6 months, they will not process. They will send to the ministry. This is the guideline, provides. So whatever.
Where is that?
Page 73, paragraph 5.2. Transfer of pension to spouse stroke daughter.
What is the date of these guidelines?
6/8/2014.
It is of 14.
This is a continuation of this?
Yes, my lord.
Continuation of 62A.
My lord, I have shown, my lord,
That
Pa-
is your shown in
Page 63, I have shown the guideline, which are circulated by page 62.
Correct, that's what I'm telling. Yes. Yes, a continuation. Okay.
Yes, continuation.
Yes.
5.2.5.2.
After the death of the petitioner.
At page 73, my lord.
Yes, yes.
After the death of the pensioner, whether freedom fighter himself or his spouse, the transfer of pension to the spouse daughter will only be considered if she applies for transfer of pension within 6 months of the death. Application received after 6 months shall not be considered by the bank, but referred to the ministry. I am pausing here, my lord. If I applied after 6 months to raise, if on the basis of this circular guideline to the bank, if the bank is unable to transfer the pension, they are directed to refer the application to the ministry.
Yes.
They kept mum in the matter. But this circular, it has been held, it is neither being a corrigendum nor a guideline, is not applicable at all. I have annexed that judgment in the middle. I am coming to that. Now, your lordship, can have a look to paragraph page 83 for a moment. It starts at page 80. A judgment of this honorable court, my lord, in an identical case, it has been held that, my lord, I am placing paragraph 17 at page 83, my lord.
83.
83, page number 17.
Yes.
A perusal of the revised guideline, which have also been relied on by the division bench of Delhi Court, shows that the same, as rightly contended by learned counsel for the petitioner, were merely a guideline issued to authorize public sector banks by the Ministry of Home Affairs for disbursement of central pension. It has been rightly contended, in paragraph 18, by the petitioner that the said guideline issued subsequent to the scheme by the concerned ministry to the authorized public sector bank do not form a corrigendum or an amendment to the original pension scheme, which still remains intact. In fact, the modalities as stipulated in the said guideline can at best pertain to procedural nuance of the disbursal under the scheme and cannot affect any substantial right conferred upon a person under the scheme read in conjunction with the concerned law governed by in the field. So, my lord, it has been held that that scheme is not applicable. But that judgment has been, my lord, complied with and paid the pension. Now, I am of 85 years old lady, whose husband sacrifices the youth for the sake of our country, and on whose sacrifice we are now free. My lord, so what I am saying before lordship at this stage, my lord, your lordship kindly dispose of the matter, directing the central government to comply with their writings in the PPO to give pension from the death of my husband.
My lord, I am representing the respondent bank, my lord. My lord, here the short point is involved. Whether, my lord, this petitioner has to apply before the Ministry of Home Affairs directly, as per the directives passed by the CPPC, or, my lord, to the bank, and the bank should forward it. Now, my lord, so far the scheme is concerned, my lord, what we have seen at page 73.
73.
73.
What scheme?
73.
Yes. No, my lord, it's at page, yes, page 73. My lord, application undoubtedly, my lord, admittedly, my lord, this is beyond 6 months. So, my lord, it has to be before the Ministry of Home Affairs. That the scheme also says. I mean, the revised policy guidelines. Now, my lord, the judgment which has been referred by my learned senior friend, my lord, is, my lord, it does not deal with this issue, my lord. It deals with whether, my lord, kindly see paragraph 20, thus clause 5.2. At page 84, my lord.
Yes.
There the contention was different. The issue was different. They are nevertheless, the paragraph 20, it says that clause 5.2.2, which stipulates that the dependent pension shall be paid from the date of the application by the spouse, daughter, and not from the date of death of the pensioner, is not so sacrosanct as sought to be projected by the respondent authorities. So date was disputed, whether from the date of death or from the date of application. This kind of issues were discussed elaborately in this judgment. But this judgment never dealt with the fact whether beyond 6 months, if an application is filed, whether it has to be filed to the bank, concerned bank or the branch, or directly to the Minister of Home Affairs. So this judgment doesn't have any application in the present writ petition, my lord. And my lord, whenever we have received this application, we have, without any further delay, we have forwarded it to the CPPC for their consideration. And while the CPPC now directed us, the branch manager, that it has to be before the Minister of Home Affairs. So this is the present scenario.
So why you are not send the matter directly to the ministry?
My lord, being a branch, my lord, we are bound by the order passed by the CPPC. Now, my lord, the CPPC has directed us that
So you could have been informed the CP, what is the guideline says? What is the guideline says?
At page 52.
When you come to the guidelines 52,
last paragraph.
Because under the guidelines there is no CPCPC.
No, my lord, this guideline, my lord, did not say.
92.
Only 52.
Yes. It says that in case of pensioners already drawing their pension through the public sector bank.
No, not that. You come to this here. Page 73.
73.
Transfer of the pension. Can you come to the you have
5.2.
taken records of this? Can you see that 5.2?
Yes, my lord, I have followed that, my lord. Then, my lord, 5.2.1 says the procedure for submitting application shall be as under.
That is different thing. If the name of the spouse already mentioned in the original sanction letter, the ministry then application be made on the plain paper. That is not here. Admittedly, she is the nominee.
Yes.
In the PPO. Admittedly, the pensioner died. Admittedly, he was the freedom fighter.
Right.
He was getting the pension. Not died. He has applied. Admittedly, also he has filed. He has submitted an application after the 6 months. So he has submitted. You have stated that it is 6 months. But 6 months, kindly come to the 5.2.
Yes.
Within 6 months from the date of application received after 6 months shall not be considered by the bank, but referred to the ministry.
Yes.
Referred to the ministry. You could have been referred to the ministry. So I will direct.
Yes, my lord.
I am setting aside that order. Directing the bank in terms of 5.2, you referred the matter to the ministry. And if the ministry received any reference letter from the bank, the ministry.
After filing of the writ application, some development has been made. Well, I have to be then. Because the POW has written to the Minister of Home Affairs, stating the entire facts.
Who has given this?
He is the respondent of the 4 hearing. Here, after getting the writ application, have to everybody, it has informed the Government of India Home Department that this matter is to be dealt with by the ministry. So deal it. And on the other hand, the last page, your lordship can see, the state government requested the bank. He applied on such and such day. You kindly proceed with the matter. Nothing has been done. So what I am on, not admittedly, I am entitled to have the pension. As per the PPO, issued by the Government of India. So let the writ application be disposed of, directing the Government of India to act on the basis of the writing on the PPO. On the basis of the application submitted before the bank.
The subject matter of the case relates to grant of family pension in the name of spouse of the freedom. Eligibility, whether the spouse is eligible or not, to be decided by the ministry, by your ministry. Which ministry?
Entire facts has been written.
Ministry of the Freedom Fighter, Home Ministry, Freedom Fighter Division, 2nd floor. Okay, I will direct you to refer the matter to the ministry.
It has already been referred. It has already with the Minister of Home.
No. Paras, my learned friend.
They are telling that it is only receipt of this writ application to save their skin.
Because I am worried, especially for the reasons. My client is on the deathbed.
Correct, correct. That's why I'm telling immediately within a week from the date of receipt of this order, refer the matter to the ministry in terms of this letter. And if the ministry receives any reference from the bank with regard to the release of the fund, ministry will consider and pass necessary order
Within certain time.
within 4 weeks. Within 4 weeks.
As your lordship, I can't never
Ministry
bargain.
is there.
I have placed my client is on the deathbed. That's much I can.
Not consider release. Pension is a freedom fighter.
Or
I will pass a mandatory order.
My lord will remember that case delivered by my lord, sitting in court number 11. That was upheld by the division bench. That was challenged to the Supreme Court. Supreme Court also affirmed my lord's judgment.
Thank you.
I could not get chance to inform my lord.
Thank you. The petitioner has filed
Our entertainment is here.
challenging
The release pension.
the order. Challenging the communication dated 7/11/2023 issued by the branch manager,
payment hope.
Centralized Pension Processing Center, Chennai, wherein it was informed to the petitioner that the petitioner has applied for grant of family pension after 6 months from the date of death of the pensioner, and pension can be sanctioned only by the Ministry of Home Affairs, New Delhi, and advise the petitioner to apply for the family pension to Ministry of Home Affairs, New Delhi. Counsel for the petitioner submit that the husband of the petitioner was the pensioner, and in the pension payment order, the name of the petitioner is recorded as nominee, being the wife of the pensioner. The pensioner died on 27th of February 2023. After the death of the pensioner, the petitioner being the wife had applied before the bank for release of the family pension on account of the death of her husband. But instead of release of the family pension, the impugn communication has been made. The petitioner has brought the attention of this court to the guidelines for disbursement of central Samman pension followed by the authorized public sector's bank, issued by the Ministry of Home Affairs, FFR division, being number 45/03/2014-FF within bracket P. In the said guidelines in the said guidelines 5.2 reads as follows. Record this. Petitioner submitted that though the petitioner has applied for grant of family pension after the period of 6 months, but the bank ought to have forwarded the case of the petitioner to the concerned ministry for release of the family pension, but instead of referring the matter to the ministry for taking decision, has directed the petitioner to apply before the ministry, which is not permissible under law. Per contra, an advocate appearing for the bank submits that admittedly the petitioner has submitted an application after the period of 6 months, and as such the bank has no authority to release the pension. Thus the bank has informed the petitioner to apply before the ministry, and if the ministry will be taken decision, the bank will release the pension, if in terms of the order, if any, passed by the ministry. The learned counsel appearing for the Union of India submits that the ministry has not received any
any request either from the bank or from the petitioner, and as such, there is no occasion to deal with the matter for release of the pension. Okay, then the Council for the Union of India submits that the matter requires consideration. If the matter will come to the ministry will look into the matter and pass appropriate order. I mean, take appropriate decision. Consider the submission made by the council for the respective parties. It is not in dispute that the husband of the petitioner was not the pensioner. It is also not the dispute that the petitioner is the wife of the pensioner. The only dispute that the wife has submitted, the petitioner being the wife of the pensioner, has submitted an application after the period of 6 months, but the bank, instead of referring the matter to the concerned ministry, has directed the petitioner to apply before the ministry directly for release of the pension. The said observation, this court has considered the guidelines 5.2, wherein it is categorically mentioned that if the application received after 6 months shall not be considered by the bank but referred to the ministry, then the ministry shall take a view whether to allow the dependent pension or not, or whether any arrears is to be paid. Full stop. At the time of hearing, the Learned Counsel for the petitioner has also handed over a communication dated 27th of August 2025, issued by the senior officer of legal cell of the Ministry of Finance, wherein it reveals that the eligibility, whether the spouse is eligible for family pension or not, is to be decided by the ministry / department. Consider the above. This court find that this court find that no purpose should be served by keeping the writ petition pending. Accordingly, the writ petition is disposed of by directing the bank. Which bank?
Indian Bank.
Record number কত বলো? 8 and 9 Miller.
By directing
8 and 9 Miller.
By directing the chief manager, Indian Bank, Centralized Pension Processing Center, Chennai,
as well as 9 because application is lying
as well as the branch manager, Indian Bank, Sitalpur branch, within bracket S-727, post 727, are directed to refer the application of the petitioner for grant of pension to the
Ministry of Home Affairs,
to the Ministry of Home Affairs, Freedom Fighter Division, second floor, NDCC Roman 2 building, Jai Singh Road, New Delhi.
Yes, 2 and 3 Miller. 3 or 3, only 3 is sufficient. Under secretary.
Yes,
Who is the
that is the respondent number 2. 2. Within a period of 2 weeks from the date of the receipt of this order. Full stop. If the ministry received the order,
with a copy to us, so that we can pursue
with the intimation to the petitioner, and if the ministry received the application from the bank for the pension of the petitioner, for release of the pension of the petitioner, the ministry shall consider and pass necessary order within a period of 4 weeks from the date of the receipt of the application from the bank, and to communicate the same to the petitioner within a period of 2 weeks thereafter.
And my lord, for this delay, am I not entitled to have cost from the bank? Well, I am asking this myself.
Full stop.
But it is up to my lord, my lord.
PA number 7 disposed of.
Deep obligation.
Affidavit of service we kept with the record. Yes, next.
Yes. My lord, you to open the brief, kindly hear me 2 minutes time.
My lord, at the outset, my lord, there's a direction earlier to file a report.
No report on behalf of the West Bengal State Tax report is filed.
Yes, no, my lord, I'm seeking, my lord, 1 week extension, my lord. It will be, my lord, affirmed, my lord, by Monday. Only 1 week extension. My lord, this is required because my landlord, my land estimate place it, my lord, this report is required.
What happened today? My land, the licensing company installed the electricity line to the private respondent's house over my plot of the land without any approval, without having any consent from the landowner. Now, I raised this objection before the authority because this is my land. I cannot construct the house over this land. Raise this objection. No, my lord, our High Court judgment clearly postulates that the line cannot be installed without having consent over the one of the land. Now, my lord, Electricity Act also provides. Correct. Section 68. You cannot keep this connection over the part of the land of the landowner without having any consent and without approval of the government. Now, only I am praying, my lord, let him make an inquiry. Make an inquiry, and if also there is an alternative passage also. And I have also pleaded, and I have given this map. And let him make an inquiry. Inquiry, if this actually it is found that this line has been installed unauthorized, let it be shifted to the other.
Okay, let us file the report.
Well, only one.
When you file, tell me.
Well, kindly extend, my lord, 10 days, my lord, in the, my lord, I will file. My lord, by next week, only one thing, my lord, private respondents are also there, my lord, whose line, my lord, they are not happy. Let a notice be served because they are the worst affected person.
I have something of it. They didn't appear. So what can be done?
No, return to sender. It is not served, sir. Return to sender. Return to sender. Your affidavit of service.
Return to sender.
Yes, return to sender. It was written to you.
No, not yet.
It is there. Can you see? Return to sender. Return to sender. Return to sender. Okay, you inform this date and this order also to the other party, the counsel for the state respondent.
My lord, distribution company.
Distribution company. Press for extension of time to file report. Report. Let the report be filed by 13, by 24th, after serving the copy to the London Council for the petitioner. The petitioner is liberty to file exception, if any, within a week. Within a week. List the matter on 4th of December 2025. The petition is directed to inform the next date of hearing to the other respondents and to file affidavit, fresh affidavit of service on the returnable date. And this is the matter under the heading adjourn motion.
For the petition. My lord, petitioner, the my lord, registered valuer, my lord, engaged with my lord, the several banks for the purpose of valuation of the my lord, immovable properties. So, my lord, petitioner was engaged by the federal bank also, and my lord, the federal bank entrusted several works to the petitioner.
Engaged by the
federal bank.
Federal bank.
My lord,
2 and 3.
Federal bank has been represented. My lord, then my lord, after the my lord, valuation of a property, after 2 years, there was a show cause notice that there was any discrepancy about the property and the valuation. And there was a show cause notice was there, my lord. I have annexed. Then, my lord, I have replied a detailed reply to the show cause notice. My lord, I will place one by one document, my lord, on the crux of the matter first, my lord. My lord, I will, my lord, file a detailed reply to that. Then, my lord, they passed a one-line order that one reply has not been satisfied. And my lord, debarred from their panel. My lord, I am today, my lord, it is their prerogative. They will, my lord, continue with me with my panel with the cards or not with the cards, my lord, that is with them, my lord. What they did, my lord, they sent my name to the my lord, Indian Bank Association for their caution list. And if my lord, it is the my lord, Reserve Bank of India, my lord,
created the Indian Bank Association, and my lord, if my name is appeared in the my lord, the caution list, then no bank can entrusted me any work. So, my lord, they have to, my lord, adhere the.
What is the allegation?
The allegation is the, my lord, the discrepancy of a valuation of a old building. They said the old building, the discrepancy after, my lord, the 2.5 years. Man, I am only, my lord, the value after the 2.5 years of this, my lord, this happened. Your lordship knows, my lord, these facts, my lord, after the, my lord, these got the, my lord, non-performing, then, my lord, these things, and my lord, it is also a fact. I cannot prove, but it is also a fact. After me, another year, my lord, another value has, my lord, valued that property. When every year, your lordship knows, man, these are all, my lord, cash credit loans, my lord. So, my lord, Indian Bank Association, my lord, framed a procedure that, my lord, first, my lord, the show cause notice, then, my lord, they have to afford me an opportunity of hearing, and, my lord, then they can send my name to the, my lord, Indian Bank Association. And no opportunity of hearing was, my lord, granted to me. That is the, my lord, first. And, my lord,
So cause notice can be said to be an opportunity.
My lord, that is 1991 Supreme Court. Your lordship knows. After that, my lord, in, my lord, other matters also, Supreme Court, my lord, dealt with. Now, my lord, the opportunity of hearing has been, my lord, in GST matters and all these matters, my lord. And I argue for the state, my lord, once, my lord, that this 1991 judgment, my lord, show cause notice will suffice. But, my lord, Supreme Court also held, my lord, now, my lord, the opportunity of hearing must be given for the, my lord, blacklisting of the, my lord, of a person. I am not being, my lord, blacklisted. So, no opportunity of hearing. I cannot place the, my lord, the judgment passed by the, my lord, Madras High Court, Odisha High Court, and the, my lord, Calcutta High Court on the similar matters, my lord. That, my lord, it can't be. So, my lord, and another thing, my lord, bank cannot, my lord, send my name, my lord, the procedure laid down by the IBA says there must be a conflict resolution committee. One of the member of the resolution committee should have been a reputed valuer from a valuer institute. My lord, neither of the communication from the bank shows that the conflict resolution committee has been set up to, my lord, to decide my case. To decide my case, my lord, because, my lord, my valuation can only be, my lord, sufficiently and, my lord, adequately, my lord, judged by another, my reputed valuer. I am a professional, my lord. My professionalism is a right or wrong. Another, my lord, senior to me or, my lord, a reputed valuer can, my lord. But, my lord, conflict resolution committee, my lord, may I place the, my lord, the policy standard and procedure of real estate by the Indian Bank Association. Those, my lord, conflict resolution committee has not decided this, my lord. These are my 2 points, my lord. The first point is, my lord, no opportunity affording my opportunity of hearing, and, my lord, could have been so, my lord, if, my lord, opportunity of hearing given to me, I can place that there is no conflict of resolution committee. Or, my lord, any valuer to engage them to, my lord, revalue my property or the reputed valuation valuer or one of valuation institute valuers, your lordship knows, my lord, so that I can be judged properly. My lord, a bank manager cannot judge me, my lord. I am a professional. That is the problem, my crux of the matter, my lord. My lord, kindly take the, my lord, the impugned order once.
Can it be decided because without affidavit?
Probably not, my lord, because this is an old valuation. Second, my lord, there are certain factors, my lord. After the Central Bank of India Prabha Devi judgment, my lord knows that we have all been cautioned to be very careful about valuation, legal opinion in respect of properties. Because, my lord, once a property is valued at 2 crores, and then I put it up for sale at 1 crore, there are a lot of explanations, my lord. Not only that, stays are granted. So, my lord, that's the reason why a whole lot of caution is being exercised now. And, my lord, there are glaring discrepancies which he himself has admitted in his reply. So, my lord, if we'll give a short time, my lord, I'll come back with his my lord, report. And the report called for from another valuer, which would show the discrepancy.
My lord, may I place the 1 page of their, my lord, order? If that is the, my lord, satisfaction, my lord, I will do out the court. My lord, page 24. Page 24.
Yes.
My lord, Bank's Journal Office, Kolkata, White Sajan sir had sought for explanation in the matter of valuation report submitted by you in the loan account of such and such. You are required to furnish your explanation in the matter. Accordingly, White letter Sajan, you had submitted your explanation. Competent authority, after considering the reply submitted to you, found that the explanation submitted by you is not satisfactory. The competent has decided to include your name in the caution list of IBA. My lord, only, my lord, no objective satisfaction, no, my lord, subjective satisfaction also, nothing. I have explained, my lord. that, my lord, this valuation has been tallied with the government valuation. My explanation is, my lord, at my lord, page 20. And my lord, I have explained with a chart of the valuation, my lord. That, my lord, how, and my lord, my report, that is with them. My lord, my report also, my lord, can show, my lord, that, my lord, those discrepancies, and my lord, why this modus of valuation has been, my lord, yes. The modus of valuation, you will also know there are modus of valuation, but this modus of valuation, my lord, the valuer has been, my lord, because of that, my lord, that also, my lord, pointed out with the valuation report, my lord. And, my lord, I am today, my lord, before your lordship for the, my lord, violation of natural justice. My lord, they must give me an effort, my lord, giving me an opportunity of hearing once, my lord. And, my lord, by the appropriate committee. I can show
Where
the,
the
my lord,
committee? Where do you find that
Yes,
committee for
my lord.
deciding the issue?
Yes, my lord. My lord, Justice Bhattacharya in another judgment, my lord, recognized this committee, and my lord said, my
That's
lord,
why, show me, show me.
yes, my lord.
Committee so that then it can be.
My lord, this is 1.4. This is first, my lord, the opportunity of hearing has to be given. .4 is the, my lord, opportunity of hearing, and then, my lord, kindly come page 68, my lord, page pagination is at the bottom. Page 68.
Yes.
Page 68, pagination at the bottom, my lord. The procedure for conflict resolution. My lord, got it?
Yes, yes.
My lord, there are bound to be variety of conflicts when hundreds of valuers are impaneled by various banks and housing finance institutions across the country. In every bank, HIFA, there shall be a bank valuation conflict resolution committee for addressing all conflicts and arriving at an amicable solution. The composition of the committee shall be decided by the respective banks and shall include representative from professional valuer association, independent reputable valuers. In case of any misconduct by an valuer, the bank or housing finance institution shall have prerogative to recommend removal of the valuer from the panel. The steps involved in the process will be as given under. On the issue of show cause notice, then, my lord, hearing. The valuer shall be given an opportunity to be heard.
Yes, madam, have you considered this?
I have, my lord, but oral hearing was not given. But, my lord, if I could, that would be taking, my lord, through the entire petition. But
And your application also, your impugn order also.
agreed, my lord. Will kindly see the show cause notice once and see the details that have been given there.
That show cause notice, okay. Yes,
Given there.
Yes, submitted.
And his reply, my lord, does not take into consideration what had happened, my lord. 5 flats in a building which was incomplete for
That's
18
correct.
years.
You could have been given this, or where is the person?
It was there in the show cause notice, not reflected in the order.
Then
correct. I would agree
order
to that.
is the main. So cause
But, my
notice
lord, here
I am setting aside remanding the back to you, and you consider in terms of this
Very well. Very well.
personal hearing.
Very well, ma'am.
Follow the procedure as per these guidelines.
I'm bow down to your lordship.
Very well, my lord.
That will be better.
Yes, my lord. But my lord will give me 4 weeks time because the
4 weeks, 6 weeks,
committee
you take
has.
whatever.
No,
It is up
but
to
then it will never happen, my lord.
But I am
The-
waiting, my lord, I will wait, my lord.
My lord, only thing is, my lord, that committee would then be formed by then.
The petitioner has challenged. The petitioner has filed the present application challenging the communication dated 11th of August 2025 issued by the Deputy Vice President, Vigilance Department of Federal Bank, wherein the explanation submitted explanation submitted by the petitioner to the show cause notice issued by the respondent number 2.
My lord, 2.
Respondent number 2.
2 was rejected.
Respondent number 3 has given, my lord.
It's the bank actually, my lord. So
By
it
the
should be 2.
By the Federal Bank.
Yes.
By the Federal Bank. has been rejected, and the bank has decided to include the name of the petitioner in the caution list of IBA. Accordingly, the bank has delisted the name of the petitioner from the approved list of third-party entities of the bank and have also included the name of the petitioner in the caution list maintained by the IBA. Full stop. The counsel for the petitioner submits that though the bank has issued the so-cause notice and the petitioner has submitted a detailed reply to the so-cause notice, but by a communication dated 11th of August 2025, the bank, without assigning any reason, in one line, has stated that these explanations submitted by the petitioner is not satisfactory, and as such, the impugned communication is without any reason and is required to be quashed. I further draw the attention of this court to the guidelines, to the handbook on policy, standards and procedures for real estate valuation by the bank and HFIs in India, and he has draw the attention of clause 1.4 of the said guidelines, wherein it is mentioned that the procedure to be followed by the bank housing finance institution shall comprising of the following steps: semicolon, issue of so-cause notice, hearing and appropriate action, including removal from the panel for a period of 5 years if charges are found serious. He has further relied upon clause 3.4 of the said guidelines with respect of procedure for conflict resolution, wherein the procedure has been mentioned and what procedure is to be followed has been prescribed. He submits that the bank, while issuing the order dated 11th of August 2025, has not followed the procedure and has not given any opportunity of hearing to the petitioner, and without assigning any reason has passed the impugned order. Learned counsel appearing for the bank submits that a detailed so-cause notice has been issued to the petitioner and the petitioner has submitted the reply. The bank has considered the reply to the so-cause notice wherein the details has been provided, and as such the bank has found that the reply submitted by the petitioner is not satisfactory. Accordingly, appropriate decision has been taken for removal of the name of the petitioner, delisted the name of the petitioner from the approved list of the third-party entities of the bank, and have also included the name of the petitioner in the caution list. Full stop. At the London full stop, London counsel for the bank submit that there is no, the bank has not committed any at the land at the Learned Counsel for the respective parties peruse the materials on recall. The bank has issued the notice to the petitioner on 6th of May 2025. On receipt of the so-cause notice, the petitioner has submitted the detailed reply on 19th of May 2025. The bank has considered the representation and passed the impugned order dated 11th August 2025. This court find passed the impugned order. By the said impugned order,
that communication space 24.
Yes, by the said impugned order, the bank has decided to include the name of the petitioner in the caution list of the IPA and also delisted the name of the petitioner from the approved list of the third-party entities of the bank, and have also included the name of the petitioner in the caution list maintained by the IPA. As per the guidelines As per the handbook on the policy, standards and procedure for real estate valuation by the banks and HFIS in India, if the bank intend to remove the valuer, the following procedure is to be followed. Number one, issuance of so-called notice, hearing, then appropriate order. As per clause 3.5, 3.4, if the bank has to follow the following procedure: issuance of the so-called notice, hearing, and deliberation by the committee, and after the deliberation, appropriate order can be passed. In the present case, though the so-called notice has been issued, but no personal hearing has been given, even no committee was constituted to deliberate, to consider the representation and to consider the reply submitted by the petitioner to the so-called notice. Simply on receipt of the reply of the so-called notice, the bank has found that this reply is not satisfactory and passed the impugn order. Considering the above, this court finds that the bank has not followed the procedure before passing the impugn order dated 11th August 2025. Accordingly, the impugn order dated 11th August 2025 is set aside at cost and remand the matter back to the bank. Who is the competent authority?
My lord, should be the vigilance, my lord, the vigilance department who's issued this order. My lord will direct them, and then they'll form a committee and then do it. My lord, the deputy vice president, vigilance
Federal
department.
Bank, Reserve Bank of India. You have not made a party.
Respondent number 3 is the deputy vice president, Kolkata Zonal Office.
They are not the same person, my lord. It would be the vigilance department probably.
To the respondent number 3.
My lord will come to page 24 once. My lord will see it was issued by the vigilance department. So my lord would direct the vigilance department.
Demanded the matter back to the vigilance department of the Federal Bank to consideration of the representation and consideration of the so-called reply submitted by the petitioner after giving an opportunity of hearing in terms of the procedure prescribed under clause 1.4 and 3.4 of the Handbook on Policy, Standards and Procedures for Real Estate Valuation by Banks and HFIs in India within a period of
4 weeks.
4 weeks from the date of receipt of the copy of this order.
Yes, ma'am.
If the full stop copy of the order and to pass appropriate order. क्या बोला? Consider the case, na? So direct to consider case of the petition and to pass appropriate pass reason in speaking order and to communicate the same to the petitioner within a week thereafter. WP is disposed of. Yes.
Lordship, I appear for the petitioner in the matter. Lordship, I beg to appear online in the matter, Lordship, since I am slightly indisposed. Lordship, can I place my matter?
Lordship.
Lordship, the affidavit of service would be handed over by my learned friend who's there in the court.
Yes.
Yes, Lordship. Lordship, in this matter, the petitioner is a registered government contractor who was allotted 3 works by the respondent numbers 5 and 7 in the matter, Lordship, who was serving as the senior DME of the Howrah Division of Eastern Railways back then in 2023 of July, Lordship. Now, they had allotted 3 works. Your Lordship will find it in page number 3 of my writ application, paragraph number 3. In July 2023, the petitioner was verbally allotted 3 distinct works by the officers of Howrah Division Eastern Railway. 1. Manufacturing of RCC garden benches. 2. Shifting of meter gauge coach from Howrah goods to Rail Museum. And 3. Furnishing of the same meter gauge coach at the site, Lordship.
Yes.
Now, all these three works that were allotted to the petitioner by the respondent numbers 5 and 7, Lordship, they were given verbally, and a promise was made that post completion of such work, the formal work orders would be issued to the petitioner, and therein the overdue payments would be made.
Yes.
Now, Your Lordship, the payments, when concerning to the work, Lordship, the works were to be completed by 16/11/2023. Now, the petitioner had completed the first two sets of work well within the time, but with respect to the third set of work, Lordship, which is furnishing of the railway coaches, the petitioner was asked to involve into indirect subcontracting because the work would be then speeded up for that reason. Now, the petitioner in the matter, Lordship, who was committed to the lawful conduct, did not want to involve into indirect subcontracting by involving a third party into the matter, Lordship, and therefore denied on doing so. There was a conflict of interest which had arisen over here, Lordship, and therein the petitioner was subjected to severe humiliation, and also threats were issued against him, Lordship. The work order, which was given out verbally with respect to the work number 3, that was also withdrawn abruptly from the petitioner, Lordship. Now, the petitioner, having no resort left, had approached the respondent number 4 in the matter, who was back then the ADRM of the Eastern Railways, who behaved even more antagonistically towards the petitioner, for which the petitioner had to again knock the doors of the respondent number 5 in the matter. And this time, the the respondent number 5, Lordship, had ensured that the work orders would be issued without any further ado. And the work orders, Lordship, with respect to the work that was completed, was issued only with respect to work number 1. Lordship will find the formal work order that was issued.
So what you have prayed for, direction for issuance of the work order?
Yes, Lordship, issuance of work
disbursement of
orders
the
and
payment.
payments therein, because
Yes,
there were
this was the
overdues.
Yes, Lordship, we have for the respondent.
Yes.
Lordship, but it is not maintainable because the petitioner himself agreed and admitted that there is no work order, no contract, no agreement, or any sort of communication which establishes his rights. Actually, as per practice and railway rules, no railway work can be initiated without any work order from the appropriate authority. So that the allegation is completely baseless and we deny it.
Okay, come tomorrow.
Lordship will kindly look at my application.
My audience.
Kindly see.
Come tomorrow. Fix tomorrow.
Lordship.
For the petition has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow.
Grateful, Lordship.
Yes, next.
Mention called Viranjan. No, it's the mention.
Yes.
My lord, may I be permitted to mention upon notice, my lord, item number 83 of my lord's list today, my lord, the interim
number
83. My lord, the interim order is expiring. My lord, this is that.
Who is afraid?
Yes.
Lordship, I'm appearing on behalf of respondent number 5 and 6.
It's only because
there was extensive hearing of the matter, Lordship.
Yes.
May the matter.
It.
No, Lordship.
No, my lord, kindly do not do that.
May
My
it
lord,
be fixed for hearing, Lordship, because otherwise it's very low in the list and we won't get a turn, Lordship, because time is very limited.
I'm acting in behalf of respondent 9. Lordship, upon instruction, I am submitting before Lordship that all the shares were already disposed of by the
This hearing is not being heard.
That is the case.
The injunction is not upon us, Your Lordship, because the injunction that was passed the earlier occasion is not effective on us.
So
whatever, if it's not effective, not effective.
It is very,
If they will file an application for contempt, then
it is very much effective on us, Lordship. Kindly fix it for hearing.
Item number 83. Counsel for the plaintiff.
Okay,
Press for extension of interim order. Counsel for the respondent Press for fixing a specific date and time so the matter can be heard on hearing. Had the counsel for the this interim order is extended. ये कौन सी कोई डेट है क्या? दो डेट दे दो, दो डेट दे दो.
What has she put?
एक दिन छोड़ के एक दिन
तो mentioning note जरा तुम ही भेज.
एक दिन दो, फिर एक दिन छोड़ के एक दिन दो. तुम बोल रहे?
No.
25 वो तो ऑलरेडी फिक्स है ना. दिसंबर में देखो. 3 and 4 है.
Right. Yes. My lord is dictating orders. You are disturbing the court.
2nd May, 2nd December and 5th December
Second May.
at 3:30.
Grateful. My lord, 5th December, my lord, kindly. 2nd December is all right. My lord, after 2nd December, my lord, some other date. My
And
lord,
8th
kindly.
December,
8th December.
2nd December and 8th December at 3:30.
Grateful.
The interim order is extended till 10th of December 2024 until further order. Which
I'm grateful, man. Grateful, my lord.
Mention an execution case in which your lordship was pleased to direct the Reserve Bank of India. This was an order dated 28th of October 2025. Direction was given upon the Reserve Bank of India to attach and debit the amount in favor of the decree holder. However, lordship, in the order, and typographical error has crept in. In place of Reserve Bank of India, judgment debtor has been written. Lordship, may this be carried out? I have indicated in pencil, lordship, the
एक काम करो, so कल to be mentioned में correction में रख दो.
lordship, may it appear on Monday as
Monday to correct.
3:30. Great.
Yes, next.
This matter has come as mine since, my lord.
Yes.
Yesterday, this matter was mentioned, my lord. So I am the contemner number 8, my lord. I have complied with the directions of your lordship, my lord. There are 2 orders, my lord. May I hand over the 2 orders, Archie? And I have also filed the compliance report, my lord.
Yes.
Lord, so I have, my lord, I have complied with the directions of your lordship, my lord. Now the warrant of arrest has been issued against my client, my lord.
So who's for the petitioner?
My lord, I appear for the petitioner in this matter. Your lordship will recall, my lords, that passed an interim order dated 3rd May 2024, directing status quo be maintained of the directorship of the company. Your lordship will recall this that matter wherein wrongfully.
Just tell me what.
Yes.
What is,
Now, my lords,
warrant has not been executed.
yeah, no. So the
You
warrant.
take steps.
I have taken requisite steps.
You've taken steps,
Yes.
but the warrant has because Bardhaman police has not submitted report, and the Bhawanipur, one of the defendant, Bardhaman police has not submitted the report. Yes. All the matter warrant has been sent to the Bardhaman, but no report has been received.
My lord.
So what can be done?
My lords, so far as there are altogether 10 contemners that are involved, my lords. Contemner number 8, that is the ROC, they filed their compliance
Yes,
report
I
long
will
back.
pass approval.
Yes.
Aside the what about
And
now you see the report, you take steps.
we'll take requisite steps, my lords. Also one thing, your lordships had passed an order for issuance of warrant against respondent number 10 back in 2024, my lords.
Correct.
Over a year has been passed. There's a report that is coming from the SP of Jamui which states that we've not been able to ascertain the whereabouts of this
Correct.
gentleman here. And
Now,
he had
thereafter 1, 2, 4 to 7 and 9 and 10.
My
You
lord.
have submitted the report. You
Yes.
submitted the requisites.
Yes.
Then it has been sent to the Bardhaman Sardar police station. Correct. Bardhaman Sardar police station. Now the police they have received, but no report has been received by this court.
They've entered appearance, your lordship will appreciate. They've
entered
changed
appearance.
their advocates twice.
Release. What can be done? That is why tomorrow the other advocate will come, they will release, then they will go.
That's how they've been conducting the affairs all this while.
Now the registrar has been transferred to
The
Guwahati, my lord.
Deputy Surveyor of Calcutta has submitted the report wherein it reveals that the warrant has been forwarded to the concerned police station, but no report has yet been received. Full stop. Learned Counsel appearing for the alleged content number 8 submits that the alleged content number 8 has been complied with the order, but inadvertently on the which date?
Order dated 12.
Huh?
My lord, the
On
warrant was issued on 12th September, my lord.
On 12 September 2025,
The
the Learned Counsel for the alleged content number 1 could not appear before this court, and according
12 September
again the warrant has been
2025.
This court find that the alleged judgment number 8 has already complied with the order. Accordingly, the warrant issued against the alleged content number 1 is recalled. Content number is recalled. 8 is recalled.
It is also
recalled. I have recalled.
Recalled.
Recalled. Okay. Let the matter.
I
have recalled. Let the matter appear on 27.
No, just one small submission. So far as the respondent contemnant number 10 is concerned, what's now really happened is that the address that we knew was in Bihar, he is not to be found. The report says that he is now staying in Kolkata. Now we do not know the address of Kolkata, my lord.
The petition is given liberty to go through the report submitted by the Deputy Sheriff and take appropriate steps.
My lord, the address is not indicated.
Go through the report
Right,
and take appropriate steps. Yes. Next.
Yes, back to
Yes.
Your Lordship kindly sees the judgment at paragraph 15.
Yes.
As per the ledger maintained by the plaintiff as on September 29, an amount of 62,84,029. And then in the next paragraph, in the ordering portion, 628, the 4 has gone missing.
Correct. So that is the only correction.
That is the only correction. In paragraph 16, it is there in 2 places.
Okay, okay.
And paragraph 18.
The matter is research to be mentioned for correction of the judgment dated 11/11/2025. Learned Counsel for the plaintiff draw the attention of this court to the paragraph 16 and paragraph 18, wherein the amount has been recorded as 6,28,029 instead of 62,84,029. In view of the submission made by the counsel for the peruse the record in paragraph 16 and paragraph 18, the amount shall be read as 62,84,029 instead of 6,28,029. This order
may be incorporated.
Yes, this correction may be incorporated in the judgment dated 11 November. Okay. Yes, next.
Deputy
appear on behalf of the petitioner in the election petition.
All sides, man.
See, nowadays the election commission all the way.
But insofar as the main matter is concerned, Madam, we had already filed our written notes. After expiry of the period to file, they came up with 2 applications. Madam had heard us also, Madam, at length. There was an opportunity to file affidavits. Affidavits have been exchanged. They have filed it beyond time, though. Yesterday, Madam, at around, in fact, tonight today at 5 minutes past 12, Madam, one of the replies was served upon us, Madam, in the morning. Madam, I had taken a point of maintainability, Madam. Madam had kept that open, Madam.
I will leave it on your lordship. If he wants to argue, he can argue on maintainability. Whichever your lordship wants. He is taking a point of maintainability of my application. So, my lord, then he will start, let him start.
But the statute is.
Which application number?
My lord, this is GA4, my lord.
Who is the GA3? Who has filed GA3? GA3 filed by? Yes, who are you? Yes.
My lord, I was no one to the suit. I believe he was someone to the suit initially. That's the difference, I think.
You are?
I am today, my lord.
You are the villager?
Yes, my lord. I'm the electorate from that locality.
Correct.
Made some interloper.
Sorry?
Yes.
My lord, a few dates, my lord, that will be relevant. Pursuant to my lord's order, the Gazette was published on 8th of September 2025.
Yes.
And the law contemplates.
Gazette dated?
Gazette was my lord on 8/9/2025.
Yes.
The law contemplates, my lord, Section 116 of the Representation of People Act, read with Rule 42 of the Election Rules of Calcutta High Court, that contemplates that within 14 days of publication in the Gazette, one has to apply.
Yes.
To be substituted. So, my lord, in my calculation, the period expired on 22/9/2025. 21/9 was a Sunday, so effectively 22nd of September.
Yes.
But both the petitions are filed on 24/9/2025, that is on the 17th day. I mean, so far as the Representation of People's Act is concerned, my lord, there is no provision, my lord, for condonation of delay. There are judgments galore that the Limitation Act, my lord, does not apply. First of all, my lord, it's a complete code, my lord. I'll be referring to 2011, Volume 1, Supreme Court Cases, page 370.
370.
370, my lord. Amar copy to the? It's 2011, 1 Supreme Court Cases, page 370. Paragraphs number 44 and 45. Or we will find it at page 385.
Yes.
Yes, 44, my lord, states contains the object of, my lord, the Act. States that the object with which the 1951 Act was enacted is reflected in the preamble, which reads as follows. The Act to provide for conduct of elections to the Houses of Parliament and to the House or Houses of Legislature of each state, the qualifications and disqualifications for membership of those houses, the corrupt practices and other offences at or in connection with such elections, and the decision of doubts and disputes arising out of or in connection with such elections. Now, 45 says that the Act is a complete code for the conduct of elections by the Election Commission of India, appointed under Article 324 of the Constitution, which provides for superintendence, direction, control and conduct of elections to the Parliament and to the legislature of every state, and also of elections to the offices of the President, Vice President held under the Constitution. The provisions of Article 193B of the Constitution have therefore to be read along with the provisions of 1951 Act. 84 of the said Act cannot be rendered odious by holding that all vacancies on account of aforesaid provision of the Constitution become immediately available for being filed by way of a by-election. So, my lord, it holds, my lord, it's a self-contained code. And, my lord, I'll also be referring to, my lord, relying upon rather, my lord's order passed in this proceeding, my lord, dated 13th of August 2025. The relevant paragraphs, my lord, that I'll be referring to is, my lord, paragraph numbers 28.
13th August.
13th August, my lord. Correct a copy? That's it.
Yes.
Yes.
Paragraph 25.
But 28 to 31.
Yes.
28 speaks about the, as per section 112, election petition shall abate only on the death of the sole petitioner or survivors. In view of the same, after death of the respondent number 1, question of abatement does not arise in this case. Thereafter, the petitioner has informed death of the respondent by way of an affidavit after serving copy to the other respondents. None of the respondents have filed the written statement, nor any notice given that they do not intend to oppose the petition. Thereafter, my lord, the elections and election disputes are matter of special nature, and that though the right to franchisee and right to office are involved in an election dispute, it is not a lis at common law, nor an action in equity. The right to vote or stand as candidate for election is not a civil right, but is a creature of statute or special law, and must be subject to the limitation imposed by it. The general rule is well settled that the statutory requirement of election law must be strictly observed, and that an election contest is not an action at law or a suit in equity, but is a purely statutory proceeding unknown to common law power. It is also well settled that it is a sound principle of natural justice that success of a candidate who has won an election should not be lightly interfered with. Any petition seeking for such interference must strictly conform to the requirements of law. And thereafter, my lord, I will be referring to 31, my lord. Entire election process, commencing from the issuance of notification calling for a constituency to elect a member or members right up to the final resolution of the dispute, if any, concerning the election, is regulated by the Representation of People's Act 1951. Different stages of the process being dealt with by different provisions of the Act. The legal position is therefore well settled that election disputes are strictly statutory proceeding. The next contention that Limitation Act does not apply. Judgment. Yes. But I'll be referring to, my lord, 1993, volume 1, Supreme Court cases, page 636.
This is relying on a 1974.
Yes, yes. Yes. Relevant paragraphs gulo bolo. Yes. The relevant paragraphs are, my lord, paragraphs 6, 8 to 11 and 13.
Yes.
There are arguments advanced regarding, my lord, the applicability of the Limitation Act, referring to, my lord, section 29 of the Limitation Act also. The Honorable Supreme Court said, my lord, they followed the 1970s landmark judgment, my lord, Hukum Narayan's case,
yes,
and held that Limitation Act does not apply. But there are, insofar as, my lord, the Representation of People Act is concerned, there are time-bound exercises to be completed, which are their content within the Act itself. For instance, if, my lord, refers to, my lord, section 86, subsection 4 or subsection 5, it speaks about the time period within which a person who ought to have been joined as a respondent has not been joined. So he has to apply within 14 days. Again, my lord, in respect of recrimination proceedings also, my lord, section 100 and section 97, that is also a stipulated period, 14 days. So, my lord, this particular petition on the face of it, my lord, is barred. And my lord, I will be praying, my lord, for, my lord, an outright dismissal, my lord. And coming to, my lord, the facts of the case, my lord. Now, Mr. Rai's client is a meddlesome interloper. He says that he is one of the electors of that area. He suddenly, my lord, wakes up from his deep slumber and, my lord, approaches the court admittedly after the time has expired. He is seeking for an order which otherwise is available to be canvassed by only a candidate, because he, in fact, is seeking for recrimination, but he cannot do that. In terms of, my lord, the language involved in section 97 of the Representation of People's Act.
No, sir.
Now, kindly takes, my lord, section 97 once.
Arriving Act.
I'll hand up my book, my lord.
Okay, pass over.
তোমার বইটা একটু নিচ্ছি আমি। ঠিক আছে, we'll work out.
তোমার টাইম দিতে হবে, তোমার খাওয়াটা বন্ধ করতে আর বুঝতে পারছি না।
It states about recrimination.
Yes.
Recrimination, what does the provision say? When in an election petition, a declaration that any candidate other than the returned candidate has been duly elected is claimed, the returned candidate or any other party may give evidence to prove that the election of such candidate would have been void if he if he had been the return candidate and a petition had been presented calling in question his election, provided that the return candidate or such other party as aforesaid shall not be entitled to give such evidence unless he has, within 14 days from the date of commencement of trial, given notice to the High Court of his intention to do so, and has also given the security and further security referred to in sections 117 and 18 respectively. On the face of it, my lord, what he is seeking for is barred at law.
Yes.
93 one take a side code here. We cited 93-1.
Yes.
1993 volume 1 in fact deals with recrimination. So my lord, on the face of it, it is barred. He is a stranger. And so far as my lord, the respondent is concerned, the respondent number 6. But that is also barred by limitation, first of all. Second is, my lord, the Representation of People Act or the Calcutta High Court rule, he has sought for recalling of the order. Does not contemplate recalling. Third is, my lord, he is also, my lord, in essence, claiming for recrimination, which again, my lord, is statutorily regulated. It cannot be done. And there is no explanation contained in the petition in order to explain the delay, because he has admitted the service. Suddenly, he felt that, no, now I think I should come into the picture.
Yes.
So, he says that he is entitled under 116, but 116 will not be applicable to him because he is already a party.
Correct.
So, but kindly, my lord, for the sake of prolixity, my lord, kindly takes paragraph 10 and the prayer in his petition. That is, my lord, that is IA 3. Paragraph 10, my lord, will find it at page 8.
Yes.
He says it has now become necessary that since the application, that the said application be opposed, since the petitioner himself at all times has been guilty of causing serious misconduct and corrupt practice during the said election, the said petition and an election would have been void if she had been declared the return candidate, and in the event a petition would have been presented questioning her election. So they have basically set out section 97. And the prayer is page 10, recalling the order dated 19 December 2024. I've already indicated that there is no provision, my lord, for recalling, my lord. So, my lord, I say, my lord, first of all, both being barred at law on the face of it, my lord.
Yes.
Both ought to be rejected, my lord, dismissed in limine.
Yes.
These are my humble submissions, my lord.
Thank you.
Well, he's GA3, my lord. I think.
Yes.
My reply which I was directed to.
Both are out of time, though.
Out of time.
Yeah,
I have served them, my lord, yesterday.
7th they were
Today, kindly condones the delay and accepts it.
Yes.
My lord, I am the respondent number 6, my lord, in the proceeding. Respondent number 1, my lord, died on 25th. These are admitted, my lord, facts. Respondent number 1 died on 25th of September 2024.
Correct.
There is an order of this court, my lord, dated 19th of December 24, by which, my lord, the suit was declared as undefended against all the, my lord, defendants or respondents in the EP, except respondent 15 and 16. Thereafter, my lord, by further order, 15 and 16 were expunged. This is, my lord, the position. Now, my lord, how do I come to, my lord, this, my lord, picture now again? After, my lord, I was being declared undefended. Kindly takes, my lord, section 116, my lord, of the, my lord, Act, 1951 Act.
Yes.
Abatement or substitution on death of respondent. If before the conclusion of trial of an election petition, the sole respondent dies or gives notice that he does not intend to oppose the petition, these two parts are not applicable to my case. Third limb, or any of the respondents dies or gives such notice and there is no other respondent who is opposing the petition, the High Court shall cause notice of such event to be published in the official gazette, and thereupon any person who might have been a petitioner may, within 14 days of such publication, apply to be substituted in place of such respondent to oppose the petition and shall be entitled to continue the proceedings upon such terms as the High Court may think fit. My lord, two rights are being recognized. One is a right to apply after, my lord, the death happens, and the other is, my lord, that right has to be exercised within a particular timeline. Now, the third limb which I was referring to, there is no other respondent who is opposing the petition by reason of the order by which the respondents were, my lord, the proceeding was declared undefended. I say this limb of section 116 is satisfied, because on the date of death of respondent number 1, there is no other respondent who is opposing the petition. The statute does not say what are the circumstances under which this situation can arise. Mr. Bhattacharya's endeavor was that because you lost your right, you chose not to file your written statement, therefore you cannot take refuge under this part of section 116. This is his, my lord, analogy, or, my lord, his understanding of the provision in the form of a submission. I say, my lord, that this section 116 does not make any distinction as to how, my lord, this situation that there is no other respondent opposing the petition, this is not recognized. There can be, my lord, A, B, C, 3 situations under which, my lord, this situation can arise. In the facts of this case, this is one of the situations where, my lord, yes, defendants were or respondents were declared undefended, but the moment there is a death of the contesting, my lord, respondent number 1, again, my lord, a fresh cause of action arises for, my lord, the parties who are already impleaded, though they were not opposing, to again apply within that particular timeline to request before the court for an opportunity to contest the proceeding. So this limb, according to me, of 116 is satisfied in this case, because the death of respondent number 1 is admitted, and there is no other respondent who is opposed.
But kindly read the section 116, first 2 lines. If before the conclusion of the trial of an election petition, yes, correct, the sole respondent dies or gives notice that he does not intend to oppose, it is not with you. It is not with you.
No.
Correct. Oppose the petition, or any of the respondents.
I fall here. I fall here.
Correct. Any of the respondent dies or gives such notice, and there is no other respondents who opposing the petition.
Yes.
Or any of the respondent dies or gives such notice, and there is no other respondents who is opposing the petition. Here, you are the respondent. You are alive. You have not choose to come. You have not choose to come when the notice was issued. How this been affected to you?
No, my lord, that is what I was trying to, my lord, convince your lordship on.
Correct.
I will read it, my lord, again, skipping these 3 words, give such notice. It is like this: if before the conclusion of the trial of an election petition, any of the respondent dies,
Correct.
and there is no other respondent who is opposing the petition.
Correct.
So 2 conditions have to be satisfied. Any of the respondent dies, here respondent number 1 is dead.
Correct.
And there is no other respondent who is opposing the petition.
Correct.
This, according to me, by reason of the order, previous order by which, my lord, it was declared undefended, there is no other respondent who is opposing the petition.
Correct.
My lord, what is the intention behind this provision? The legislative intent is that an election petition must be decided on contest. If the only contesting respondent dies, law envisages another, my lord, situation, another opportunity for the respondent.
Coming, kindly read further. Opposing the petition, the High Court. So that is.
Yes, I'll place it, my lord. I'll read the entirety of it. Any of the respondent dies and there is no other respondent who is opposing the petition, the High Court shall cause notice of such event to be published in the official gazette.
Yes.
This is to, my lord, notify others that you may come and contest.
Published, yes.
And thereupon, any person who might have been a petitioner may, within 14 days of such publication, apply to be substituted in place of such respondent to oppose the petition.
Correct.
And shall be entitled to continue the proceedings upon such terms
Correct.
as the High Court may think fit.
Correct.
My understanding of this provision is this, my lord.
So if you come, thereupon any person who might have been a petitioner. Not
Yes, so
might have been
no,
any
he could
person,
have been,
might
he
have
could have been an election petitioner.
If that's why might have been a petition. Any person continued. It is not that stop. Any person who might have been a petitioner. So if
petitioner, writ petitioner is there, then it can be. Where is the respondent or the appearing respondent or who did not choose to appear?
No, my lord, appearing respondent, I am respondent number 6. My lord, I could have otherwise filed an independent EP. I could have.
Correct.
So, my lord, I satisfy this condition that I could have otherwise, my lord, become a petitioner in respect of, my lord, this parliament constituency election
Correct.
at Boshirat. Now, my lord, I choose not to do so independently, but will that, in my respectful submission, take away the right which the statute recognizes and provides for in section 116 on the happening of a particular event?
Okay.
That event, according to me, my lord, is the death of one of the respondent who is only contesting the EP. So that event has occurred, and the other condition is that there is no other respondent who is opposing. According to me, that condition is also satisfied because by reason of the previous order, there is no other person opposing. Now, my lord, there is another aspect to this. Kindly sees the second part of this section. High Court is required to cause notice of such event to be published in the official gazette. My lord, the rules.
The first part, there is no problem. Because why the notice is to be published, that is the first 3 lines is given why the notice is to be published.
Yes.
If the respondent dies or petitioner dies, if they are not coming, whatever it may be, the High Court shall cause notice of such event to be published. That has been done by this court in the official gazette. And thereupon, then your cause came. And thereupon, any person who might have been a petitioner, within 14 days, any person who might have, any person is not an independent.
No, any person here could be, my lord, this expression, any person could be either a person who is already implemented as a respondent in one of the EPs, or a person who chose not to challenge the process and, my lord, stay out of this, my lord, proceeding, but he could have otherwise filed an EP by satisfying the conditions in the 1951 Act. If I otherwise satisfy section 81 criteria or the conditions of section 81, and if I could have otherwise filed an EP, then I satisfy even this condition of section 116. That is my submission.
Okay. Next.
Now, my lord, the next is that this has to be done, a notice has to be published in the official gazette. There is a rule in this regard. My lord, kindly takes the my lord, EP rules of 1967 copy. My lord, I think we had given a copy, but we are carrying. Lordship has a copy.
Yes.
And my lord, kindly also takes, my lord, the gazette, my lord, notification, the publication side by side.
Yes.
My lord, rule 41.
Yes.
If before the conclusion of the trial of an election petition, the sole respondent dies or gives notice that he does not intend to oppose the petition, or if any of the respondent dies or gives such notice as aforesaid, and there is no other respondent who is opposing the petition, the order of the judge recording such facts in the proceedings of the election petition shall be published in the Calcutta Gazette. This is first, one condition, and the fact of such publication shall be recorded in the court's proceedings. Now, my lord, this according to me has not been done.
Which one?
My lord, compliance of rule 41, these two conditions. That, my lord, there is no other respondent opposing the petition is not, kindly sees the, my lord, gazette.
Yes, that is there.
Yes. My lord, kindly comes to the body of that, my lord, notification in terms of provisions of section 116 of the Representations of People Act 1951 read with rule so and so.
Where from you are reading?
My lord, from the Gazette, my lord, 25th September 25.
Correct. Which portion?
I'm sorry, 8 September 2025, the internal page, second page of that, my lord, notification.
Yes, in terms of section.
In terms of provisions of section 116 of 1951 Act read with rule so and so, and pursuant to an order dated 13th August 25 of the High Court at Calcutta, passed by Honorable Justice so and so in GA number so and so, it is notified for general information that the petitioner has filed an election petition being EP number so and so on 16 July 24 in respect of 18 Boshirhat parliamentary constituency in connection with parliamentary general election 2024. And during the pendency of the said election petition, an affidavit dated 13 December 2024 was filed by the petitioner in terms of Rule 39 of the Election Petition Rules 1967, stating the fact that the respondent number 1, namely Sheikh Nurul Islam, expired on 24th September 24, and any person who might have been a petitioner may, within 14 days of the publication of this notification, apply to be substituted in place of respondent number 1 to oppose the petition, and shall be entitled to continue the proceedings upon such terms as the Honorable High Court may think fit. Now kindly takes, my lord, Rule 41 once again. After, my lord, noting the, my lord, language of the notification. Correct. Rule ta dekha. If before the conclusion of the trial of an election petition, the sole respondent dies or gives notice that he does not intend to oppose the petition, or if any of the respondent dies or gives such notice as aforesaid, and there is no other respondent who is opposing the petition, my lord, after this is very important according to me, the order of the judge recording such facts. So the facts which are there in the first 4 lines of this provision, in the proceeding of the election petition shall be published in the Calcutta Gazette, and the fact of such publication, as in the fact of, my lord, the order being passed that there is no other person opposing the petition in view of the death of respondent number 1, should also be there.
What is recorded? Affidavit filed, died, nobody is then.
No, that is not recorded.
You want that the total 25 pages is to be recorded?
No, not 25. This is, my lord, election petition. My lord, the regards.
You are the senior person. Please argue the matter which can the court can conceive. Not to argue the matter.
My lord
to
may
show
not
the
accept.
public.
My lord may not accept this contention.
Kindly
But
see the, what is required. The person died. In the election petition is pending. Call for the person.
No, but that there is no other person to oppose that, my lord, election petition. That fact has to, my lord, Rule 41 has to be complied with. That fact should have been there in the, my lord.
Next, I am not satisfied. Next, you come.
Very well, my lord.
The court is not satisfied. Come to the next point.
I rely on one judgment, my lord. I had already placed that, my lord, when I was. This is, my lord, in the matter of Kalyan Chaube versus Shadon Pandey, where a similar situation had arisen.
Yes.
এটার একটা কপি দিয়ে দিচ্ছি তোমাকে দাদা।
Yes.
My lord, kindly comes to internal page 2. This last paragraph. Mr. Ray, Learned Counsel, appearing on behalf of the respondent number 8, submits Section 116 of the Act was very much applicable in the case. As per provision, after a notice is issued in terms of 116, it shall be open to anyone, even an existing respondent, to decide to contest the petition. Reference may also be made to Section 87 of the Act. It is always open to the petitioner who had contested the allegation to enter appearance and seek leave to file written statement. Although time for filing written statement may be termed as mandatory in commercial suits, but in regular suits, same is essentially directory in nature. Then, my lord, this was considered. Kindly comes to now, my lord, the finding at page number, my lord, 6, after considering Section 116.
Yes.
Because the petitioner's contention was similar to that of Mr. Bhattacharya.
Yes, next.
I do not find any, my lord, at the top, my lord, the first para. I do not find any merit in the petition. My lord, page 6.
Yes.
I do not find any merit in the petitioner's contention that it is only a person other than the existing non-appearing respondent who can respond to a notice under Section 116. This is the point I was trying to make, my lord. that Rule 41 and Section 116 read together, my lord, it does not mean that a person who is a existing, my lord, respondent in an EP, he cannot, my lord, be substituted after, my lord, this event occurs. My lord, there is a precedent of our High Court. I was relying on this to, my lord, draw inspiration and make this argument, my lord. I did not want to, please don't take me, my lord, amiss, my lord, with my submissions. The respondent was allowed to file the written statement after the death. So this is, my lord, there, my lord, as a precedent. My lord, for GA3, these are my submissions.
Yes, Mr. Roy.
हमारे ऊपर ही तो नहीं है।
I'm feeling a bit unnerved, my lord.
No, no.
Because I will take the point again. So, my lord, kindly does not take me amiss. My position is a bit different. I was no one to this litigation. So, my lord, why do I come up? Because, my lord, the reason for coming up.
Sorry for the interjection. I missed only addressing one point, the point of limitation. For me, my lord, there is no limitation because 8th of September was the date of death. 22nd of September is, my lord, date of filing of the petition. It is within 14 days.
Filing
So,
when you filed?
In the affidavit in opposition, this point of limitation has also not been noticed. It's not
No, when you filed?
I filed 22nd of September. Date of death is 8th of September.
24 September. 24 September.
And
That's why. You have been
G3.
Yeah, G3, 24 September. Not 22nd.
Then also, my lord, 14 days.
22nd is the last day.
Yeah.
22nd is the last.
22.
23.
Never ask a lawyer about mathematics. আমার অন্যদিকে ফিরে হবে।
Filed is 24 September.
When I was, my lord, wrongly instructed, I was.
That's what I'm telling. Yes.
So, my lord,
that point has not been taken.
Yes, yes.
Now, my lord, I draw inspiration from your lordship's order that, my lord, why I am required to be given a notice. The requirement is no one should steal a march. So that is the basic reasoning. Now, my learned friend has taken the point of maintainability. But with humility, I say whatever he has urged is not a question of maintainability. Maybe it is that orders can be passed, but it's not a question of maintainability. So the only point which he is taking, it's beyond time. Therefore, this application should not be allowed. In my case, that is the position. In his case, it's maybe something different. Maybe a bit of.
In addition to your.
His would be waiver and things like that. I will not acquiesce.
In addition to your grounds, there is some.
He has more grounds than me. Rather, he has more follies than me. I have a better case. Now, my lord kindly appreciates my position. I will get a notice from this court. Now, my lord, it is not the court who is issuing the notice. Your lordship has passed a direction on my learned friends saying that issue notice as required under
publication.
Section. Yes, publication under. The exact words are the petitioner is directed to take appropriate steps by publishing in the Calcutta Gazette in compliance with the provisions of Section 106, specific, of the Act of 1951, read with Rule 41 within a period of 3 weeks. But I know Mr. Bhattacharya on the last occasion claimed that we do not do such matters, they do such matters. If I missed the bus because it was in the new secretariat building. Now, if they do so much matters, my lord, then they should also realize, and also, my lord, it is your lordship's finding, just a second, please. It is also your lordship's finding. My lord, if I may read your lordship's order, my lord, to that extent, my lord. The general rule, my lord, para 30, is well settled that the statutory requirement of election law must be strictly observed. And that an election contest is not an action at law or a suit in equity, but is a purely statutory proceeding unknown to the common law power. May I wait and pause here for a moment? My lord, if your lordship goes, my lord, again, my lord, I know Mr. Datta has made this point. I'll try and make it a bit more, my lord, where I am coming from, my lord. Section 116 and 41 both requires there should be two things mentioned in the Gazette notification. I'm not saying your Lordship's 25 pages, no. It will say that your Lordship has come to a conclusion that one of the respondents passed away, one, and second is there is no one else. And why is that important, I'll point out, Malad? The importance is from 116 itself. Because if there is no one else, then I become interested. If there is someone else, I cannot be interested. Or I will not be allowed to join the proceedings. Because there will be other respondents, unless I make an application for addition of party. That's a different thing altogether. But here, my your Lordship kindly appreciates, my rights to notice also arise from the second limb, that there are no respondents. But I maybe, my Lord, Mr.
See, that's why, if suppose,
Sorry, my Lord.
okay,
Yes,
it is not mentioned, but you have come, you have not came as a public interest. I could not get an opportunity because in the notice it is not mentioned. If suppose no person opposing, publication is issued and that word is not in the Gazette notification, but you are appearing. So how you can take that plea now?
I am taking that plea. I'll point out why, my Lord. That is where I'm coming from, my Lord.
How you can take?
My Lord, may I just say this, my Lord? Today I am being put at a gun's barrel, saying that you have come, that did not come within 14 days.
No, leave us at 14.
No, I'm on that.
No, with regard to the condition of the Gazette.
My Lord, I am challenging it on that basis, my Lord. I am saying what is sauce for the goose is sauce for the gander. If my learned friend says that it has to be, my Lord, kindly does not take me amiss, my Lord, because he is saying that, so he has to abide by the rules also. Or else, my Lord, the test has to be same for both the parties. If he is getting some lacune, some.
That's why I'm telling. I think you are not understand. You, although Mr. Datto has taken that this word has not been given, the no other respondent is opposing in the petition. This is not mentioned in the Gazette.
It is not.
That is the only submission which Mr. Datto has also. You are also doing something.
No, I am submitting. If that is not there, the 14 days period is not starting. I'm on that, my Lord. I am not here to challenge your Lordship's notice, my Lord. I am saying the 14 days period has to be on a compliance of Rule 41, which says that that part also needs to be there. Since my learned friend is taking this point of order, and again, my Lord, but kindly appreciate what I'm saying. The 14 days notice has to be, the precondition of the notice is that both these limbs should be there. Unless both these limbs are there, the 14 days thing is not binding me. This is one of my submissions. And other submission I'll make, with regard to 14 also. I'll come to that later. That is on pure question of law, But what I'm saying is, my learned friend will say that there, the requirement of mentioning of the respondents having all died is not mandatory. And in my case, it will be mandatory. That is something which I am beseeching your Lordship to kindly consider. But I'm not taking the point that the notice is bad, it cannot. I'm not on that. I want to enter the foray. My learned friend is preventing me.
No, that's correct.
So if he's taking a point, then he should be bound by that point.
Okay.
I'm on that.
Okay.
I am not here to miss. I'm sure he's not going to give me an inch.
Okay.
So why will I give him an inch, I'm asking myself this question. And it is a point, which I humbly submit, It is a mandate even according to your Lordship's order, para 30.
Meters, not by
এই ছাত্র আমার 6 মিটার লাগে তোর অত লাগে না
not by inches.
And he's challenging me. He's saying he needs cloth in meters. I said I need 6 meters. You don't need 6
I
meters.
said that comparing our sizes, we do not measure each other by inches but by meters.
So, my lord, as I was coming, my lord, again, I will repeat, my lord. I am saying the test should be the same. If you are now giving a bit of a leeway, because I contend that this is mandatory, the wordings are mandatory.
So you are arguing on the equality.
Yes, my lord. And your Lordship has held.
Correct. You are arguing on equality.
And your Lordship has held. It's a statutory prescription.
Okay.
And your Lordship's direction, my lord, again, my lord, it is not the department who has done it. This is now become an adversarial proceeding. Your Lordship's direction is my learned friend. There is non-compliance. That is my second point.
Okay.
If there is a non-compliance, my learned friend cannot prevent me.
Okay.
Now the last point, my lord. But I humbly say, my lord, if your Lordship kindly reads the 116 41, my lord will kindly see, my lord, your Lordship is well aware, this is regular law, my lord. if there is a time period which does not give any consequence, then that time period is not mandatory. It is directory.
No, but if it is special act and
Even then,
provides it is not
even then,
it's not applicable, then what will
even then, that is, I'll try and refer to two judgments. One of the Consumer Forum, and other is, your Lordship is well aware, I took a point before your Lordship also. Your Lordship knows this section 34 of the Arbitration Act. I am delayed by 1 day, then everything is stopped. But if your Lordship has gone through section 34(6), my Lord will see that there is a shall and disposal in 1 year. But that was made directory. That's a special act. And there, the Supreme Court held that even in special acts, my Lord, if there is no consequence vis-a-vis non-fulfillment of the time period, that will be not mandatory but directory.
No, that is with regard to the non-receipt, and that is a procedural aspect.
No, my Lord, that is disposal.
That's why.
Well, this is also procedural. I am again application before your Lordship. My Lord, here there are several other things. My Lord, I would beseech your Lordship, my Lord, I had personally come and mentioned. My Lord, because I could not get the gazette notification, my Lord. That is why I am being now.
You don't say you have not.
I approached your Lordship, my Lord, kindly, my Lord.
You approach.
I approached.
But you should not say.
So, my Lord, if I could not get it.
If I will say, if I would have been that side and I say that I am not aware where the gazette notification, it can be appreciated. But
I said so. I came before, obviously with genuine intentions, I came before your Lordship. That let it be served. But whatever, I could not get it. Whenever I got it, I made the application. The point is, my bona fides are not in question. Bona fides are not in question, my Lord. If I could have got it within that period, then why will I not file it? And I'd come before your Lordship and mentioned before that. So, my Lord, I am trying to get the leeways through. So, the second question which I am trying to raise is, my Lord, that it is not mandatory, it is directory. And if it is directory, even the language, if your Lordship kindly see section 41.
How many years have passed? 2 years. 2 years over.
It was held in 2000.
My Lord, I will not. Sorry.
2024 June, the election results were.
Okay.
For me, my Lord, since it, I can appreciate where it's coming from, my Lord, I have no notice of 2 years, my Lord. My notice is.
I am not on that.
No, I'm just pointing out because maybe Mr. Dotto's case might be something different, but in my case, my Lord, I do not have that notice. I came at the very end. Now, my Lord, kindly sees.
160.
Yes, next.
My Lord, kindly sees 116. The last part of that, my Lord, I say, my Lord, it gives your Lordship the powers. Kindly sees. Apply to the subsequent place of such respondent to oppose the petition and shall be entitled to continue the proceedings upon such terms as may be considered by the Honorable High Court. But this I humbly submit, my Lord, this gives the High Court full powers. If I have been late, my Lord can put me on terms.
That is the only question, whether this 14 days is mandatory or not.
That I'm showing judgment. But also, my Lord, kindly, I have taken that first point also, my Lord, kindly.
I will take care of it. So
Considers that, my Lord. The Supreme Court to এটা কোনটা দিচ্ছ হ্যাঁ প্যারাগ্রাফটা দেখো এই ওকে দে মানে this is 2018 9 Supreme Court cases 472 Yes, 2018. I'm sorry, I just had give them the citation. 2018 9 Supreme Court cases 472. I'll straight away take your Lordship. I mean, replacing the entire thing will be difficult. I'll just take your Lordship. Kindly comes to paragraph 19, Malad. If your Lordship wants, I can read section 34(5), but it uses the word shall. It will thus be seen that section 34(5) does not deal with the power of the court to condone the non-compliance thereof. If it is imperative to note that the provisions is procedural, the object behind which is to dispose of application section 34 expeditiously. One must remember the wise observation contained in Kailash, where the object of service is only to expedite the hearing, not to scuttle the same. All rules of procedure are handmaids of justice, and if any in advancing the cause of justice, it is made clear that such provision should be construed as directory, then so be it. Take the case of section 80. Malad, they have taken the case of section 80, Malad, para 21. Important, Malad. Section 80, though a procedural provision, has been held to be mandatory and is conceived in public interest. The public purpose underlying it being the advancement justice, giving the government the opportunity to scrutinize and take immediate action to settle a just claim, without driving the person who has issued a notice having to institute a suit involved in considerable expenditure and delay. That is to be contrasted with section 34(5), also a procedural provision, the infraction of which leads to no consequence. But I want this. To consummate, if the act provided or the rules provided that no, you cannot make it thereafter, then I could have understood, Malik.
No application is maintained as
yes, then no consequence.
Correct.
In that even, Malik, I say, Malik, this is a case of directory and not mandatory. Malik, this is further proceeded with, Malik. Yes. Para 23.
Yes.
It makes a contrast between section 34(5) and 34(6), and again holds that where there is no specific consequence,
no consequence is provided. There is
yes.
no more indicator that the same. Yes.
And para 25 is last where was for a change the Calcutta High Court and the Bombay High Court were right. The Supreme Court holds on that ground. Now, this was also followed in another arbitration, civil revision. It was a page 19. Page 19, para 44.
Para
44.
Yes.
It echoes the same thing, Malad. Oh, but one last point, if I can make, Malad, then next day, Malad, Mr. Portugal. Yes, one last one.
Conclude.
Yes, Malad, the next point is, Malad.
Bhattacharya will not take much.
I don't think so. Malad, I will
conclude it, Malad, today only.
I will just deal with his judgments once and quickly, Malad, I'll do it. Malad, so, Malad, this also says the same thing. Now, Malad, kindly appreciate Representative People's Act. Malad, kindly appreciates what is falling from your lordship, Malad. I've also trying to gauge it, Malad, that this is not an equity, it's a statute. Now, Malad kindly sees, be that as it may, it's a statute. Malad, it incorporates the procedure of the Code of Civil Procedure. So it's not in the air per se. And not, Malad, because Mr. Bhattacharya has shown a judgment, complete code, Malad, it says about the election process. Because for the purpose of these election petitions, Malad, it may not be a complete code because the CPC has been imbibed. Applicable. So that is not the case of complete code. Now, Malad, your lordship will also appreciate the complete the petition, the representative people that allows rules to be framed by your lordship's court. And I am in terms of the rules, I am saying this. So the rules also did not make it mandatory that there will be a consequence. You will not be heard. But that could be the only consequence. But it says that no, it can be heard and you can put, your lordships can put terms. So, Malad, now your lordship will kindly weigh the entire consequences. Here is what your lordship has held, that one must not get the chance of easily going through. But what we say is, Malad, without any person straight goal. That your lordship has held.
No, that's right. Because
so the best thing is to achieve justice, Malad. And having a look at my case, I have come 2 days late.
Because the circumstances of passing this order already reflect in the earlier point.
That is what I am trying to achieve here. Now, whether I should be penalized because of 2 days, and if that is the penalization of 2 days, Malad, then they should also be penalized of not having the proper.
Now further.
My lord, my lord,
Don't worry, Mr. Ghosh is there.
well,
He
this
will
is
continue.
Nazir Ahmed, my lord. Act to be done in a one way, act to be done in that way.
Yes, because that part has not been published.
And so it's Nazir Ahmed. And Lordship is well aware of this, my lord. My lord, this we'll send a printout. My lord.
Citation.
My lord, this is
1941 Privy Council.
1941. Oh, এটা তো হবে না, এটা তো and I'll give the Privy Council. This is volume 18 Lahore series ILR
Give to
629.
Give to my court.
I'll give it to you. Well, can your lordship take it up tomorrow for 5 minutes
Wow.
so that I can finish with their judgments?
How much time will it take, Mr.
He will take 5 minutes.
Maximum 5 to 7 minutes, my lord. But we can do it today itself, my lord. If it is not, my lord,
I have no problem.
my lord, we can, my lord, finish it off, my lord. শেষ করে দাও, তুমি তো সবই বলে দিয়েছো, নাজির আহমেদ তো দেখিয়ে দিয়েছো, তো মহিনুদ্দিন ব্যাপারটাও সাইড করো, ওটাও ভালো।
যেটা করতে দেবে সময় দাও।
করে দাও না, এটা করো না, করে শেষ করে দাও, আজকেই শেষ করো, আরে করো না প্লিজ, আমি পারছি না।
ओके ओके कल क्या है? कल तो फ्राइडे, कल तो नॉन कमर्शियल। 18 मंडे, ट्यूसडे 17, ठीक है 18 रख देगा। कम ऑन 18th, it will top
10 minutes or maximum.
Counsel for the petitioner in can number 3 of 2025 has concluded his argument. Counsel for the petitioner in can number 4 has argued the matter at length, but due to the paucity of time, hearing could not be completed. It is the matter on 18th November at the top.
Very grateful, your lordship. My lord, I think Mr.
Yes, my lord, Mr. My lord, item number 5 and 6, my lord, the 2 section 9 application where, my lord, we had argued on the last occasion.
Order has expired, my lord.
Yes,
No,
my lord, it is expired on 6
September.
November. I'll tell you, lordship, 6 November. I'll tell you, lordship, my lord, on the last
You got an
occasion,
application.
I'll tell you, lordship, on the last occasion, I forgot to mention, my lord, the extension of the interim. If lordship kindly extends, my lord, the interim order. My lord, kindly do not.
It's not an extension, reinstatement of
No,
interim order.
no.
I'll leave it to your lordship.
No, my lord, kindly do not. my lord.
Some cost.
And something to be paid at least.
Hey,
Personal to us.
Personally.
kindly do not. My lord, very important.
I will record. You will have a copy with
Yes.
Of course, all of this. Yes, of course.
and with the snacks.
Yes, of course.
Then at counsel for the petitioner 4 and 5, submit that though the interim order was till 6th of November 2020, but due to inadvertence, the matter could not be mentioned before this court. Accordingly, prays for extension, reimposition of the interim. Consider the submission made by the counsel for the party. This court finds that the petition is already enjoying the interim order. Thus, the interim order is extended till 20th November 2020.
And your lordship is keeping this matter, my lord, on the 20. It will
It will be remain in the list.
very well.
Very
Very
good.
Let the matter remain in the list.
Very grateful to your lordship.
grateful.
It is
This item 5 and 6, I think. Both 5 and 6. Item 5.
5 and 6.
Great.
Very grateful. Grateful.
2-1.
चलो चलो चलो